also a former board member at Kampala Serena Hotel and a former member of the board of directors of National Social Security Fund in Uganda. In the interest of time, allow me to introduce to you Honorable Justice Richard Wabwire in that capacity, and Honorable Justice Wabwire, you are welcome, and I hand to you the audience this morning. You are welcome.
Thank you, Your Worship. My Lord, the President of the African Court of People and Human Rights, my Lord, the Judge President of the African Court of Justice, all of you, Your Lordships and Worships present, all delegates that are participating in here, the panelists and the presenter this morning, you're all very welcome to this session. We do apologize for starting late, but I'm confident that we shall make up for the time we lost. This morning's session is on the role of national and regional courts in bridging the access to justice for cross-border trade disputes. Thank you. At the core of the discussion of this topic is the role of the East African Court of Justice in advancing the aspirations and objectives of the people of East Africa as expressed in the Treaty for the Establishment of the East African Community, cardinal of which includes widening and deepening cooperation in economic and social fields for their mutual benefit. This aspiration is amplified in different protocols of the community under the treaty, and as many of you in the room might have experienced, any form of legal dispute can be absolutely draining for anyone involved. Cross-border disputes come with an amplified array of challenges, including jurisdiction, navigation across different jurisdictions, instructing and managing lawyers to help resolve the disputes, and many other issues. And for companies and individuals working and living across borders, issues such as tax and trade disputes are constantly alive and can only usually become more frequent with increase in trade and interactions. Today, we shall be looking at what mechanisms and remedies are therefore available for disputants, be them corporate or individuals, involved in cross-border disputes generally, and most specifically, trade disputes. Effective cross-border trade dispute resolution mechanisms boost confidence in foreign trade and local investments. So what kind of trade disputes typically end up in our courts, in our municipal courts and in our East African Court of Justice? Are these courts appropriately mandated and resourced to facilitate effective and efficient resolution of cross-border trade disputes? What really could be the role of our courts in resolution of these disputes? To help us find possible answers to these inquiries this morning are eminent persons who have committed their professional and personal careers and lives in building the architecture of solutions for some of these challenges. Our main presenter this morning is Brenda Ntukunda. Brenda Kankunda. She's not yet here. Here we go, yeah. Welcome, Brenda. Brenda Kankunda is a program coordinator, trade investment and development at Siatini, Uganda. She's a graduate of law with a certificate in tax and revenue administration. She has written several publications, including publications in investment governance in Africa to support climate resilience. She has written on energy. She has written on the TRIPS agreement. She has also been involved in trade and investment analysis and policy analysis, research and advocacy to influence trade and investment. On the panel to discuss Brenda's paper are other eminent persons in this space. To my extreme left, I'll start from my extreme left because the person on my extreme left is very interesting. Sheila Kaumara Mishambi is one of the pioneer legislators at the East African Legislative Assembly. So she's one of the people that birthed the East African Court of Justice. Sheila is a journalist by profession. She has got a master's degree in development studies, a bachelor's degree in education from Makerere University, and a postgraduate diploma in journalism. She has served as a director of the Uganda Women's Network and also a teacher of economics. Sheila is currently a private entrepreneur and an alumnus of the Sherry Blair Foundation. You join me in applauding our discussants and presenters. The other eminent person we have is a learned Attorney General of the Republic of Uganda, Honorable Kiriowa Chwanuka. The Honorable Attorney General of Uganda is previously an ardent practicing advocate who has practiced for so many years in the municipal courts in Uganda, but also at the East African Court of Justice. He holds a Master's of Laws degree in Petroleum Law and Policy from the University of Dundee in Scotland, a Bachelor of Laws from Makerere University, and a postgraduate diploma in legal practice. He has served on various boards of business entities in Uganda. He's also an ardent sports enthusiast. He's been the president of Uganda Golf Union, but also has been a president and chairman of one of the very popular football clubs in Uganda, on the Ugandan Super League. Has been the chairman of Express Football Club. Please join me in applauding and welcoming the learned Attorney General. On my right is Lady Justice Monica Mugenyi Kayijira. Lady Justice Mugenyi will go a long way. We have almost trailed each other's career footprints. She's currently a Justice of the Court of Appeal of Uganda. She has previously served as the principal judge of the East African Court of Justice as the First Instance Division. She's actually the immediate past principal judge of the East African Court of Justice. Justice Mugenyi holds a Master of Laws degree in International Trade. She specifically wrote her dissertation on transnational corporations and human rights in host states. She holds a Bachelor of Laws degree from Makerere University and a postgraduate diploma of the Law Development Center. She has previously served as a state attorney and as a legal officer in government entities. She's also currently the chairperson of East African Development Bank Staff Appeals Tribunal. Please join me in applauding Justice Mugenyi. On my immediate right is Mr. John Bosco Kalisa. Mr. John Bosco Kalisa is not only my neighbor on this podium, but he's also my neighbor in Arusha. Our apartments are next to each other. Mr. John Bosco Kalisa is the Chief Executive Director, the Chief Executive Director, CEO, Chief Executive Officer of the East African Business Council. He has previously served as the Chief Executive Officer of Trademark East Africa. Country Director for South Sudan Trademark East Africa. Ladies and gentlemen, you'll appreciate that with this array of presenters, justice will be done to the subject this morning. It is now my singular and very honorary pleasure to invite Brenda Atkunda to present the key note address on this subject, and then we shall get the panelists. Brenda, we've got 1 hour of discussion, presentation and discussion. So if you take 30 minutes, then we shall use the rest for, if you take 20 minutes, then we shall spread out the rest for the other panelists, and then Q&A. Welcome. Take the floor.
All protocol observed. Good morning. Today's discussion around looking at the role of the national and regional courts, especially from an aspect of dealing with cross-border trade disputes. In my presentation, as it is displayed there, I thought that it would be imperative that we first of all look at what is on the context, or what are some of the key challenges that we see cross-border traders face, especially when it comes to accessing justice, but also moving forward to see, with the changing dynamics, what role do we think that the courts at the national and regional level can play to ensure that these cross-border traders are able to access justice. Like introduced earlier, as Siatini, Uganda, we are a trade, fiscal, and investment policy-related advocacy is what we do to ensure that the policies we have in place promote pro-development, and trade forms a core of the economy. So that is why a discussion around trade is really very key to us. So what we do is we try to influence policy formulation, but to ensure that these policies support and improve the livelihoods of the people. We do not have the mandate, and that is why we join spaces like these, because we believe that we come to a sector that is filled with people who have the mandate, for instance, to offer justice when it comes to issues dealing with justice. In line with the context, like I had earlier said, it's important that we look at what are some of the actual trade disputes that we could probably open up to our panelists to discuss. And it's a blessing that we actually have some of the people that actually hold the power on our panel, so probably would be able to hear from them how best we see governments making an effort to address these disputes. But also, we cannot go away from addressing what are some of the barriers to justice in cross-border trade. And definitely, we come to you with recommendations, hoping that probably some of those could be taken on. Now, moving forward, what forms the context of the ESC, specifically for today's discussion, is from when it was established back then, we've seen that there's been continued expansion to 7 countries now after the admission of DRC. And why this is important is because the more we diversify, the more we've seen the changing context. For instance, I can give you an example of the languages. Probably earlier we knew that English and Kiswahili were some of the languages that mattered, but today, seeing DRC, Burundi, we know that with the expansion, issues to do with language are some that we cannot do away with. But we've also seen commencement of different trade regimes. At the moment, there's a discussion about trading under the African Continental Free Trade Area, which is yet to be the largest trade area that we've ever had in the world. And we know that the ESC, or the regional blocks, act as a building block for the AFCFTA. But also important to note is that these different trade regimes come with different trade codes. So those are some of the issues that we feel usually have caused disputes, because when it comes to interpretation of these trade regimes under these, for instance, the ESC trade regime, we have the common external tariffs, we have the COMESA tripartite, COMESA, SADC, and ESC. So with the enhancement in the trade regimes, we've also seen new policies being put in place and rules. And interpretation remains a key challenge, which we actually pose right here to you. But moving forward, there's also been an issue of the rising bilateral free trade areas. And we know that countries, especially our neighbors in Kenya here, we see oftentimes them getting into extra free trade agreements. We see free trade arrangements with the US, with Kenya, with the US and the EU. So, and even here as Uganda, we see it is a thing that still goes on. So with these different rules that we keep joining, or the free trade arrangements that we get into, we still see new principles being brought up. And maybe still on that issue, we cannot do away with the fact that we've often seen a rise in the trade disputes. And this, the most recent one that I think everyone has talked about is an issue to do with the border closures. We've seen instances where goods, say Ugandan goods, are being rejected on a market for one of our partner states like Kenya and Rwanda. So there are those different dynamics. But amidst all that, we've also seen a lot of calls, especially calls headed towards calling for reforms within our policies, especially at the ESC level, and majorly being a call for reform to the ESC treaty, which is why we think that if this is addressed, it could come in to address some of the challenges that we talk about in this particular presentation. Next slide, please. Next slide. Yeah, so like I earlier said, some of the challenges, and most of which I have hinted on in the interest of time, we also see that with the regional integration, and just to bring this discussion home, is that why we talk about cross-border trade and the disputes is because there is a core objective, which is regional integration. And we know that one of the core objectives for that regional integration is to promote and facilitate intra-ESC trade. But we've seen initiatives at the ESC, like coming up with a common market protocol, but we still see that there's a slow pace of implementation, and we do not know where the challenge is or why there's that slow implementation. But because of it, we've seen that it creates difficulties, especially to do with free movement of goods and services. We also still see a challenge with competition among us as partner states. Now, oftentimes we've talked about looking at the fact that ESC partner states are producing similar goods, and it becomes a challenge. And that is just the context. But we've also seen the reoccurrence of the non-tariff barriers. Now, in my trying to understand, we believe that some of these NTBs reoccur because they're actually not being addressed. And courts being one of the arms that we think could address such tariff barriers, if we don't see them, non-tariff barriers, if we don't see the courts address them, then it still remains as a gap. The other challenge is also with the existing different tax regimes. Now, there's been really a lot of effort towards tax harmonization. However, we still get to see that we have different, for instance, we have different tax incentive regimes, that the incentives that Uganda is awarding to maybe investors, foreign investors, are still different from what Kenya or Rwanda are offering. And because of those differences, we see a rise in competition. And we find that our policies are not aligned in that particular manner. So now the question is, what can the courts do, or what role do we think that courts can do towards addressing these particular challenges? First of all, as established under the ESC Treaty, we know that it is the mandate of these courts to see that they protect the rights and rights. We speak about the economic, social, cultural, environmental rights of these cross-border traders. I I see Honorable Sheila Kawamala. I know she's one of those ladies that have been at the forefront when it comes to trying to intervene in issues to do with the cross-border traders. But they still come to us and tell us that we are not trading. And for us, we actually want to have this conversation beyond the courts that we were today, but bringing it down to see how best can we use our courts to address these challenges. But we also take into account the fact that we know there are challenges or limitations that these courts are facing, and these hinder the implementation. Next slide, please. So how I've tried to cluster the disputes that we have is we have some disputes that are administrative disputes. We have those that are politically induced, but we also have the socially induced disputes. And to start with maybe the administrative disputes, like I had earlier on hinted on it, you realize that we have some, for instance, if it is to say with the reoccurrence of the non-tariff barriers, these are disputes that we feel could be addressed at the administrative angle for the partner states, but we still don't see these disputes being addressed. Talking about the political interests as well brings in issues to do with, for instance, border closures. I think sometimes for us we could try to assess them as disputes that are just coming up because of political interests, sometimes not known to us or even to these cross-border traders. But there are also those that are socially induced, and I can give you an example that of the people that are trading around the cross-border, 60% are trading informally, and that is not by choice. Most of them do not even know the language that we speak today here. So when in such an instance a dispute arises, someone wants to run to the court of first instance, but they actually don't even understand the language. So like a video was playing earlier before this session began, that costs for an interpreter is to be barred by the applicant. And that makes the costs for accessing justice high. So it definitely impacts on this woman who is trying to make ends meet. And at the end of the day, they will just decide to do away with it. So it really becomes intricate for them to be able to access justice. Some of them just decide to pull out of it. But we also know that courts are mandated with a responsibility to protect these rights of the cross-border traders. And this is not being done because courts as well have particular challenges that they face. And I can just highlight one of them maybe. I may not have to go by the slides, but I was checking out in the most recent ESC report, and courts had highlighted, and it was highlighted that, first of all, the limited resources to the ESCJ. And I think that is really something that as partner states, we could probably think about looking into, that there is a case backlog because of the limited financial and human resource. And because of this case backlog, we've seen cases being delayed for so long. Siatini Uganda, together with EAC, filed a case when the Uganda-Rwanda border was closed. There's a judgment that came out, but that judgment actually came when the borders have already been opened. So would that really amount to justice, or it wouldn't? Because like it is often said, that delayed justice is denied justice. So we think that maybe if that issue of the resources could be looked into, it would be one of the key aspects that we could address. I had just prepared something I wanted to show you. Next slide. That when we keep seeing these disputes, the challenge is that it affects our trade. And the next slide, please. Beyond revenue loss, when you look at those statistics, it shows you how much Uganda lost in terms of its export markets when the Uganda-Rwanda border was closed. Now, the implication is not entirely on the country, maybe in terms of revenue loss, because even URA said they lost about 16 billion, I think. But the actual implication is felt by this woman that has been trading, by these cross-border traders. And sometimes when we just look at these figures, we tend to not pay key attention to who is feeling the pinch of these decisions that we are making. And that is why we feel that the courts who have the powers can be able to come in and address these particular disputes. Now, I also wanted, and as I come to a conclusion, I wanted to address one key issue that has, I think, remained a very major challenge when it comes to dealing with courts, especially within the EAC. With the whole context, like I have explained, we realize that interpretation remains a key challenge. Now, one issue that I think we have gone to the ESCJ and it has been mentioned everywhere is issues of interpretation, for instance, of the variable geometry. We've seen oftentimes partner states within the ESC violating, and I think I would want to say deliberately violating the principles of variable geometry. This is a time where we want to run to the ESCJ and say, please offer a solution, because if we have negotiated a common external tariff, but we see countries like Kenya are going ahead to negotiate FTAs with the US or the UK, they are violating these principles. But still, we have not, and the ESCJ, for instance, has come out to pronounce itself on interpreting this particular principle. But even when they've done, we still see that nothing has changed. The same thing is still being done. So we need to have in place a strong dispute settlement mechanism, which is beyond just interpreting the sections of the law, but rather, I don't know if the courts even have the power to enforce, because we need to do like what I've seen the EU has in place, the code of conduct, that in such instances, we could maybe see the ESCJ coming out to, and of course the ESC's secretariat coming out to offer strict restrictions or sanctions to countries that keep violating the principles of the regional integration. The other issue that we really think should be addressed, and if well addressed, we could be able to deal with some of these challenges, is an issue to do with tax harmonization of our policies. Now, our policies, like I earlier mentioned, are not aligned. And what challenge that raises is, one, it is a reason we are seeing this stiff competition amongst us as partner states. We have a tax incentive regime in Uganda that is different from a tax incentive regime for Rwanda and Kenya. And because of those differences, we've seen countries trying to pull, not to pull ropes, but we are competing in a way that whoever offers the better incentives is the one who gets the investments. Yet we all agree that yes, FDIs are a panacea to our development, but still we need to see how best we can use these courts to bring that out. There's one thing that I must mention, since I know that most of us here are lawyers. It is quite absurd that we still struggle with trying to be recognized, especially when it comes to trading services. I know that oftentimes, and I don't know if this has changed, but a practicing certificate for someone in Uganda is not recognized in Kenya. That is how the position has been over time. And it becomes challenging. Yet, for us in Uganda, like I was looking at the liberalization schedule for the AFCFTA, we've liberalized services, including the professional services, such as the legal services. But we are still not being allowed to practice law, for instance, in Kenya, which I think is also a challenge that we could address. Now, lastly, maybe to talk about some of the recommendations and what we think can be done. I think it's a call for reform. We need to see how best we address all these challenges that hinder intra-regional trade, but also specifically when it comes to accessing justice. And one of them being the harmonization of our policies. We believe that the courts have a role when it comes to influencing the harmonization of our trade and tax policies, so that they are all aligned and we are not competing amongst each other. We also need to put in place a dedicated body for addressing NTBs and trade disputes. I've always had challenges when I table this proposal that the ESCJ is overwhelmed, especially with the non-economic aspects, issues to do with human rights, political-related issues. But we find that little attention is addressed or given to trade-related disputes. So we've always been calling for a dedicated body that is to work on trade-related aspects, because we know that the core for regional integration is promoting trade. We call, and this is not just to the ESC, but to the partner states, that prioritizing economic, social, and cultural rights should always be at the forefront for these cross-border traders. And that also brings out the role of the ESCJ to see that it is a pillar when it comes to advocating for these particular rights. And lastly, we know that there are policies, there are acts that we have agreed upon at the ESC level, but we are not seeing the operationalization of those. One of them, one key being the NTBs Act, the elimination of NTBs Act. I think non-tariff barriers remain a challenge, and this can be addressed if we put these policies in place. Now, that is all about the regional trade. But we know that there are also issues that are coming up over and over again, and I don't want to leave this podium before I address an issue to do with the energy transition. We are discussing energy transition, but this is going to have a huge impact on our trade. We've seen the EU has already put in place a carbon border adjustment mechanism, which is a carbon tax that will be charged on all the imports. And as ESC, that definitely means that our products will be affected when it comes to accessing the EU markets. It's about that time that I call upon you all that as Uganda and as ESC and as the ESCJ, we need to look at how best we start on a discussion towards clean energy transition. Thank you very much for listening. God bless you, and God bless Uganda.
Thank you very much, Brenda, for your very able handling of the subject. I will not dilute what Brenda has, Brenda's presentation. She has clearly given us context. She has highlighted the challenges, she has highlighted issues, and she has come up with possible recommendations to address the issues. I'll give time to the panelists to respond, and then the participants will come in. I'll give 10 minutes to John Bosco Kalisa, the CEO of the East African Business Council. He represents mainly the business community, and so it's just appropriate that he responds first. So, my brother Kalisa, please go ahead.
Thank you very much, moderator, and first of all, again, to observe the protocol, and I want to appreciate the president of the court and the entire team in terms of this kind of engagement, very, very paramount engagement, bring the private sector, the voice of the private sector to share our insight in terms of the integration agenda. And I want to again appreciate Brenda. She has ably articulated the context and the disputes we are grappling with in terms of cross-border trade-related dispute. But let me remind the audience that the treaty is very clear, and the law of the court is very clear. The treaty has two important principles. People-centered integration, which brings a human development dimension. Two, market-led integration, meaning that the current integration, ESC integration, is different from colonial integration, where the law of the court was to ensure that the raw materials produced in East Africa, they reach in their destination, in the developed country, in their market, in our colonizers. And the court had to ensure that these raw materials are well prepared, they are produced in terms of large quantities in terms of the quality that is required. So when the new ESC, the new court, had a paramount role to play in terms of understanding those cardinal objectives of human development aspect, people-centered integration, and the market-led integration, meaning that goods, services, and other factors of production could move easily across the borders with minimal restrictions. And I've always, with my sister Shira here, I've always said the integration, ES integration, and the ES institution have not served their purposes. Because, as Brenda Ebre highlighted, we've jeopardized the integration agenda because we've politicized it. It has become a political club as opposed to serve its mandate of that human development element, that private sector development element. And Brenda did not mention, when you look at our intra-regional trade, ESC intra-regional trade, is less than 20%. Our counterparts in EU is 69%. Our counterparts in Asia is 60%, meaning that they are trading amongst themselves. So then it has come, as Brenda mentioned, 3 components. What are the 3 issues? Politically motivated conflicts. We cannot have integration when borders are crossed. Administrative-related issues. I've always mentioned that our borders, our trade facilitation agencies, are trade hindrance agencies. Why do we have 20 agencies at the border when we should be talking about borderless trade and investment within ESC? And we are happy at attracting and encouraging other partners to join ESC when we are the border, what we call trade governance around the borders, they are trade hindrance agencies. Should we be seated here saying that milk from Uganda should not access Kenyan market? Rice from United Republic of Tanzania cannot access Ugandan market. We have created cartels, but the cartels benefiting politicians. I would not try to say that those people who are making it hard for business, for people, are not business themselves. They are politicians who are involved into those issues because there is that incentive scheme that is not equally distributed. And I think the work we've been doing with Honorable Shira is that when you go to the borders, when you talk to the customs union, they say the customs officers, to the migration officers, they say, no, we are ready to do our work. But we don't want to step on someone's shoes. And then it brings me to the question we are discussing. Does the court, East African court, has the power, authority to enforce? That is my question, and I've been grappling with that question. Does it have the power to resolve border-related disputes? It's not about the issue of resources, and I've challenged the team here, the judges. It's not about resources. Donors, we have GIZ, we have trade. They are ready to give you resources. But do you have that capacity and competence and the will to make a change? To make a change. Is your jurisdiction well defined to address trade, investment-related disputes? And I think this is the discussion we need to bring to the limelight. Why do we have these borders? Why do you have 20 agencies at the borders? Even others are coming up. So what does it mean? What is the implication? The growth of informality. My friend Brenda mentioned about the disputes, even now between maybe Burundi and Rwanda, borders are crossed. But what happens, you find those products, whether you want it, they will find them in the market. They will use other means to be in the market because the institutions are not working. I remember when I was here and you could find products from Rwanda are here in the market. Products from Uganda are in the Rwandan market. But they are passing through informal channels. So what we are doing, we are growing level of informality, and we are happy with that. General, I was looking at the report from UNCTAD and UNECA. We realized that intra-informal trade is higher than formal trade because institutions are not working. That is the question. That is the paradox we are in. So my view is that we need to streamline how these institutions work. We need to empower them in terms of resources, in terms of competence, in terms of staff, in terms of logistics, in terms of embracing. Currently, we are trying to push for digitalizing our borders to ensure that we use digital instrument. The same, I'm happy that the president of the court is here. He's trying to encourage that. He's trying to inculcate that within the minds of our judges and others to ensure that we need to reduce those human frictions. I think that let me leave it there, and I will submit, but we need to have a kind of a paradigm shift. We need to have a kind of a mindset shift so that we look at the community in terms of shared destiny as opposed to the way we look at it in terms of consensus building. I want to make two important aspects, and I've been grappling with them. One is that we've been, since the customs union and the common market, we've been talking about trade remedy committee for almost 20 years. It has never been there, it's never been established. Two, we had an NTB Act, 2017. It has been going under a review for 6 years. In 2021, the Sectoral Council of Ministers in charge of trade investment cleared it. It has been going through legal scrubbing for 2 years. Do we have really the sense of urgency in terms of what we are doing? That brings the element of time, cost, and efficiency. Private sector will not wait, will disrupt the traditional system. So we need to work together. Thank you very much.
Thank you very much, Mr. Kalisa, for your very brief but incisive presentation or comments. You have clearly indicated what you believe are the pain points, typified by behavior and inaction by some of the institutions and individuals of the EAC and partner states. You have also suggested ways in which these could be addressed. I'll now invite one of the architects of the framework in which we operate at the EAC to make her remarks. I'll invite Madam Sheila Mishambi to make her presentation, make her brief comments. You have 10 minutes.
Yeah. Thank you very much, my Lord, and all protocol observed, your Lords and your worships. I think I wouldn't agree more with the two previous speakers, Brenda and John Bosco. One of the challenges we continue to have is ignoring the masses. The majority, when we talk about trade in Eastern Africa, within the East African community, much of that trade is actually done by the small, medium, micro traders. These are the ones at the borders. And these are the ones that can't access the justice that we are trying to talk about. Trade disputes just fall onto them. If a border is closed, they don't know why they are closing the border, whether for Corona, COVID-19, or there is a political dispute somewhere. So those traders are the ones that we should be talking about. Can they access the justice? They have a number of barriers. One, they are small, they are micro, they are insignificant, but yet we know they are the ones handling the trade within the region. Those are the traders we work with. As a EAC, we work with women cross-border traders at 20 borders in Eastern Africa, and all their conditions are the same. Whether in Tanzania, where we work in Kobero, Kobero is in Burundi, and we work at Kabanga, we are at Lunga Lunga, Horohoro, whether it is at the DRC border in Mahagi and the Goli, Uganda side, the conditions are the same. These are people who hardly went to school, so they will not know about the laws. When we are talking about they will have to incur the cost of translating the laws to the judges, definitely that is out of the way. Even getting to the court, it is in Arusha. It is so remote. Even going to the local court, it's very difficult for them. So where is justice? So if there are any disputes, I think it is not those disputes for the micro and small. Maybe it's the disputes for the big traders that we should be talking about. One of the challenges, I don't know whether things changed, but I recall when I was in the East African Legislative Assembly, the East African Court of Justice looked like a very limp organization, completely ignored. They always had no resources. They had to come and lobby the IALA to make sure we are not passing the budget unless you increase here and there. And I felt really that was not supposed to be it. I don't know whether we can, if we are to settle disputes, trade disputes, and improve the conditions of doing business in the East African community, then we should be thinking about how is the East African Court of Justice resourced to be able to deliver justice to us, to be able to reach us as East Africans, citizens. Because as long as the East African Court of Justice is not given resources, then I think we are just fighting a losing battle. Because it is our governments. For me, I wouldn't want to resort to donors, external donors. It is our governments that should fund justice for us as citizens. Because the Court of Justice, as far as I'm concerned, if you are to look at trade disputes, you must understand trade. I'm not saying that the judges are not learned, but there are continuous agreements that come with WTO every day there is another trade agreement coming up. So there should be continuous training. There should be continuous training of the human resources that are given to support the East African Court of Justice. The IT, I'm glad that you are going digital, but that will also require resources. Resources from how do I reach a judge, for example? How do we provide you information if we wanted to network with the Court of Justice? Who do we approach? Because as long as the court is inaccessible, then we as citizens can't reach out there. I feel more an East African of late, because maybe I keep crisscrossing the different borders. I go to Kenya, I'm asked, how long are you here? And I say, I'm an East African, I can stay as long as I want. Then somebody tells me, you can't. Okay, fine. And eventually I subdue because I want to pass through customs. I go to Tanzania, I'm asked the same questions. I don't know, when I come to Uganda, of course it is welcome back home. So I don't know whether they ask that of Kenyans and Tanzanians at the Ugandan borders. But I think there is a bit of lack of understanding. Where are we going with the East African community? Where are we going with the East African Court of Justice? As far as the traders are concerned, they would be happier if we didn't have borders. That was our ambition when we went to the East African Legislative Assembly in 2001. We were very ambitious, we didn't want borders. But before we left, I think in 2006, OSBP's bigger borders were being constructed. Much as they call them one-stop border posts, but as far as we are concerned, for the small traders, there are bigger barriers now. Bigger barriers to trade for inland trade, intra-trade between countries. I think we have established bigger barriers. The East African community, the East African Legislative Assembly, and of course, the court, they are becoming more and more remote to their mandate. Of course, the other thing is, I used to find it ridiculous to say that the East African Court of Justice will interpret the law and ensure compliance. I find it ridiculous. There is more to our safety. There is more the East African Court of Justice should be doing. It should be handling the issues of environmental degradation, human rights, issues of governance. If I feel I can't get justice in Uganda, for example, I should be able to go to the East African Court of Justice and get that justice. So there is a bit of, I think, liaison. I don't know whether our courts, the national courts, actually understand the mandate of the East African Court of Justice, or how do they align? That is not my territory, so it is a bit vague. But as private citizens, we feel that there is somewhere there is a gap, and I think in this room there are people who are better placed to explain to us, as citizens, can we actually get justice, either from the national courts or the regional court, in terms of trade within the region, in terms to our aspiration of actually being integrated. I thank you.
Thank you, Sheila. That was very crisp and a very opportune moment to bring in the person that advises on formulation of policy and the direction of where we are going and where we're headed. So I'll now call upon the Learned Attorney General, Mr. Konka, to tell us how we get there, or whether we are veered off the rails.
Thank you very much, my Lord. My Lords, Justices present, everyone in their respective capacities. It's actually, I think, a disservice always to be asked to speak third. I'm going to start lobbying that I speak first so my points seem a bit heavier. Because after all these people have spoken, your points may seem a little bit constricted. But really, the conversation we are having here is actually a very, very important conversation, because we are going back. It's actually a very good thing that, my Lord, the President of the Court, you're having these conversations, because we are actually checking to see how far we have gone and what we need to do. Is it okay for us to continue on this path, or should we rethink where we are going? And for us to rethink, we need to understand the purpose. And I'm going to make my comments mainly because I've seen we've gone away from the municipal courts and gone into regional courts, because I think that's where the conversation is. We need to understand what is the purpose of integration. The purpose of integration, if we forget that, then we will not be able to find the answer. One is prosperity for the people. Secondly, it is strategic security. And thirdly, is fraternity of people. Now, that is the purpose why Uganda, Kenya, and all the other partners are getting into this space. And like the colleagues have said, it is supposed to be people-based. What we are discussing here today is the role of national and regional courts in achieving prosperity for the people. I want to rephrase it to say, how are these regional and municipal courts going to come to create prosperity for the people? And prosperity for the people, here we are discussing trade. Because when they have trade, then you will have money, affluence. That is where we are. So you cannot read the role of the court without having that, the question of our understanding of what prosperity is. And prosperity, my understanding, is wealth creation. How is the court going to help to create wealth? And that's what we are all discussing, non-trade barriers, non-tariff barriers, all these things. So my view is that much of this is mindset. Like one of the discussants said, we have gone away and turned it into a political club. You cannot have integration without the people. It will not happen. So, and you can't force it. The borders are there. They exist. There are different governments in different places in the region. They exist. There are municipal laws. They exist. There are rules of sovereignty, and they exist. So you must go back to ask yourself the question, do we need each other after all? Do I need to trade with Kenya to prosper? Do I need to trade with Rwanda to prosper? And therefore, does the closure of the border or the non-tariff barrier help in making that prosperity? We are not going to sit in any boardroom, in any place and write away these borders. We are not. And for me, while everyone is looking at what the court has done and looking at it with a bit of skepticism, I'm actually, personally, extremely happy with what the court is doing. You see, This East African court is a court of interpretation. It is the court that tells you what the aspirations of the people of East Africa is, what their aspirations are. So they sit in Arusha not to discuss and determine the trade dispute between the tomato trader on Kenyan side and the trader on the Tanzanian side. No. They sit in Arusha to tell you that what you government are doing is not consistent with the aspiration of the people of East Africa. And if you look at the decisions that the court is making, and Brenda may think the delayed release of a judgment was justice denied, no. A principle has been written. It has been put down, and it has been put down in the case between one party and another, but it is speaking to the whole of East Africa. And therefore, the principle that has been set down there that when you close the border, it is against the aspirations of the people of East Africa. That, for me, the court has done. Because then, any trader at any border can go to the municipal court and tell the municipal court, the East African Court of Justice said this is against the aspirations of the people of East Africa and therefore illegal, and therefore I'm entitled to a decision. I participated in the case of BAT versus Attorney General, where we're discussing not even non-tariff barriers, tariff barriers, where the government of Uganda set up a barrier against goods coming in from Kenya. We took it to the East African Court of Justice. We did not go to the East African Court of Justice to tell the Republic of Uganda what to do. We went to the East African Court of Justice to tell us whether what the government of Uganda had done was consistent with the aspirations of the people of East Africa. The Court of Justice said, no, it's not consistent. And therefore, what did Uganda do? It amended the law. So I think what the court is doing, this court is not a court of enforcement. It's not a court of enforcement. It's not a court going to come and shake Uganda and Kenya into action, shake Rwanda into action. It's a court of the mind. It's a court that is helping the people understand what the aspirations of the community are, so that we now change our minds to understand that. And if we continue with this, we shall be able to achieve what we need to do. So the role of the court, in my view, is to provide policy legal guidance. It is like the court that tells you that as you go down in your country to make the laws, don't do this. It's a court of policy legal guidance. And I think the court has done very well. And I think what we all need to appreciate is that the number of cases that are going to the community today, to the East African Court of Justice today, is actually a realization by the people of East Africa that I can actually go get some guidance from the East African Court on what I should expect of my country. Now, speaking from a political perspective, if the East African Court of Justice said it is wrong for you to close the border, and you close the border, the person who is aggrieved, you will go back to them for political renewal. And they will say, no, the East African Court of Justice said what you did was wrong. So that is where we are. But I think where we are as a community, we must appreciate exactly the stage of development at which we are. 39% of the people in Uganda are not in the money economy. They don't trade at all. At all. They eat, they live every day, but they don't trade. Now, the other 61% is in the money economy. But the numbers we are seeing here on the screen are talking about the formal space, the people who are in the formal space. And what Sheila is talking about are the people that we don't see. So the policies that the East African Court of Justice is actually putting in place are the ones to address that question. And I think the East African Court of Justice has done very, very well. And I will encourage you to continue, Mr. President, and your team, to continue to enhance the people-led integration. Just keep talking to us, telling us what is right and what is wrong. And as we go, as we keep changing these small rules one by one, we shall be able to get to where we need to get. I thank you very much.
Thank you very much, Attorney General. I do recognize the arrival of the principal judge of the Court of Judicature in Uganda. My Lord, you're welcome. And can we also clap for the East African Court of Justice, as has been appreciated by the Learned General? Of course, I'm conflicted because I sit at the East African Court of Justice. Thank you very much, Attorney General, for appreciating the work that's being done by the East African Court of Justice and for your submissions on the subject. I will now invite Lady Justice Anna, I know. I withdraw that because Lady Justice Anna Mugenyi is also a colleague of mine elsewhere. Lady Justice Monica Mugenyi to make her presentation. My Lord, Justice Mugenyi, the floor is yours.
Thank you very, very much, my Lord Chair. It's always very difficult speaking after KK has spoken, but I'll try and do my best. It's a delight to be back to the East African community. I always feel like coming back to the East African Court of Justice is home. Very many familiar faces, very good times. I see my former boss, Justice Butasi, my former boss, Justice Libois, my colleague, Justice Njie, and all the current sitting judges. Very pleased to be with you today. And you're my chief litigant. And there's another chief litigant across here. So I'll start where the Honorable Attorney General stopped. And that is briefly on international economic obligations and how domestic courts interface with them, as well as enforcement. I had the privilege of sitting on the BAT case. I think it's the only trade case that the East African Court of Justice has decided in terms of finality. We've had a number of cases. I think when I was leaving, I left a number of cases on border closures and the implications to petty traders especially. I'm glad the discussion has come out in terms of petty traders, informal traders versus the more formal and large conglomerates, because the issues that arise from that sort of trade is different. The petty traders tend to simply move across borders to trade in agricultural produce. A Kenyan farmer who's got tomatoes in Busia is moving across to Busia, Uganda, to trade in their tomatoes. Busia, Uganda has gone through a sort of a period of famine and needs the tomatoes, and they buy it. So that's really petty trade. However, there is also the larger companies, the conglomerates, the formal corporations. The dynamics are totally different. And I think if we're talking about access to justice, from the court's perspective, it's important that the people in the East African Court of Justice, as well as in the national courts, appreciate those dynamics. Because a large conglomerate will have the financial muscle and the ability to mobilize funds much faster than this petty trader will. So in the event of a dispute, as happened recently when we had border closures, and also as the governments continue to learn what the trade issues are, disputes are inevitable. So that's the sort of background to the BAT case. BAT is a huge transnational corporation. It is the sort of corporation that operates in a globalized world and organizes or structures its operations in such a way that manufacturing may take place in country A and sale or marketing takes place in country B, and the agricultural ingredients, the tobacco, is grown in country C. That's how the large conglomerates operate. They maximize the advantages of scales. So that's how BAT comes to the court. BAT Uganda was set up in 1984, if I remember the facts. Actually, the Honorable Attorney General, probably with guidance from my predecessor, Justice Wejuli, is the one that argued that case, as he said. So what happens was BAT Uganda was set up in 1984 at that time to generally deal in tobacco products, including cigarettes. Now, with time, I think as it studied the trade regime and the tax regime in Uganda vis-a-vis Kenya, it opted to have the manufacturing of the cigarettes done in Kenya and then sold by its company in Uganda. So BAT Kenya was doing the manufacturing, BAT Uganda was doing the actual sale. Now, Uganda along the way decides to amend its tax law and increase excise duty to benefit from this tobacco industry. When it did that, it assumed that foreign products from, let me put it this way, when it did that, it categorized foreign products and said they were to pay a higher duty than the local products, which was okay. However, it then categorizes products from Uganda and Kenya, products from Kenya as foreign to Uganda, which was contrary to the Customs Union Protocol. So that's how the case comes in, because the argument was, for as long as the ESC is a single economic unit, you cannot categorize products from any of the partner states as foreign products. So when it comes before us, the issue was, has there been a violation of the protocol, the Customs Union Protocol? And following numerous discussions, I think Justice Nyachai was one of the sinners on that case, together with myself, Justice Nyawelo, and Justice Njie. And I think that's the current Chief Justice of Rwanda. So we decided we need to make this case the sort of case that lays down the ground rules for international trade in the region. We applied the WTO rules. They have the most favored nation principle, as well as the principle national treatment. It is actually reflected in the Customs Union Protocol, but nobody had been looking at it. So we decided this is an opportunity for the court to lay the ground rules on what happens when there is discrimination of products which are from a state within the East African community. And I think I heard Brenda and John Bosco, talk about enforcement. That decision was so well received within the region, within Kenya and Uganda, and it has got excellent reviews across the world. So it was very well received, and the Ugandan government, because I think our orders were synchronize all your tax laws with your commitments to the East African community, and then waive this notice of taxation that you have served upon BAT Uganda. So in short, the government of Uganda implemented every single order that we made in that case. The laws were synchronized, both in terms of drafting and application, and then the notice that had been issued, I think, was withdrawn, if I remember right. So it's baby steps. You cannot compare the East African community to the European Union. The European Union is probably running. We are still crawling. We shall get there, but slowly by slowly, for as long as we have a few cases come up and start to be enforced, it will get there with time. So I don't think it's a lost cause. I think the court has actually done very well. And what I need to encourage the judges of the court to do is whatever decisions that you are making, remember, as the Honorable Attorney General has said, you are laying down legal policy. These partner states look to the court for guidance. There are all sorts of avenues within which you can guide, but it's important that you look at your decisions from a policy perspective, because it's that policy that is hived out and used to apply in the national governance. So that's a message to the national courts as well, that it's important when you look at your decisions to also think about the international economic obligations of whichever countries you're operating in. Because I think in the BAT case, we made the case, we started the conversation that partner states, the domestic courts, need to realize that they are operating within a certain framework. It's no longer business as usual. You are operating within a framework that you voluntarily entered into, and that framework comes with obligations. And those obligations are spelled out in the treaty and in the various protocols. I think it's Article 24, if I remember right, of the treaty, that says that the national courts can actually hear a case against the community. They are not waived from hearing cases against the community. The only limitation to that is when it comes to any matter for treaty interpretation. It is now established East African community law that the East African Court of Justice is the only body that is clothed with the jurisdiction for treaty interpretation. There's the supremacy doctrine that is very clearly spelled out in the treaty, and it says when the courts in domestic, when the domestic courts say in the partner states, when they are faced with any matter for treaty interpretation, they should always send it as a preliminary reference to the East African Court of Justice. You stay the matter, it's interpreted by the court, and then it goes back. So domestic courts, the interface between the domestic courts and the East African Court of Justice is the support function when it comes to treaty application and interpretation. The other thing I wanted to pick up, I think it was from Sheila and John Bosco, was on the challenges, financial autonomy of the court. Having served in the court, I think it's important that we put context to this. For as long as the court is tied to the West, to the Secretariat and IALA, and all the funds come into a pool, and the court is dished out a few remnants, and the bulk goes to IALA and the Secretariat, you are making your court lame. It can't walk. It can't work. Something must be done about that. And I think a very good initiative had come up. The East African Court of Justice Administration of Justice Bill. It went to IALA, it was deliberated, it was approved, it was forwarded to the governments, and it died there. When it gets there, we started trying to follow it up. Attorneys generals, a few would lose it, you furnish a new copy. Then the next time you come back, he's misplaced it, you furnish a second copy. And then, so we are appealing to the Attorney General that is here. I do not know whether the chair of the Council of Ministers is here. Please do not lose our bills. Please, please present them to the heads of state for assent. It is bad manners to lose bills. These are very important documents. So, and this bill was talking about granting the court financial autonomy and administrative autonomy. Once the court has that, it can engage donors directly, because our governments are broke. You know, we need to be candid. Our governments are broke. So get donors to put money in this kitty and let the court plan for it on its own. The next thing I want, and tied to that, is the operations of the court. These judges are ad hoc, except the judge president and the principal judge. So they visit the court once every quarter, go back after 30 days, and we expect the court to function. Remember, trade disputes are about expediency. You can't have ad hoc judges administering commercial justice. Commercial justice, the bank loan won't wait. If you have had financing from a bank, the installments won't stop until the judges are back. So it's important that the ad hoc nature of the judges is addressed, and that the court is very capable of addressing these issues itself. if it can only be removed from this tying to the hip with these other entities, given its independence, it will plan for its money and it will perform. So I think that's very important. We cannot run away from the importance of financial autonomy. Another issue I picked up, I think, again, was from maybe it was the Honorable Attorney General, and that is on the nature of dispute resolution. The East African Court of Justice has a unique mandate in that it has both the litigation and arbitration mandate. And that is perfect for commercial justice and dispute resolution. Arbitration hastens issues. One of the characteristics of arbitration is that it is speedy. Parties have an opportunity to design their own dispute resolution. They have party autonomy to decide who shall be their arbitrator, choice of arbitration, and all these other things. So it would have been a perfect solution to these speedy trade disputes that require expeditious treatment. However, the rules, I am concerned about the rules. I was looking at them yesterday. I know there is finality. They give finality in the sense that there is no appeal. Once the East African Court of Justice pronounces itself on an arbitration, that is final. The arbitral award is final, which is very good, because in terms of commercial justice, you need finality as quickly as possible. However, my concern is on the appointment of arbitrators and the support function that courts play. Since we are discussing access to justice, the trade gaps, we need to be very careful about this. If we have one court appointing judges to sit as arbitrators, and yet we know within the arbitration process there are always challenges. Someone might challenge the impartiality of an arbitrator that has been appointed, or any other challenge that comes up. There needs to be an independent court to which these challenges are taken. Now, the danger with the judges of the court serving as the arbitrators is there is no room for such a challenge. And the trade actors, especially the conglomerates, will want that avenue such that they are able to challenge the impartiality of a judge that has been appointed whom they think is not the appropriate judge. That's the first aspect to it. The second aspect to it is the choice of arbitrator alone. Arbitration is a party autonomy-based dispute resolution process. So parties must be in a position to say, as a point of first call, I'd like to appoint X as my arbitrator, opposite party appoints Y, then the two of them appoint a third arbitrator. But if you're going to say, His Lordship, the Judge President sits and says, so-and-so smiled at me this morning, that's arbitrator 1. So-and-so smiled at me yesterday, that's arbitrator 2. And this one is my friend, so this is the third. It cannot work. We need to be more professional about how we do this. So I think the arbitration rules have huge potential and present very good prospects for arbitration in the East African Court of Justice as a first point of call before we go to the ICC and the London Court of International Arbitration. Let's go local. Let's grow our institutions here. And let's equip the East African Court of Justice to do its arbitral function. But let's streamline that function so that it can do it efficiently. So I think in terms of the arbitration rules, I would propose there may be need, it may perhaps won't happen in this forum, but there may be need to revisit these rules first to tap into the already established expertise of arbitrators that exist in this region. Kenya especially has a huge pool of arbitrators, very seasoned, extremely experienced, that can handle arbitration in the court. So I would think that it would be in the interests of the court to broaden its mandate and tap into the pool of arbitrators that already exists, leaving the court to do the traditional support function, where you either address challenges to arbitration. If there must be appeals on whatever grounds, you address those, then the judges would step out. The second advantage with that is the nature of the huge trade disputes, is that they are so complicated, and some of them are so complex and technical, that the courts, with utmost respect, may not have the capacity to handle them. I think it's important that you tap into, because you see arbitrators don't have to be lawyers, and yet the arbitration process provides for experts. So rather than hire an additional expert to explain things to you, you'd rather have an arbitrator who is an expert in himself or herself, such that cases like construction contracts, you tap into the expertise of an arbitrator who is an engineer. Cases like tax disputes, you tap into the expertise of a professional arbitrator who doubles as a tax expert. And then these would enrich the jurisprudence of the court. In the long run, we're not saying remove the court's judges totally, but in the long run, as you understudy these people, the capacity of the court grows as well. So I would propose reform in that area. Finally, I want to touch a little bit on yes, the final question was the challenges. I think I've talked about the challenges. Yes, my final point now is to the national courts. There is a question that is increasing, at least when I was there, it was increasingly emerging as an emerging issue, and that is the question of the international review of the decisions of domestic courts. It has caused a lot of an uproar, because I remember when we handled the Martha Karua case. This is a lady who came through the system of courts in Kenya and goes up to the Supreme Court, then comes back and says the Supreme Court is no good. That's in a nutshell what she said. So she comes to the East African Court and she's coming to the First Instance Division. And there was an uproar, a huge uproar. How does a judge of the Supreme Court of Kenya pronounce himself, then some humble judge in the First Instance Division of the court sits to review this decision? But the national courts need to be aware that there is a concept called the International Review of Domestic Decisions, which is an established international law principle. And therefore, they could do themselves a service by, whenever they are handling disputes, be mindful of the obligations that your states have entered into. If there are obligations under the Convention on Economic, Social, and Cultural Rights, be mindful of those obligations. We're now talking about the East African Community Treaty. If there are obligations there, be mindful about them as you decide your cases, so that you don't have this uncomfortable situation where tensions are created when matters come to the East African Court of Justice. However, once the matters come to the East African Court of Justice, I think we must start the discussion on the parameters that how far this court can go. Because right now we're talking about a Supreme Court judge, but one day we could have 7 chief justices complaining that we have once been called a little court. That language could come back, where you have 7 chief justices sit in their countries and decide a matter, and then a litigant decides to come to the East African Court of Justice, and the East African Court of Justice trashes the decisions of those apex courts. I think the court needs to be sensitive. There are certain things where sensibilities apply more than legalities. They need to redefine their parameters. As we said, you're a policy court. Define the parameters within which that review can happen. In our time, before we left, we simply said this is the principle. The principle is it can happen. Now the challenge to the sitting judges today is within what parameters shall that happen? Because if you do not address yourselves to that, you run the risk of another Anyang Nyong. Somebody sitting in a partner state getting fed up and saying disband that court while we rethink its mandate. So it is better for the court itself to rethink the parameters within which it shall apply the international review of domestic cases. I thank you very much.
Thank you very much, my lord. That is very useful counsel to the court, but also contribution to the discussion. We're now going into the question time, but very briefly, all the presenters have touched on the challenges that the courts that are faced in the region in terms of the court users and the courts. The challenges range from diversity of trade regimes, including non-tariff barriers, disparity of tax regimes, the mandate and resource limitations of the court, inaction of key players pointing towards implementers of protocols of the treaty, and the need to focus on the aspirations of the treaty, which are the aspirations of the peoples of East Africa. Justice Mugenyi, in closing, has spoken about the need for the courts to be mindful of the impact of their decisions across all levels, both municipal and the regional courts. And of course, most importantly, she has touched on the need for enhanced autonomy of the court by properly resourcing it in terms of financial resource, but also enabling it to operate efficiently by restructuring its operations. She has also advised on the need to reform or revisit the arbitration aspects of the laws of the court. Very validly mentioned, yes, indeed, there seems to be an issue with the way the provisions that relate to arbitration are couched in the East African Court of Justice rules. I will now invite you, first of all, I thank you all panelists and presenters for a very, very good exposition of the subject. Give them a round of applause. I'll invite questions. We have run, I know we started late, and, but I suppose we have 1 minute within the time frame which we allocated, but with the permission of the administration of the proceedings, I will assume I'm given five minutes to ask the questions, and I believe 5 minutes to answer the questions. So I put it to you, these are very important things we are discussing, so be precise so that we, as much as possible, everybody participates. So we'll start with this side and then come this side. So Justice Nyachae, and then 1, 2, 3, 4, 5, 6, and then we'll go this side. So let us start this side. Justice Nyachae, everybody knows the numbers I gave, 1, 2, 3, 4, 5, and 6. Then we'll come this side, yeah. We'll do all the questions. Please, if you want to address your question to a particular presenter, say so, and then we shall go into answering the questions all in one flow. So start the question, Justice Nyachae.
Thank you very much, my Lord. My question is to my principal judge, Justice Monica. I take your point about the courts needing to be sensitive so that we don't end up like the SADC tribunal. But I just want to hear your comment on this. Because the basic role of the East African Court of Justice is to interpret the treaty. And I think it is established jurisprudence within the court that in interpreting the treaty and holding partner states accountable to fulfilling the obligations under the treaty, the court will not shy away, notwithstanding that the organ within the partner states may be the judiciary, for example. So my question to you is this. When you have a situation, and anybody who takes the time, for example, to read and understand the Martha Karua case will appreciate that what the court was deciding upon was the issue of the Supreme Court of Kenya not abiding with the laws of Kenya and therefore being in violation of the treaty. In being sensitive in the sense that you have advised, how will the court do that in a scenario where there's a clear issue that is brought before it which alleges a violation of the treaty on the part of a partner state through its judicial organ?
Thank you very much, my lord. So we'll go to the next question. The next 5, which were this side, was 1, 2, 3, 4. There were 6. So yes, Justice Emeritus from Burundi. Then we'll come to the Lady Justice from Kenya, and then the other 2 behind. Then we'll, Proceed. Proceed, my lord.
Thank you very much. I do appreciate the advice and the brilliant views from Monique, Justice Monique, who in his brief, I can summarize that she has said.
No, don't summarize, please. Ask the question.
Yes, I'm heading to there. That this is an international court which has to abide to international principles. It is not a court of appeal in the same hierarchy. With that, I do appreciate also the most fundamental questions which have been asked here, such as the expertise that can be taken into account when it comes to arbitration, the review of arbitration rules, and a very critical question comes to then these trade issues, petit, gross, in terms of the laws which have been passed at the EAC level. Under Customs Union, we have under 24, sub-article 1, a committee on the trade remedies which is established. And Article 24, sub-article 5, is clear that the decision of the committee are final and conclusive. There was another law at the EAC level which came into place, I think, in 2017. It is an act of EALA, and an act, according to the laws of the community, an act comes into force when it has been assented to by the presidents, the heads of state, and published. It was published, if I am not mistaken, it was published in 2017. It has some aspect relating to trade, especially non-tariff barriers.
My lord, if you may,
yes.
Because...
Then the question is, if we take into account those 2 laws of the community, and if there is a particular conflict between the 2 read together with the provision of the treaty, which one will prevail? My question ends there.
Thank you, my lord. Let us have the 3, and then we'll go this way, and because we are time constrained. My lord, Justice Cheborion, we skipped this row, so we're going behind. Okay, let the lady go, Lady Justice start, and then we'll see when we come back, second round. Yeah.
All right, thank you very much. This is Justice Jackie Kamau from Kenya. Thank you so much, Justice Mugeni, and all the other panelists. Mine is just a comment that when we look at arbitration, you're right to say that Kenya has got very many arbitrators, a large pool. But I think one of the things that can also happen for you people to be able to understand arbitration is to get training. The Chartered Institute of Arbitrators, Kenya, is a good trainer in that. So, but my comment would be that avoid being the arbitrators so that the expertise, you are now going to be left dealing with jurisprudence, like in Kenya. So when we come to your court, let the first court perhaps be looking at the issues of setting aside of their awards and that kind of thing. But then have an option of an appeal, because on points of law, because again, it's very final, it becomes a problem. So you people are creating precedents of being arbitrators, but you should be creating precedents of jurisprudence on those points of law. Because other countries are having the jurisprudence, we look internationally, but then we have nothing from you. And we complain when other foreigners are taken over and above Africans in dealing with these international arbitrations. Number two that I wanted to just mention is that on the issue of the review of decisions.
Please abridge, my lord. Abridge your comments and questions so that we have.
Yes.
We spread
so
out
on
the
the
cake.
issue of review of decisions of the Supreme Court, I'm also careful. I think you need to be careful about interfering with the sovereignty of countries. Otherwise, then there's going to be a lot of resistance. Those are my comments. Thank you.
Thank you. Let's have the lady at the back. You mention your name and then you.
Thank you. My name is Nima Lugangira. I'm a member of parliament from Tanzania and also chair of the African Parliamentary Network on Internet Governance. I just have two quick questions. One, we're talking about issues of cross-border. So I wanted to understand from our very able panelists on how do we handle the issue of cross-border data flows, considering that in our respective countries we have data protection acts, etc. And then the second issue is, how do we manage the issue of access of information and understanding of cross-border women traders whilst they don't have digital literacy and access to internet, because most of these areas are peripheral regions. So they're already limited by the lack of access of affordable internet and access of digital skills. Those are my two questions. Thank you.
Let us have the last person from this side and then we'll cross. Yes, go on, please.
Good morning. Mine will be brief. I will have a very quick comment, elicited by comments from the Honorable Attorney General from Uganda. He was of the position that...
Can you introduce yourself first?
My name is Evans Ogada. I'm an advocate and a lecturer from Kenya. The comment from the AG Uganda was that the role of the court is solely to make policy declarations. I hold a different view. A norm is either a principle or a rule. If you look at the ESC Treaty, we have principle provisions and we have rules. Principle provisions and rules differ on the basis of their degree of obligation, which means the court either way has to give meaning to principles and enforce rules. Therefore, the court cannot be touted as merely a policy declarations. Policy declarations are made by the executive, the political wings. So the court has to enforce rules. Thank you.
Thank you.
Thank you, Chair. A few comments. From where I sit, Brenda, the court must be moved. It will never move to come and help your members if you don't move it. And also I can say the people who least use the court are your members. Very many times I've been invited here in Uganda to talk to business community about the court. When I finish, you know what they tell me? You know, we don't want to be seen to be brushing our government the wrong side. So then how will your members be helped if they cannot go to court? That is something you need to take up. Even the case you mentioned about Kenya's case with FTA in US, that case is already pending in ESCJ. Maybe that would be a good case for your members to join because it is affecting your members. Trade Remedies Committee, 20 years down the line, it has not been implemented. Is it really necessary? Do you think it is still important really to sort your problems? And after all, it is a committee. Those decisions, are they binding? So why not go to court? Get a binding decision that will have to be respected by both parties. I'm glad funding to the court has been mentioned. Every member pays 8 million. Times 6, that is about 48 million. How much does the court get? 4 billion. Even struggling to get to 5 billion is a big problem. The other two arms of ESC share the 90 million. How does the court deliver? AG. Getting less than 10 million? I mean 10%? The bigger cake. And then we want integration. Lastly, for our case, PJ, it has been discussed in very many forums in Kenya. The good thing is that lacuna which was there, out of your decision, is now being addressed. Thank you very much.
Thank you. Let's go to, at your back, Simon. This side, this side. This side is not crossing here.
Thank you very much, Thomas Mire, Kenyatta University, I teach there. I have a question regarding NTBs, small-scale traders, and national judiciaries. So there's this drink in Uganda called Officer Spirit, which is sold in sachets. It is allowed in Uganda, it is banned in Kenya. So apparently when a Ugandan drinks this Officer Spirit, he or she becomes cheerful, while the Kenyan counterpart becomes sick. Now imagine a small-scale trader buying Officer Spirit in Uganda and wants to sell it in Kenya. Now, what would happen is that this trader will be oppressed. This is an NTB. If that small trader does that, the trader would violate the law. The Kenyan judiciary, the courts in Busia, would not eliminate this NTB, although this NTB is banned by virtue of Article, I think, 5 on the NTB Act 2017. The trader will be prosecuted. I had the honor to visit the courts in Busia equipped with the introductory letter of Madam Amandi. The evidence store is full with Officer Spirit. Now, the question is there any strategy on the part of the civil society to empower the small-scale traders to challenge such regulations in the national courts so that the Kenyan court would declare this regulation, this prohibition, as being contrary to the free movement of goods and the NTB Act, rather than oppressing the small-scale trader? Question number one. Now, question number two, if such challenge, judicial challenge, would be brought before the court, would the national judiciaries, this is just an example, it's not about Kenyan judiciary only, would be receptive to such claims? And number three, what about IALA? What about having common standards, common legislation about consumer protection, about safety standards, about eco-design of products, so that, because when you have harmonized standards, such NTBs would not occur? Thank you.
Thank you. The next person.
Thank you. I salute the justices around. My name is Associate Professor Dr. Sadat Samakula. I'm the General Secretary of Uganda Law Deans in Uganda. So I'm presenting all the law schools in Uganda in my presence today. Mine would highlight issues on arbitral proceedings. Justice Mugeni, you spoke more about the exclusivity of the justices in arbitral proceedings. Yes, it is true, under the doctrine of party autonomy, that arbitrators have the competence, and also the doctrine of competenza, and separability, that arbitral proceedings are always separate from court proceedings. A point should be noted that much as we need the arbitrators, it should be noted that arbitral proceedings is not an island. Judges are needed because of the doctrine of complementary, that arbitration is a younger bird trying to fly. So most times the judges give support, especially on enforceability, at times when they need witnesses to appear before arbitral tribunal. The other position that should be taken into account of the role of the courts is the doctrine that when arbitration commences, it is not fully established like a courts. At times, the courts can give a freezing order until the composition of the tribunal is set up. So we cannot at times fully exclude the courts, but we can assume that whenever a matter comes to you and has got a clause of arbitration, it is within your mandate to refer or to stay the proceedings until the matter is fully handled. A classical case is the case of BT against Tano Channel, which laid out a lot of rules and procedures by the House of Lords, and that one can guide a lot.
All right, thank you.
The other point is the question of interpretation. We know that the ECJ does not interpret constitutions of member states. It will be my humble prayer that in matters of human rights and environment, regardless of the constitutionality of member states, the ECJ, in their supremacy as the highest court in the land, to consider the new development with the partner states, that some of these areas should be handled by the East African. Thank you very much, Attorney General and Justice Monica, for the BAT case which has set a precedence.
Okay, we are going to the next, in the interest of time, yes, yeah. Thank you so much for your submissions, your contributions, yeah. Yes.
Thank you so much. My name is Jack Tsime. I work for the East African Youth Network. I would first thank my Lord, the Judge President, when we hosted you at the International Youth Day. You told us that you're going to bring the court to the biggest constituency in the region. And I'm very glad that I'm here to represent the young people. Thank you so much. My question goes to the Attorney General, Counsel Chiwanuka. You said that the court is doing a great job, which is very good. But I want to ask you, do you think that the court should create awareness to help address the issues of its remoteness and how it is very expensive to access it? For example, we've been trying to work with the young people who are in small-scale trade, and we tried to create legal clinics helped by the East Africa Law Society. We actually didn't know that the court can make a decision and pronounce itself to help us directly. So how best can we get to know how our court works and how all these legal frameworks can be addressed on the issue of its accessibility and its closeness to the young people? Because I'm telling you the truth, many of the youth don't know about this court. They don't know how it works. They don't know if they can even be employed there. They don't know if they can even get internship. And I'm looking at its sustainability. If the bigger constituency is not aware of the court,
okay,
how
the point has been made.
Thank
Thank you so much. The point has been made. I think the Judge President has partly answered that question. You answered the question at the beginning when you said you appreciate that the court is sitting here. I'll give Justice Chebori an opportunity to make his comment in 1 minute, in half a minute actually, and then I will go to answers.
Where is the mic?
Justice Cheborion and PJ. And the President of the African Court wants to make, so let us give some latitude.
The question I was going to raise has been raised, but I also just wanted to say that the AG of Uganda has given a very good background as to why the community was set up and the work it is doing and the way it is going. I was only asking him, and I think Justice Mugeni also used the same words, when you say that the court is there to provide
policy legal guidance. This has been asked. This may be misunderstood. I know that it can touch on enforcement and execution of the decisions of the court. Maybe you would rather give more guidance on that. Thank you.
Thank you, my lord. So we'll have the principal judge of the East African Court and then the judge president of the African Court. And then we should come and very quickly answer the questions. And again, I beg your indulgence, the administration of the session will steal a little more time. So, PJ, please. Yeah.
Thank you, moderator. Mine is just to commend the panel and the presenter. But two things needs maybe a response, and I'll start with what Brenda referred to as the doctrine of variable geometry, as a hindrance or as something that has been applied wrongly within the EAC. And I think the concept, as was elaborated by the court, was not to prohibit states from going on with trade relations with third parties if the others were not ready. So if we say, for example, Kenya violated the treaty by engaging other, by leaving behind the others in their trade relations, I think we're missing the concept and the idea that was in that decision. Primarily, the decision is, we have, for example, now 7 partner states. And a good example would be what pertains in the Common Market Protocol, where issues of land, for example, they are left to those countries that, when you talk about the right of establishment, some states were not ready. Use of IDs as methodologies of passing borders. So those fall under the ambit of variable geometry. I thought I should put that clear. But 2, the Trade Remedies Committee. Well, as the former registrar said, it has been 20 years. It is in the Customs Union Protocol. It was established, but it has not been made operational. And whose fault is that? But you have a recourse to the court. All the issues pertained in the Customs Market Protocol, they can be litigated with the court. And with the establishment of the protocol on the extended jurisdiction of the court has been empowered to deal with issues of trade and investment. So probably we should not be talking about this trade remedy as a solution to the problems if the court is empowered to deal with issues of trade. Thank you.
Thank you, my Lord PJ. I'll now close with the comments from the President of the African Court. My Lord.
Thank you, Honorable Chair of this session. Yeah, I was wondering, maybe I didn't know the rules of the game in this forum, because I raised my flag as I used to do. You didn't see my flag. Thank you very much. But it's good also to be the last person to comment. Yeah, mine is just comment, and then I start by commending the robust presentation by Brenda and the powerful contribution by all the panelists. I just want to say I join hand with my sister Monica Mugeni, the Lady Justice, that state members of the EAC,
should be mindful that they have obligation to comply with the treaty, and that which are party to. This has been also a challenge on our part at the African Court, because most of the member states, they do feel that what we are doing, we are interfering their state sovereignty. And what I will just suggest to my colleague, my sister court, our sister court and judges, we just need to soldier on to do our work within the parameter of our mandate, without forgetting to engage with state members in proper forums. One is just like this one, which have involved a number of judges from the domestic jurisdictions, chief justices, judges, and even from the executive, the Attorney General. This is the proper forum where we can speak and discuss. And they have to understand that when the courts, we are doing our work within our mandate, we are not interfering their sovereignty at all. But we are trying to, as one of the panelists said, we are trying to establish some of the policies which will guide the member states to do or to operate their things within within the concepts or the content of protecting and promoting human rights. So I just wanted to join hands with Justice Monica that this is a big challenge, but we are not supposed to retreat. We just soldier on, doing our work within our mandate, and just telling the state members that what we are doing is not interfering of the state or the state sovereignty, but we are promoting and protecting human rights. Thank you.
Much, my Lord. I will now give the panelists just 2 minutes to briefly touch on areas that necessarily need a comment, and those that are basically discussion points or contributions from the plenary will be left to stand as they are. We'll start with Brenda, and then we'll just come in that order, and we'll wind up. You may comment on areas specific or as you deem appropriate. Please, go on.
Thank you very much, and to my fellow panelists and to everyone for the questions. I'll just comment on one which I think was a bit specific to me, and a question asked by a gentleman from Kenya around the NTBs and how some products are not allowed in Kenya, yet they're allowed in Uganda. But I think that there's been an effort towards addressing this, and I like that you concluded with a proposal that we need to have something to do with harmonization, which goes back to the call towards harmonizing our policies and our customs and our practices. But I know that the ESC is right now working on the ESC harmonization of standards, and I think that this aspect could be addressed therein. Thank you very much.
Thank you, Brenda. Lady Justice Mugeni.
Thank you very much. I got about 5 questions. I'll start with Justice Nkurunziza. Yes, there are committees set up in the Custom Unions Protocol. However, those decisions cannot be binding. I think the court's interpretative function is what is binding. So the treaty is binding upon all parties, and a committee cannot stray outside the treaty and claim to be within the Custom Unions Protocol. So the treaty is binding and the court's decisions are binding. Lady Justice Kamau, I agree with most of what you said. It's important that the court separates its judicial function from its arbitration role and starts to create jurisprudence for the region. So yes, I do agree with most of what you said. Then the question of sovereignty came up. This has always been a perennial problem, just like Her Lordship from the African Court said. I think the best way to approach it is, once states sign these treaties, they have to cede a bit of their sovereignty to whatever obligations they are signing to. They can't run away from that in international law. The moment you decide to endorse a treaty, you are saying, I bind myself to whatever is in that treaty. And now to try and invoke your sovereignty later is really not playing according to the rules of the game. So I think I shall leave it at that. But, and that touches on Justice Nyachai's comment, I think it's important for the court to state as much. For the court to, in its decisions, whenever it's faced with these issues of state sovereignty, to clearly state the principles that have been laid down, for instance, the one on the international review of domestic decisions, but then get into the detail on the sovereignty issue and how under international law part of it has been ceded. You cannot sign a treaty and then walk away from it, but want to benefit from it. So I think that's the only, we're trying to be pragmatic. We do not want the court to go the SADC route, but we also want clarity so that whoever is in doubt needs to know exactly what is being said. Then there was a question on, I think from the gentleman from universities. Yes, there was a question about constitutional interpretation. And this goes to what I've just said. The court's mandate is treaty interpretation, but some of the fundamental principles under the treaty include rule of law, and therefore all state organs of partner states are bound to abide by the principle of rule of law. When it comes to the judicial organs, which are the courts, they are bound to abide by their constitutions. That was the gist of the Martha Karua case, where a judicial organ, the apex court, flouted provisions of its own constitution. Now, in order to interpret the treaty and discover whether there has been a constitutional violation, we must interpret the constitution. We are not reconstituting ourselves into a constitutional court, but we are applying the constitution in order to determine whether there's been a treaty violation. That's the context within which we address the constitutions. There was a question by Justice Cheborian on policy guidance and vis-a-vis enforcement. I think I need to clarify a bit more on the enforcement issue before I get to policy guidance. The enforcement under the East African court regime is done by the domestic courts. If a decision comes from the East African Court of Justice that has a judgment decree that requires enforcement, according to the court's rules, the litigant that has the holder of this judgment decree goes to the domestic courts for its execution. So execution happens in the national courts. And that's where the question of visibility comes in. The national courts may not be aware. So the national courts may not be aware of what they're supposed to do in that regard. So it's important for the East African Court of Justice, my Lord Judge President, to keep on going around these partner states and enlightening the national judiciaries on their supportive function as far as execution is concerned, because that's what the enforcement is about. But relying on the goodwill as happened in the BAT case is not very pragmatic. I think we need to go a step further and have the national courts aware that they are to play a role in terms of enforcement. I think those are the questions that came to me, so thank you very much.
I'll just also respond to a few questions that were raised with regard to cross-border trade data. Let me say here, like in Uganda, the Bank of Uganda, in collaboration with the Minister of Trade, they always have a system to collect data, trade data at the border, and especially cross-border trade-related data. And that data is validity, and it is always shared. Another question was raised was on the trade information for cross-border trade. And I'm happy that the chairperson of IASA is here. We work closely in terms of, we have a desk at each and every border, almost 13 borders, in terms of monitoring what the cross-border trade go through and we provide them regular and updated information on how to trade, especially using what we call simplified trade regime. It was one of the instruments under Customs Union that enables cross-border trade to trade with the minimal challenge, and that instrument is being used, and generally we are even extending it to the wider continental free trade area. I know ECOWAS has already approached us to support them, and other countries are approaching us. Then there was, and I want to appreciate the principal judge for the issue of trade remedy committee. This has been one of the daunting challenges for the business community, that the committee is not working. And with all the commitment, with all the, this is not working. I'm happy that the mandate of the court has been extended to cover, their jurisdiction has been extended to cover trade and investment. So, and I agree with you that we don't need that trade remedy committee. The same for NTB Act. Someone spoke about NTB Act. Why do we need, if the court is doing that, why do we need again the Act? Because I think the court has more authority and power to address such issues. So I'm happy, but my last comment maybe as a concluding remark is that we need to work together with the court in terms of awareness creation, sensitization, and simplicity. Let's try to use simple languages. Let's try to understand that we are serving the small and micro enterprises who don't understand these legal jargons. Can we simplify it? Can we create the way we have the simplified trade regime? Can we have also a booklet in terms of the legal a booklet that would enable the traders, small cross-border traders, to understand where they can address their issues, their disputes. So we can work together. EABC is committed to work with you in terms of developing that tool. And we, again, the issue of resources, we can work together to mobilize both the resources from our partners, not necessarily the donors, but even the resources from private sector, because the challenge from the private, as everyone has mentioned, if we address these disputes, the business will go, the companies are committed, like the BAT case and other cases we've handled. It is a testimony that the court is working. So we need to share, and generally that's the issue. Some of the judges were telling me that you are not allowed to market yourself. Why? And I was wondering why the court shouldn't be visible when you are doing such excellent work. So we need to step up in terms of communication, visibility, sensitization, understanding your law and obligation very clearly. Thank you very much.
JB.
Thank you very much, my lord. There was a comment about the jurisdiction of the court. I think that one I'll just state that jurisdiction of courts is a matter of law. So if you read the provision and says they interpret rules, then we do that. But I think the court has gone a long way in determining this question of interpretation on what the jurisdiction of the court is. Mr. Tusime, yes, we need to address awareness, and I think that's what exactly the ESCJ is doing here, going around the partner states to have these conversations so that we can all get the buy-in. And I think I would like to commend the court for that, because I think the biggest problem is awareness. And I think we're going to do that. Justice Cheborian, yes, the role of the court is to give policy, legal guidance. The enforcement is going to be by the municipal, the individual country. And that is why buy-in becomes very important. That's why buy-in becomes very important, because imagine a situation where the East African Court of Justice makes a decision and the country doesn't enforce it. That's disorder. But the law has said they will enforce it. What do we do if they don't? We can issue another order of contempt and they don't buy in. So we need to get that buy-in. We need everyone to understand that the lady president, judge said, this buy-in is important. It's very easy for us to write these things on paper, but understanding their practical implication, that is where the court comes in. And the court needs to be mindful of that. And like the PJ said when discussing variable geometry, it's exactly that. The partner states were alive to the fact that they were giving away their sovereignty, but still taking it back. So they gave it away and then put another provision which said variable, we will go together, but I can go alone. So it is that stage where we are that we need to be careful as we address these issues. And as partner states, what our role from the executive is to constantly reflect on these things, reflect on them, and Uganda will have no problem with ASCJ because the principles on which we are operating are very clear, and so it is for the different partner states. But the circumstances that obtain on that day in the partner state must be taken into consideration. A judgment without context is a very dangerous thing. A judgment without context is very dangerous, and where we are sitting, I can tell you it can really be a problem. So, Madam President, yes, you can carry out your mandate, but within the context of, and especially now, East Africa is smaller. Africa is even bigger. You have a much bigger diversity. Of here we have a fraternity of people. We speak almost the same languages, and etc. We all understand almost the same thing. And even the things that we had a vice president in Kenya who was a brother of a minister in Uganda at the same time. So the fraternity of people is so close that it is different. So the context in which we make these decisions and wish for them to be enforced needs to be taken into consideration. Madam, Lady Justice Monica Mugenyi, I'm going to find this law. That got lost somewhere. I don't know where it got lost. We are going to find it. But as I conclude, I think for me, what I want us to go away with is to ask ourselves consistently the question, do we need each other? Do we need each other? And every time you ask that question and say yes, then you must soldier on. Do we need each other? We do need each other as a fraternal people in East Africa, as a fraternal people in Africa, and therefore we must soldier on even with all these challenges. I thank you.
Yeah, my lord, my case has been well stated by the panelists, and in the interest of time, I rest my case. Thank you.
Thank you. Thank you so much. Thank you. Let's clap for all ourselves. We have been a very interactive audience and presenters. We, I'm sure, have enriched ourselves in terms of comprehension of the role of the courts in resolution of cross-border trade disputes, and also generally on the functionalities of the courts. Before I ask panelists to leave, I'll just do two things. I would like to recognize in our midst the Chief Justices of the Republic of South Sudan, the Chief Justice of the Republic of Burundi, and the Chief Justice of the Federal Republic of Somalia. You're very welcome, Your Lordships. And finally, I'll give the Judge President of the East African Court of Justice a brief moment to say one or two things before we step down, get off the podium.
Yeah, thank you very much, my brother. First of all, I wish to thank the presenter and the panelists. Secondly, I can assure you that we must understand the role of the court in a political and a socio-economic development, which is not well understood, because people may not be aware that the role of the court in the political and the socio-economic development is key. There is no one system which can develop without a strong judiciary. No one in the world. It is why I'm making a plea to the Attorney General, who is the member of the Council of Ministers, who is also a member of the Secretarial Council on Legal and the Judicial Affairs. That is the specialized Secretarial Council of the community on legal matters. You are a former private litigant. Now you are a government litigant. And I know we have talked with you. I talked with the Chief Justice here, with the President of the Parliament here, with the President of the Republic here, with the Minister in charge of ASC Affairs. The philosophy of this country, it is an East African philosophy. If you hear Muse here, he talks about prosperity, which means wealth. You can never have prosperity without strong judiciary. He talks about strategic security. You can never have strategic security without strong judiciary. He talks about fraternity. Fraternity is what? Is that people from Uganda, from Rwanda, you find yourself brothers and sisters. You can never be a fraternity, you can never build a fraternity if you are just crossing borders and you don't have judiciary, just there. So that's the philosophy. It is why when we came here, even before we organized this activity, we had to meet with the madam, the speaker, and we talked, because she was also a litigant to our court. The Speaker of Parliament here, she was a litigant in our court, and she got justice. The first Deputy Prime Minister, she was a lawyer, so she knows the importance of justice. She knows. It is why she has been implicated in the organization of this conference. So to me, I'm saying, my brother, the Attorney General, find the way you can defend the financial and administrative bill of the court. Instead of the court going to the Secretary General, there is a very strong committee called the F&A, which decides on what the court can do. We organize our activities, they delete. So if we say we go to South Sudan, they delete, they say this is not important. You can imagine the senior official coming from the partner says, who decide what the court can do? What kind of that judiciary you want? It is not possible. Even when we organize these kind of conferences, there are partners who thought we are campaigning for the people to file cases against them. It is not true. Because the people, they have the right to know what we are doing. Because they are our employers. So we will be here. We know people may think, well, especially for you politicians. You hear yesterday, a minister saying, we must look at the treaty because this court may be interfering with our sovereignty. Instead of, for you, the politicians, going and respect the rule of law, which is the requirement of the treaty. Article 60D is clear. 72 is clear. So when we say the partner should abide with the principle and the treaty, and the case comes to our court, what happened in SADC, to us, it is not a problem. If the partner says, if the court can interpret the treaty, and it says, we violate the treaty, that they can go and say, let us do what happened for SADC. It is not our business. So to me, I'm saying the Martha Karua case is not a problem. It is a good case which you can go and read. It shows that even if for the judiciary, whatever you are making your judgments, tomorrow it can be taken to Eastern Court of Justice and put on the balance and see if really what you did is in compliance with the provisions and the treaty. It is what we do. And there's no problem. So if the Burundi judiciary, which the Chief Justice is here, if they make a ruling there, a judgment, they should not be afraid. That judgment now, people are knowing what the court is doing. There is a court there. We can go and challenge what happened in Burundi. So if the people come, it is not a problem with the judge president. So what we do, we put the judgment by the Judicial Supreme Court of Burundi on the balance and see if really that judgment is in compliance with the provisions of the treaty. So to us, we are comfortable with what we are doing. You have set precedents before we come, before we join. What we require is only that let people understand the role of the court. Last year we were in Burundi the whole week, the whole month. Now we are here. Next year we will be in Rwanda, and we are not afraid of that one. Because we have been appointed to be in ESJ. Tomorrow we will leave. But what are we leaving behind us? For us, that is the issue only. So I'm saying that these panelists, the subject of our discussion was key. It was touching about the trade, about the business of the court, about the life of the court, We have the former member of EALA, and we thank you very much even for the bill. You know how it came there up to there. So we are saying, let us continue informing the people that the role of the court is key into the implementation of the agenda of the community. It's not only having a court in Arusha, we're sitting there requesting some money from the secretariat. They can give, they may not give. Every day we are writing a letter requesting money from the Secretary General. Sometimes they respond. In order to respond, sometimes we have to talk and then you try to laugh, so that at least you can be into good collaboration. It is not a proper. I submit.
Thank you very much, Judge President. Thank you very much once again to all of you distinguished panelists, and thank you very much the administration of the sessions for giving us a latitude to abuse the time, but I think it was for good. Thank you so much.
Thank you very much. Let us appreciate the panel. Thank you very much. We are going into a tea break, given the time according to our watches. But before we do that, I would like to inform the delegates that COVID tests are ongoing for purposes of the closing ceremony tomorrow. You can access the services in Aswa room, which is on the first floor. If you go to the reception, they will guide you on where you can do the tests. For those of you who may have done tests before, especially for the conference which is in Munyonyo, the tests which were done still apply for this closing ceremony. So you don't need to do another test. There has been a concern because according to the news we watch, there are issues to do with Ebola. We would like to bring in someone within 5 minutes. We allow him to give us some information about Ebola so that we can have our fears allayed. Doctor, I will give you 5 minutes and you try to assure our delegates here about Ebola.
Thank you, and good morning to you all. I am Dr. Kambugu Trevor, Regional Emergency Medical Services Coordinator for Greater Kampala Metropolitan with the Ministry of Health. So in just 3 to 5 minutes, I'm just going to give a bit of a brief about Ebola and the situation we are having in Kampala, just so you know that the condition or the situation is under control and a lot is being done to see that it does not get out of hand. So, as is right now in Kampala, we are having 17 confirmed cases. That's Greater Kampala, Wakiso, and Mukono. And all of these are under institutional isolation, meaning that we were following up these people. And these are all connected to about 3 families or 3 cases that had escaped from Movende Kasanda. And these were all being followed up. That is why we were able to identify them and take off tests before some of them became positive. And some of them even became positive while we were monitoring them. They initially had negative tests, but we'll continue to monitor them under institutional isolation. A lot is in place for Kampala and the country at large, Kampala, Movende, Kasanda, to ensure robust contact tracing, that we are following up who have you been in touch with, who have they been in touch with, where did they come from, to see that we are able to identify all the likely suspects and asymptomatic or people without any symptoms that have not yet developed any features of Ebola, have them under, some of them are had under isolation, according to the guidance present, and then we keep on monitoring them and we see who turns positive. So there's a very robust system in place. Just to know, Ebola is a condition that has been around for quite some time and has ravaged lots of countries across the world, much so in Africa. We've not Uganda is particularly not having the first or second outbreak, and in all of these we have come at the top of it. It's a viral disease. The spread is very known. the features or the ways in which we can prevent spread and cut off the propagation of the disease in communities is also very well known, and they are very easy activities or behaviors that we should be, or practices that we should be doing. Just so we know, the spread of Ebola is through contact with body fluids from a person that is infected. That is blood, can be blood, can be mucus, can be sweat, can be urine, can be fecal matter, vomitus. As long as the person is infected and you get in touch with this, you can potentially get Ebola. Not necessarily that you will, but you can get Ebola. And then other ways, of course, when you participate in the burial process and you come into contact still with the fluids, you come into contact with the body, you still can also get Ebola. The primary way in which it is thought to come to the human population is contact with animals that are reservoirs or that are usually having this virus in them, and those are primates, bats, some wild antelopes, and the like. And then they come into contact with people, and then people propagate amongst other people. And with that information, it is easy also to understand how we have to prevent, or we can cut off the spread from one person to another. But before I get to that, I'll just go through the signs and symptoms for Ebola. Ebola presents like many illnesses that we commonly have in our sub-Saharan setting. It can present in the features looking like malaria. There is malaise, there is general body weakness, muscle weakness, fever, headache, and then other things can come in. There's a sore throat, some people are coughing. Bleeding is a late sign, and by the time people are bleeding, it's usually in the late stages of the disease. And it's a small percentage actually of patients that do bleed, only about 30%. Yes, but many of the features are generalized. So the main way we identify them is contact tracing and finding out the whereabouts of the people, being very robust in taking off samples to test people. Whoever is line listed, we do test them, and we do continuously call them to know what is happening. Getting to the prevention, we know that Ebola is a severe disease and can be deadly. Depending on what kind of care is available, the mortality or the percentage of people that will die from the disease can go all the way from about 3-5% to even 90% or 100%, depending on the care that can be provided. But the key thing is that once people are identified earlier on and are taken into facilities for care, this mortality or the percentage that will die is reduced very significantly, and that is why the ministry has invested a lot of resources and redirected a lot of resources in early detection of these cases, and that's the contact tracing that we are doing. So the things that we can do to prevent Ebola: one, avoid touching, handshakes, fist shaking, even elbows. We avoid that. At the moment, you can just do a greeting with just a wave, and that should suffice. Another thing is caring for the sick. If you are caring for a person that is suspected to be having Ebola, one is that you should inform the Ministry of Health so that they can send teams to evacuate the patient, and the teams that are well covered or well protected with the appropriate gear do take care of the patient. That is the second picture and caption that you're having there. Number three, people that are suspects. If anyone is suspecting that this person might have died from Ebola, they still have to notify the ministry so that the ministry sends a burial team that will go and do a safe and dignified burial for this person. And these are all in place currently in Kampala and Mubende and the other places. And then, very importantly, hand washing. This was a winner for the time that we had this outbreak in Gulu, and it had taken over a very big landscape. Hand washing facilities, homes, every home had a hand washing facility, tippy taps, basins with jik, with appropriately mixed jik, and they were able, the region was able to overcome Ebola. Not because there was a medicine that was treating Ebola, but just this practice of IPC, preventing physical contact. If a person is suspected to have died from Ebola, you do not conduct the burial yourself, but you call the ministry teams to come and do a safe and dignified burial. These are the things that work for Ebola and have been proven for the past outbreaks and will still continue to work even in this outbreak. So I want to assure you that a lot is being done by the ministry. In concluding, a lot is being done by the ministry to ensure that there are no positives that are discovered out in the community. Many of these people are already in isolation when they do turn positive, which is a very good thing for the response. Thank you.
Thank you very much, Doctor, for that guidance. We are going for tea, and according to the time now, it is 5 minutes past midday. We can be back by 35 minutes past midday. I will request the protocol to guide the front row on where they are going to have tea. For the rest of us, we shall have tea from where we did yesterday. You are welcome for tea. Let's reconvene 25 minutes to 1 for the next presentations. Thank you.
Mesdames et messieurs, le gouvernement de l'Ouganda et la Cour de justice de l'Afrique de l'Est, le bras judiciaire de la communauté de l'Afrique de l'Est, par l'intermédiaire du juge président, le juge Nestor Kayobera, vous souhaite la bienvenue à la deuxième conférence judiciaire annuelle de la Cour de justice de l'Afrique de l'Est.
Kenya, that is Ajwala and Kama Advocates. She holds a Bachelor of Laws, LLB, from the University of Nairobi, Higher Diploma Kenya Law School. She's an advocate of the High Court of Kenya. She's a trainer of trainers in human rights advocacy and conflict management, which she obtained from United Development Program, UNDP. Second, Stevenson Wood, London, on arbitration in Africa. ECJ as a seat of arbitration for commercial disputes. DRC entry into East Africa. What does the country bring to the table? Some of those are the publications that she has made. Other information concerning her is that she has participated in dispute resolution in regional cross-border commercial trade, employment, shareholders, contractual, tax cases. She's an advisor on enforcement of local and international arbitral awards in Kenya. Elected member, Law Society of Kenya Task Force for Policy and Legal Reforms, and she is rated top 40 women under 40 in 2021 by the Business Daily Kenya, ranked by the Chambers of Global and Legal 500 in the dispute resolution category, Kenya, speaker at the East African Arbitration Conference on Arbitration. The person I've mentioned above is the person that is going to take us through this session that is upcoming. Let us welcome Faith Macharia, the moderator of this session. You are most welcome.
Thank you very much for the warm introduction. So the President of the East African Court of Justice, the AG of the Republic of Uganda, Chief Justices in attendance, judges and registrars from our national courts and regional courts, representatives of the government of the East Africa community, private sector, ladies and gentlemen, good afternoon. So this is session 5 in your program. So we are going to discuss a topic that is not new to most of us in this room, and this is alternative dispute resolution. Realities, we are going to look at what is happening on the ground in our member states, the deterring factors, and the solutions. Now, the Lady Justice, Honorable Monica Mugenyi, has started us off on this topic at a high note. She highlighted some of the areas that we needed to look into regarding arbitration at the ESCJ. And we also received comments from the audience. So we will start off on that note. So to lead us through this discussion is a distinguished panel that's before you. So our first panelist is the Honorable Justice David Kutosi Wangutusi. He is a retired judge. He holds a Bachelor of Laws from Makerere University. He also has a master's from the United Kingdom in Science Research in Law. He joined the courts in Uganda in 1983 as a magistrate grade 1, and he grew up the rank to become the judge of the High Court in the year 2000. In 2013, he headed the commercial division, and in 2016 to 2021, he was a member of the Judiciary Law Reform Committee. He has done a couple of publications, just to mention 2, Case Flow Management, Role of Judiciary in Economic Development, and the Role of Information Technology in the Courts. That was a discussion that we had yesterday. Welcome, my Lord. So the second panelist is the Honorable Justice Mr. Richard Mororo Mongo. He's a presiding judge, High Court of Kenya at Kirinyaga. He's a graduate from the University of Nairobi, and he also holds a diploma in business management, Kenya Institute of Management. He has practiced both domestic and international arbitration, and he's an approved tutor and trainer in arbitration and ADR in several countries in Africa. You're welcome, my lord. So, and the third panelist, we'll have Miss Florida Kabasinga. That's the lady seated between the two judges. So she's the founder and managing partner of SATA Law Chambers. I was told it's pronounced SATA and not Kata. I was very careful to get the pronunciation. Kigali, Rwanda, where she leads its ADR practice. She holds a Master's of Law in International Human Rights Law from the University of Notre Dame, Indiana, USA. She also holds a Bachelor of Laws from Makerere University. She's just chair of the ADR Committee of the East African Law Society, and she's also a member of the Kigali International Arbitration. Welcome, Ms. Florida. And the last, not the least, is Mr. Aderickson Hezron Njumwa. He is the presenter today. So after the introduction, or maybe in the course of the introduction to save time, I can ask you just to start moving so that you can settle in. And once I finish, you just start off with your presentation. So he's a senior arbitrator, Tanzania Insurance Ombudsman Service. He is the vice president of the Tanzania Institute of Arbitrator. He's accredited mediator and arbitrator by the Ministry of Constitutional and Legal Affairs, Tanzania. He's a registered arbitrator of the Tanzania Institute of Arbitrators. He's an associate member, Chartered Institute of Arbitrators. He has done a couple of publications. I'll just mention one, A Practical Guide to Insurance Litigation, Theophilus Enterprises, Dar es Salaam, 2022. So welcome, Mr. Njunwa. So just a bit of guidelines on how we are going to carry on this panel. I'll ask my panelists and the presenter to stand on the protocol that has already been observed to save on time. Then we'll have a presentation maybe for 10 to 15 minutes, willing. And then I will give my panelists about 7 minutes each for reaction. And then now we'll be able to open up to the floor for their comments. I understand some of us have flights to catch and will not want to miss some of the sessions. So you allow us to be able to work within the time that has been allocated to us. Welcome, Mr. Njunwa.
Thank you very much. That was a very good introduction. Protocol having been observed, I salute you all. I am glad to be standing before you to share my thoughts on the realities, the deterrent factors, and what might be the solutions towards improving ADR in our region. I am also glad that I am in the panel of my bosses because I am a son of the judiciary. I was started off by the late Chef Mjasiri as a judge assistant at the Judiciary of Tanzania. So I am happy to be among you because I am actually in the company that I am used to. In the interest of time, I had about 40 or so slides, but I will try to condense them. And I'll look at the general overview, but I will also touch on the inside out of the ADR, as well as the legal framework of ADR in the East African region, and the institutions. And then I'll look briefly on the what I consider to be the deterring factors of use or maximum use of ADR. And then I'll look at the suggested solutions. And just as a matter of emphasis on an overview of ADR as an acronym for Alternative Dispute Resolution, which is conventionally known to be other ways than litigation in accessing justice or in resolving dispute. Now, the emphasis that I have there is that currently there is a shift of discussion or definition of what actually ADR is, because conventionally that definition puts these other mechanisms of resolving disputes onto a lesser status to litigation. But currently, the shift is to more of appropriate ways of resolving dispute rather than them being alternative. So that is the point of emphasis there when defining or describing ADR. So that is a point of emphasis, that currently there is a move to shift the definition from it being alternative to it being appropriate dispute resolution, meaning adopting any other way possible to resolve a dispute out of litigation or different from litigation. And there are several others who are agreeing on that. Why? Because every dispute has its own circumstance, its own requirements. And in order to make full use of ADR, there is that shift of definition. So that is the emphasis with the definition. And maybe the importance of ADR was given, or I would rather quote the words of two prominent persons whose word still lives on. The first one being the late Land Council, President Abraham Lincoln, also known as the Honest Ebb. And the other one is the living Jesus Christ. Also, he has something to say about ADR. So, Lincoln once said, he was a practicing lawyer at some time, he said that discourage litigation, persuade your neighbors to compromise whenever you can, point out to them how the nominal winner is often the real loser in fees and expenses and waste of time. As a peacemaker, the lawyer has a superior opportunity of being good man. There will be business enough. That is how we put it in the emphasis of you or lawyers or anyone involved in a dispute, just find any other way around litigation to have your scores settled. And then the latter one, as I said, the living Jesus Christ, who is also known as the Savior, or others call him the Messiah, others call him the Prince of Peace, wonderful counselor. He said this, come to terms quickly, that means at the earliest opportunity, with your opponent at law while you are with him on the way, where? To court, so that your opponent does not hand you to the judge, and the judge to the guard, and you are thrown into prison. He is saying, I assure you, and most solemnly say to you, that you'll not come out of there until you've paid the last cent. So, as an emphasis, why you should adopt any other alternative way before you're taken before a judge. Because once you are before the judge, you'll be taken to another person. And certainly, the emphasis here is you adopting any other way possible than litigation, so as to avoid litigation and its consequences. That was the emphasis with these two prominent persons in their weddings. Now, as I said, currently there is a move to remove the A, which stands for alternative, and instead putting for it appropriate. Why? Because these ADR forms are defined and categorized depending on the nature of the engagement, nature and purpose of the engagement. Why are you engaging? Why are you, and how are you engaging in the discussion around litigation? And there are several suggestions which will always will tend now to show that whatever you're adopting is either better dispute resolution or appropriate dispute resolution or affordable dispute resolution, or at least the appropriate depending on a particular circumstance. So depending on the nature of the engagement, you may have preventive ADR, which includes negotiations, partnering, peer review, early neutral evaluation. Also, you may have facilitative ADR, where you have now a mediator facilitating parties to arrive at a resolution. But also you have advisory, where you have conciliation and collaborative lawyering. Also, you have determinative ADR, where you have arbitration, adjudication, expert determination, as well as these hybrid models, where you have combined mediation, arbitration, mediation. But also you have collective ADR, which is an area not that much developed in our jurisdiction, but taking place in, for example, in South Africa, the collective ADR, where you have ombudsman schemes, and of course, court-based ADR, where you engage through the courts. Now, all these ADR takes place or are governed by fundamental principles of voluntariness, commonly part autonomy sometimes, and confidentiality, neutrality of the parties, of the neutrals involved to assist the parties, as well as self-determination through informed consent of the parties, and flexibility. Those are some of the fundamental principles that governs the conduct of ADR. Now, with that background or foundational cause, I would rather touch on the inside out as part of the reality check of ADR, because always ADR has been praised for being master key to access to justice for its relative costlessness or expeditiousness, but there is its downside, and critics exposes this downside, and I think it is good to look at them so that when we are trying to look at solutions, we are so much informed on this other side. So the downside of ADR, they talk about the lack of precedence, which is based on the rules of privacy and confidentiality. So it is said that where there are no precedents, sometimes it's hard to predict how ADR may turn out and what may happen. So it is being put forward by writers and practitioners as a setback or a downside of ADR. But also they say, actually, the privacy and confidentiality sometimes has a tendency of shielding some of the injustices in the society. For example, you have a Swahili saying, kitanda kizai haram. When that means matrimonial bed does not produce illegal or illegitimate children. A very common saying applied in traditional dispute resolution when you're trying to bring together matrimonial issues. But also they are saying that private self, resolving disputes privately, has also a tendency of justifying the aggressors or oppressors' impunity, because you say, oh, let us keep things just inside, whatever, and that's why you see lots of gender-based violences in the families continuing, the downside of ADR. But also, there's a question of power imbalance and coercion, rather the possibility of coercion rather than concession in ADR, where you have mediation. It is a fact that parties cannot be equal in terms of status, socially, politically, economically. So it is said there is this possibility that the weaker party in those angles could sometimes be forced to concede to the solution. Yesterday there was a hot debate about plea bargaining, all those things. Plea bargaining is a sort of ADR mechanism in the criminal justice, but one would say it's another mode, but where some feel people may be forced to concede just because of ADR. But also, cost is another issue. They say it is actually not that cheap. For example, in arbitration, you have several types of costs that in most instances are borne by the parties, and which I commend the East African Court of Justice, because there you don't pay arbitrator's fee. So it's a point of emphasis for people to know. But there are several costs that may be involved in ADR. But then other would say there is this third-party funding as a savior for costs that may be involved in ADR. Yet, even third-party funding is said to have its downside insofar as ADR is concerned, because it is said that there may be possibility of overly influencing, the third-party funders, overly influencing the process, and possibility of conflict of interest, because a third-party funder is not looking at whatever relation wants to be maintained, he is looking at what he gets or the return after the process is done. So they are saying, for instances where, for example, you have a same third-party funder funding an ADR proceedings where the arbitrator or mediator was also a mediator in another proceeding which the very same third-party funder was funding that proceedings. They are saying there may be possibility of biasness and overly influencing. So those are some of the downside of the alternative dispute resolution mechanism other than litigation. But also there are questions of unpredictability in the enforcement. For example, they are still very hard or not that straightforward as a court decisions in enforcement, for example, of a settlement agreement. We have currently the draft bill of the ADR bill in Kenya, which is trying to address that one because it is prescribing how the settled agreement can be enforced. But also ADR sometimes is regarded as a tactical delay. Some of unscrupulous lawyers or parties may use that chance to simply to have a view of what is happening the other side, though actually there is that rule which says that you cannot use whatever that you've held during the proceedings of ADR to any other avenue, litigation, but that in actual fact does not prevent the parties from benefiting from the information that they had during the ADR. So sometimes unscrupulous people may use ADR to simply see what is happening the other side so that they can, at a later stage, get out of the process so that they can proceed to somewhere else. That is the inside out. Now, I'll quickly go through the framework, which has already been touched on. We have the treaty in the region. We have the East African Court of Justice rules of procedure, as well as rules of arbitration, but they are all pro these other forms of settlement. The treaty talks directly about arbitration, but you have the rules of procedure under Rule 64, sub 2, which allows the court to adopt any other form of settlement, of dispute resolution, as well as mediation. So it's a good point. Also, now, actually, I would love to ask the justices that whatever discussion that took place about arbitration, whatever, should be adopted in our discussion so that we leave out much of what we might not need to repeat. Equally, the member states, they have their ADR legal framework is inculcated in the constitutions. Almost all members. And they have also ADR legislation. But one thing notable is that these legislation are scattered everywhere. They are not streamlined, which also may be a deterrent factor. And another thing about ADR, maybe at the East African Court of Justice, is that it is quite progressing very well in ADR, though it seems it is not that much used. For example, arbitration. Maybe it may be due to maybe visibility. Not visibility of the court, but of the ADR mechanism itself. So, but it is quite doing well. Institutionally, in East Africa, we have several institutions right now on ADR. I have outlined only few, which are prominent. For example, the Kigali International Arbitration Center, the Tanzania Institute of Arbitrators, the Nairobi Center for International Arbitration, the Chartered Institute of Arbitrators, Kenya branch. We have the Uganda Center for Arbitration and Dispute Resolution. We have the National Center for Arbitration, Council and Mediation, which is Senacom in DR Congo, and the Burundi Center for Arbitration and Mediation. Now, I've made a note of what is happening in this institution, that most of them have rules that are based on international best practices in ADR and arbitration, which is a very good point, which is increasing the international visibility. They have state-of-art facilities. For example, the Nairobi International Center of Arbitration, which is ranked the fourth on what can I say, on facilities. Also, you have the Kigali International Center, International Arbitration Center, which is also among the top 5 of the best arbitration institutions in the region. So these institutions, they have also tried to create a register of arbitrators, both international and domestic. So they are trying to create visibility of our local practitioners, which is a very good mark. Now, that is a bit of what I deem to be happening in ADR in brief, because the topic itself is very wide. I cannot claim to do each and everything that there is about what is happening in the ADR. Now, what I consider to be the deterrent factors towards the full realization and utilization of these other methods of resolving disputes alternatively or different from litigation. One, absence of ADR policy framework. It has also been hinted somewhere during the discussions, both in the government and private sectors. Only few are trying to now do that away, but there is no actually, for example, policy directives to direct all government departments or whoever that anything, whatever is a dispute, ADR should come first before you think of anything. Likewise, in the private sector, as it is required in other areas, for example, you cannot take a loan without whatever guarantee, guarantors or whatever. I would think if private sectors were having ADR policy, it could help its use. That maybe that could be ADR policy statement. You don't do anything with any private sector without seeing that policy statement. But another thing which is a deterrent factor is visibility and accessibility. As I said, these methods are common, yes, but they are not popular. They are not popular. So it is a deterrent factor. It is a deterrent factor. They are not visible, but the accessibility is also tied to other conditions, for example, competence and all that things, fees and all those things. So there is low publicity of these mechanisms. But also you have lack of synergy in training. Training has been a point which has also been discussed here. All these institutions plus higher learning institutions and other learning institution levels, they have no integrated curriculum on this alternative dispute resolution, and also their importance and how they facilitate access to justice. It is not there, and therefore it is deterring growth and use of ADR. But also you have legal practitioners' competence and their attitude towards ADR. You can't believe and I know most of you can testify to this. There are some of the lawyers who are still averse to ADR, alternative dispute resolution. For example, I had an instance in a training where this lawyer is telling me that she had a client of the co-counsel that was a defendant who came to report his lawyer to this lady that my lawyer is refusing me to settle this matter because I know it is true I trespassed the land of this gentleman, but my lawyer has refused, he doesn't want me to settle. So you have all these incidences. Lawyers, first of all, most of them are not competent in ADR, but they are also averse to ADR. Then you've also legal practitioners lacking in-depth knowledge about areas that generate international arbitration or international dispute resolution. For example, maritime, exploration, mining, insurance, which are very key areas which are occupying international arena in arbitration. So it is making maybe sometimes our practitioners not to be of choice, though some of the jurisdictions are progressing very well. For example, Kenya is doing very good in terms of developing capacity. We have also no effective monitoring and evaluation mechanism for the ADR. How is it performing? We are trying so much to push it, but yet there is not in place a mechanism to monitor how it is performing and evaluate what are the challenges, what are the weaknesses. And I'm happy that this formed a part of the topic in this conference, and I commend the EACJ, because it could help, this discussion could help if we are so much determined to make full use of ADR. Now, what I consider to be solutions: one, we need strong political will and a policy framework towards developing and use ADR, to make ADR as an integral part of the policies aimed at improving access to justice. So what is the use of policy framework? It will ensure there is adequate resources towards development or implementing ADR projects. For example, ADR community legal aid services through ADR. Also, it could help to create alternative structures and institutions. For example, the ombudsman institutions, which are so much now prevalent everywhere else, but not so much used in our jurisdictions. In Tanzania, we have the Insurance Ombudsman Service, which is under the Ministry of Finance and trying to resolve insurance disputes by ADR, mediation, reconciliation, and arbitration. So it's trying to cut the chunk of insurance disputes out of court systems through these other alternatives. So that's what I'm trying to say. Policy framework would help. In Kenya, they also are trying to do that. But also, private sectors could also be encouraged to integrate ADR in their policies, in their plans, in their strategies. And another thing I would also say, if we are to make ADR useful, for these lawyers, I mean corporate persons who use lawyers, they should also, instead of considering to take a lawyer on the number of cases that he has won in courts, they should also evaluate on the numbers of ADR that he has facilitated. Maybe how many the cost-benefit evaluation of their works. How many disputes were you able to get resolved out of court? How many companies do you assist to avoid litigation? It could be another factor to simply make lawyers now start to love ADR and use it. But also,
Mr. Njuma, I'll ask you to.
Okay, thank you. I am just finishing. Training has also been mentioned. It's a matter of importance. There is need to allocate budgets. We don't allocate budgets for training to develop our people in ADR and all those specialized areas. But also, there is a need of having joint awareness strategies within and among institutions. It's also very important for the purpose of visibility. But another thing I strongly recommend is establish and implement ADR incentive schemes, or incentive both positive and negative. For example, in the High Court Commercial Division of Tanzania, a person is allowed for reimbursement for the cases that they have settled without going to full trial. They are allowed to be reimbursed part of the filing fee. It could be an incentive. But also somewhere else, the party who refuses to go for arbitration, or for ADR, he may be denied the cost in the court of law where, for instance, he has won. So it is acting as an exception to the general rule of cost follow the event. And it is being applied somewhere as a way to make sure people first go to ADR. So another thing, the opposite, put effective monitoring evaluation framework in place to monitor performance of ADR, but also embrace technology and integrate it in the legislation about ADR so as to make it work. Ladies and gentlemen, thank you for your attention.
Thank you. Thank you so much, Mr. Njuma. Let's appreciate him for keeping time. So I will start with Your Lordship, Mr. Justice David Wangutuse. I mean, we've heard some key terms that have come from the presentation: alternative dispute resolution, appropriate dispute resolution. We've had religious reference in the course of the presentation, you know, persuade your neighbor to settle the dispute as much as you can to avoid going to litigation. So maybe in the course of sharing your reviews, you know, your reactions to the presentation, you can also mention whether this is the attitude that you're seeing from the practitioners, in your view, from our courts, and even from the government in terms of putting policies to facilitate ADR. Judge, the floor is yours.
Thank you very much, Madam Moderator. I want to first of all thank the presenter for a paper that he must have spent sleepless nights on. I read the whole paper. What he has given us here is an abridged paper for purposes of meeting the time spans that we have here. So I want to thank him for that. My lords, justices, judges, and participants, we are three people here. I just think that in the 5 or 6 minutes that I have, I'll only tackle the historical deterrence. What is in history that deters or that would fight against ADR, that would fight against mediation, that would fight against arbitration? And that's why not only the domestic courts, but even the East African court is saying that people are not fully utilizing. They are not fully utilizing ADR. They are not fully utilizing the provisions of arbitration. And they are not fully utilizing those because they have not been created or they have not been trained to do them even at home. And the problem begins in the 1800s. The people who are coming here from out, supposedly to teach us religion, supposedly to teach us civilization, supposedly are actually looking for markets and sources of raw materials. On the 15th of November, 1884, to I think 25th to 12th of February 1885, we have the Berlin Conference. The Berlin Conference decides to chop and distribute this Africa into small pieces to each other. This is mine, I am Britain. This is mine, I am Germany. This is mine. The purpose was for economic purposes. The purposes were economic. We used to read in history, and whenever every alternate year, you would have the question, the flag follows the cross. Nobody was talking that the money follows these two things. But those two things were supposed to facilitate the economic development, not of Africa, but there. We have said in our research that if you have a country where the judicial system is not working, where the judicial system is slow, then you cannot harvest what you are looking for. The colonialists, therefore, after the Berlin Conference, bring their legal system. The legal system is not for us. The legal system is, if I invest in Africa, how quickly will I have my matters resolved? How will they be sorted out? That was the purpose. So they must bring a legal system that they understand. And by use of religion, we are told to obey, to agree. Anybody who disobeyed would not go to the other kingdom. And that's what happens, and we follow, and we believe, and we understand. And then they train us and teach us how to conduct those courts. Remember, before they come, we had mediation. Mediation is not new. It is not yesterday. Mediation has been here for long. And that's why the presenter has cited Matthew 5, verse 25, saying that even in religion, the people were told, settle your matter with your adversary before you go to the courts. Because the moment you reach the court and you are handed over to the judge, he will hand you over to the officer who will take you to prison. And that while also battling with your case, he goes on to verse 26, while you are still battling with your case, you will spend every shilling that you have. And that's what happens, by the way. If you go to court, you are going to spend. And if you are the loser, even the little you have will go away. And that's what Matthew, which he has referred to, is talking about. And the same thing is repeated in Luke 12, verse 58. The same thing. Deal with this matter before it goes too far. But while the religious people were showing us that, and if you go to the Sunnah reports are scholarly writings of the Muslim, you will find that Prophet Muhammad is also dealing with mediation. So this is not something we are just beginning last year or the other day because you went to the Strass and learned mediation at the university. It has been around, it has been interfered with. And therefore the training that we got in the law school was for purposes of preserving this position, that we must have adversarial proceedings, that the conventional court must have one person who makes a decision and it's final, unless it is overturned by the appellate court, which also tends to be final at some point. If you go to our universities now, and I agree with the presenter, it's the same thing. The training is how to file a plaint, how to defend, how to adjourn, how to strike out the proceedings by objections, technical matters, and so that's what we learn. Nobody is saying how to come together to agree on settling this matter outside court. The training is not there. And therefore, I agree with him when he says we need that type of training. We need our children and students who now go, because they're the ones who are going to come out and practice law, to know that, first of all, that litigation has finality. Secondly, that cheaper litigation is the best thing for people because it improves on access to justice. Confidentiality is one of the best things because then Madam does not discuss the potentiality of her husband in public, and so on. So it has a historical background. The advocate who comes out now has been taught to do exactly what we are doing. Do not accept to be defeated. Therefore, do not share the spoils. The advocate has also been told that an advocate must put on a suit, look smart, and move. So make money in whatever form you can. If it means having the same case in court for 30 years, that is your benefit. We have ego. So the people that over whom we administer justice have a bit different, have the same understanding as the colonialists wanted. They know that a case must have a judgment from a judicial officer. They know that. They no longer believe that a case can be settled from home, before an elder, before a mediator. They don't believe in that. So we must work towards changing that attitude. How do we go and change something that has been around for over a century? How do we get the people to believe that for you to continue business, you must settle your matters? Because it is the same people who also appear in the East African Court, the same people who appear in the Court of Appeal, the same people who appear in the Supreme Court, they speak the same language. I thank you very much.
Thank you. Thank you so much, Your Lordship, Mr. Justice David Wangutusi. We appreciate. So coming to you, Your Lordship, Mr. Justice Richard Mwongo, if you can just, take it up from where His Lordship has talked. We've talked about the fact that mediation has been there since time immemorial. We've been referred to the book of Luke, but we also have some other ADR, means reconciliation, resolving dispute before the Council of Elders, as it has been mentioned. But why is it seems to me that when we talk about ADR, most often than not, people think about arbitration and forget about the other means of ADR. Is it a truth or is it a myth that it seems that arbitration is having an upper hand when compared to these other means of ADR? And if so, what could have led to this? And if maybe possibly, Your Lordship, you can give us solutions on how to go about it. Thank you. You're welcome.
Well, thank you very much, moderator, and thank you very much, presenter and my Lord, for that discussion. Very interesting. I think you're talking about a paradigm shift. I observe all protocols. I think that was done by our moderator, so I hope I'm not being disrespectful to anyone. All protocols are observed. I will just start with, I have just, I think, 3 things that I am going to say. I'll talk about paradigm shift. I'll talk about the level of development of ADR, and I'll talk about some specific ADR challenges that I think I have seen in the statutes of the EACJ. With regard to the question that my Lord has raised about the history, where we are coming from and where we are at, and our reliance on law for the resolution of disputes, and particularly the adversarial process. I think what is helping us in Kenya is a paradigm shift that has been occasioned by the adoption of our Constitution 2010. There's an article there, Article 1592, which requires the judiciary to promote the principles of alternative dispute resolution in all its work. So literally, our judiciary is almost an activist, required to be, by the people of Kenya, required to be an activist body in fostering and promoting alternative dispute resolution. That is forcing a paradigm shift because in the thinking of Kenyans. Why do I say that? I think until 2010 and until the judiciary got very involved in that pursuit under Article 159, it was thought that the litigation process is perhaps the most important or the most well-used method of dispute resolution. Let me tell you now, it is not. And I will give you an example. Think for yourself. In the last 1 week, how many disputes have you been able to resolve yourself with people that you are in constant contact with, whether it's your wife, your children, your colleagues at work, your driver, your house people? How many disputes have you been able to resolve between yourself and them in the last 1 week? And I'm sure you can count at least 1 or 2. How many disputes equally have you been able to resolve through litigation? In fact, how many have you been involved in that require litigation? Probably none. In the world, I look at ADR like the sea of trouble. There's a sea of trouble. The sea of trouble has a river of justice to resolve that sea of trouble. Think of the sea with a river flowing from the sea inland. All right? It's backwards, I know, but just try it. It's flowing inland. The sea is where all the troubles and conflicts are. So the river is wider, the river of justice is wider at the sea compared to further inland. The further inland you go, the fewer disputes you are able to resolve. And the end of that river is litigation. Litigation actually caters for less than 5% of the world's disputes. And negotiation caters for the other, negotiation in its various forms, including the facilitated forms, caters for the other 95%. But this is anecdotal, it's not a research that has been conducted. But just think about it. This is why I asked you, how many disputes have you resolved? I'm always resolving disputes with my driver, because he wants to drive fast, he wants to drive into potholes, he wants to drive when there's mist without the lights on, and all sorts of things. So I stop him every once in a while and I tell him, my friend, there are two ways we can resolve this problem we have between the two of us. I can report you to your boss and you will be sanctioned, or I can start a case against you in court for the tort of assault. Those are possibilities. I choose negotiation because it is the easiest, it is the least costly. It involves just the two of us. There are no procedures. We can do it anytime, anywhere. That's negotiation. So when you're looking at ADR, the paradigm shift that we must all, including we at the court, the East African Court of Justice, but we in the countries of the community, we must see ADR as what is appropriate to the dispute. How do you resolve the dispute in the most appropriate manner? And most people want to resolve the dispute in a manner that is least costly, most effective, least time-consuming, and so on. And that's where negotiation comes in. So in that river of justice, negotiation will be right at the beginning of near the sea, where the broad number of disputes are resolved. And as you go deeper inland on the river of justice, you begin to resolve with other methods, traditional dispute resolution methods, customary dispute resolution methods, the churches, and so on, adjudication, arbitration, all the way to litigation is a small trickle. There's what I normally call a spectrum, and I think those who have done the courses in arbitration or in ADR will recall those. Negotiation in the X and Y axis is right at the beginning of the X and Y axis where they meet. And litigation is at the far end. And if you draw a line from litigation, which has a coerced result or outcome, compared to negotiation, which has a self-enforcing outcome, which creates a happy relationship between the parties, you will find that the line goes upwards towards absence of party autonomy for litigation, absence of flexibility, absence of speed and cost effectiveness, and so on. Whereas in negotiation, which is at the beginning, all those advantages will normally be there. And in between negotiation and litigation, you have all the other forms of dispute resolution, including the alternative justice system, which we are actively working on in our country. We have just recently produced a policy framework, which you are able to Google. It's in the judiciary website, our judiciary website, in which there's a whole discussion about how to mainstream traditional dispute resolution mechanisms as part of the judicial process in our country. We have already taken on board court-annexed mediation, so that cases that come to court can be screened for purposes of being referred to mediation. So I mean, I could talk about this all day, but I will not, because then I will lose our time, and we were told to try and be very circumspect with our time. Our court-annexed mediation processes have enabled us in our country to deal since 2017 with about 10,000 odd cases involving 48 billion shillings, of which those that have been resolved are in the region of about 12.9 billion. A lot of these are commercial and family. So that you can imagine all those matters which were in court that had this amount of money locked up has now been freed in the last 6 or so years. The average rate of of settlement for court-annexed mediation in our country is about 66 to 70 days. So that we have cases that were in the court, especially in the family cases, that were in the court for 10, 15 years that have been resolved in less than a day. Less than a day. I move to the EACJ. In your statutes, you have provision for arbitration, and I will not go into that. I think it was fairly well discussed earlier on. I agree that arbitration is a risky area for the judges to get engaged in. It's a risky area. For the reason that, for example, and it was pointed out, the ability to challenge the decision for purposes of setting aside on grounds such as corruption, failure to notify, and so on and so forth. Again, the outcome in your arbitral process, does it become a judgment? Does it have the same value and effect as a decision of the court? But even more problematic, I think, is the requirement for mediation. And I know it is well intended. There is a provision, I think, was it Rule 11 or somewhere there, of the arbitration rules or rules of procedure. I can't remember which is which. But there's a provision that enables settlement by mediation at the point where the judge who is holding the preliminary meeting or preliminary conference, he can engage in a mediation process. And in fact, there's at one place he has been called the judge mediator. I think you will have a problem. I think it is a dangerous line or a pursuit that we are taking, because you're talking about mediation, which is confidential, just like arbitration is confidential. You are talking about a judgment that you will offer with the I saw that there was a in the schedule, I think there's a place for a confidentiality agreement during the mediation. And here we are talking about the East African Court of Justice, and they are the judges engaged in this. I don't know whether they will have had the training and skills for mediation. And there are certain special skills in mediation. Some of you have been trained in them. There are certain skills of communication, of negotiation, and of bringing out the interests. Mediation is all about bringing out the interests and needs of the parties, not their rights and obligations in law. Because what you are resolving is the interests and needs that are embedded in the legal language of rights and obligations in the plaintiff that has been brought before you. And there's a whole world of difference in the two processes. And that is why in our mediation processes, in court-annexed mediation, it is very easy to unlock a 15-year-old family dispute in exactly one day. It's very possible. Because what the dispute is all about, at the end of the day, was about interests and needs rather than rights and obligations in law. So I thought I would just throw out those things so that we can have further discussion later on. Thank you, Madam Moderator.
Thank you. Thank you so much, Your Lordship. So we will go to our last panelist, Ms. Florida Kabasinga. So we have looked at the Kenyan experience and, of course, a couple of EAC countries that were mentioned on the EAC. And we talked about the attitude of the practitioners of the courts towards ADR. Maybe you can just share with us from the Rwandan perspective, and maybe there's some things which we can emulate and learn and implement in our various jurisdictions to improve on the use of ADR as a means of adjudication of disputes. Welcome.
Thank you, Faith. The main presenter said something that I really want to touch upon because I'm a private legal practitioner. I'm unfortunately not a judge. So I am going to talk about the issue raised on practitioners being averse to ADR. And I don't think that's really an accident. It is not. One of the interlocutors spoke about how most of these things and the way we practice them are foreign to us. So picture this, we had our own traditional ways of doing things, and then that got overtaken by litigation that is combative, and as people are getting really, really good at that, we are telling them to look at alternative dispute resolution. Yes, and not even the one that they knew about, but now a different form that has intricacies that the justice has spoken about that not everybody is conversant with. We are taught as lawyers to look at the interests of our clients. It is kind of anathema to what ADR is. So literally when you're practicing law in different areas, like contract law and all of that, you should have an understanding of ADR for you to be able to actually advise your clients to choose ADR over litigation. Most people don't. ADR so far is kind of looked at as an elitist kind of thing, and so lawyers who don't have that understanding are not going to be advising their clients to choose ADR as a form of dispute resolution. And then as a lawyer, when I look at what ADR is, especially if I'm not trained in ADR, and I'm told you go before an arbitral tribunal in arbitration, and that is the final decision. My client will not have recourse to any sort of appeal except for limited areas, which are literally sometimes really hard to get. So when I look at all of that, I am not going to advise my client to choose ADR. The issue of pretending that lawyers, while looking out for the interests of their clients, don't think about their own interests is kind of being in denial. The longer I'm going to have my client's case, the longer I'm going to be paid. So while looking at my client's interests, I am also going to look at my own interests. It is one level in arbitration. If I have a contract, I'm not going to put in there that, on appeal, I'll charge this. When we go to the Supreme Court, I'll charge this and all of that. So we need to factor in that these are real issues that lawyers look at and that we must take into account. Most people that have disputes, parties, they always want different outcomes and they have different interests. The issue of ADR being private, what do I gain out of it if I want to embarrass the other party? Why would I choose ADR if part of the reason why I'm going into dispute resolution is to make sure that I embarrassed you publicly? So we have to understand that sometimes people are looking at ADR in a different light and they don't choose it just because of the way it is structured. So we are looking at this in a very interesting way. So I keep wondering what comes first? Training people in ADR and making sure that everybody knows what it is so that we try to promote it, or putting it in the law and making it mandatory so that people try to understand it and use it by the force of law. So I think in Rwanda, for example, the government is extremely pro-ADR, and we have court-mandated mediation as well. And we have the Kigali International Arbitration Center that is doing a fantastic job in arbitration. But when you come to ADR, the same practitioners that are very good in litigation and before courts of law are the ones coming to represent people in ADR. And the nuances are completely different. So, and you find this across the entire region. It's not unique to one jurisdiction. So I have had people coming to me with cases, and because I am very passionate about ADR, I always advise them to mediate. But that means I am actually losing money as a lawyer, and I'm choosing to do it. And then guess what happens? The parties' legal representatives now start having interesting ideas. If the party that came to me first, I convinced them to do ADR, then the lawyer on the other side always says to the client, it's okay, choose for her to mediate, because then she won't be able to be the other party's lawyer. And so they actually come to me already made up their minds to frustrate the process. So these are the realities we are facing, and when we talk about solutions, we need to be mindful that these are the realities that we are dealing with. And when parties come to ADR processes, they always approach it in terms of litigation. Sometimes, because you have to compromise, you're mediating something, and the parties are close to coming to an understanding, and then one of the lawyers literally throws a spanner in the works, and then that's the end of the story. So while we talk about solutions, I think that's a good start to understand the challenges and why it is important for everybody to understand these complexities and be aware of them. Thank you.
Thank you so much, Ms. Kabasinga. So we will take a different approach in this session. So we know what ADR is, and we know the advantages of ADR. So what we have done in this panel, we have highlighted some of the challenges that we are facing in terms of ADR at the national and regional level. We have proposed some solutions from a panelist view, and what we'll want to do at this time is to open up a 15-minute discussion from the audience, just to share, enrich this discussion by letting us know some of the ways in which we can address the challenges that we have highlighted. So maybe we can have 3 this side and 3 that side for equality purposes. Yes, the first 3 hands that were up, please, whoever was with the mic. Yeah. There was 2 hands here at the front. I saw them first, please. His Lordship, Justice Nyochai, I think his hand was first up, please. The 2, yeah, then one at the back.
Thank you very much, Wakili. I just wanted to hear a little more from Ms. Florida on the issue of why, I know you addressed it, but I just wanted to hear a little more. Why is it really that lawyers resist ADR? Is the bottom line about them being paid? Why I'm asking this? Because when I've done mediation, there are lawyers sitting there. Therefore, I assume they're being paid. So what reasons do they have for resisting? And the reason I say resisting is I always get the impression that, and perhaps it's the beauty of mediation, because when parties get to speak to each other, they actually, more often than not, seem to make progress despite the lawyers. Because I can, even when I do it virtually, I can feel the impatience of the lawyers. They really want to go back to court. So I just feel that that's an issue. Perhaps you could say a little more, because you are a private practitioner who is passionate about, about ADR. Thank you.
Thank you, Your Lordship. If we can keep it short, kindly. I'm being reminded you have 2 more presentations after this. Okay. And you've been kindly requested
thank you
to
very
keep
much,
it short.
Moderator. My congratulations to the presenter. The historical dimension has been very deep. And even it is even deeper than that, because the Jews wrote their Bible during their captivity in Babylon. And so the Babylonians were the first people actually who started civilization. So those things are there. So arbitration, I mean, ADR has always been there in the history, right from the founding of the human society. So that is good. In your presentation, you mentioned, you have talked about political will as a problem. And the solution, in my view, is that it's rooted in public relation activity. Because we have to go around the parliament, these are the lawmakers, in order to make them aware of the essence and the usefulness, both in terms of time and in terms of resources, money. And also we have to go around the executive, because most of the government bills begin with the executive. So you start with the Minister of Justice or the Attorney General by making such seminars like the one we are doing here. And then from there you proceed to the parliament. Then also you go to Chamber of Commerce, this is the private sector, so that whenever they enter into a contract, ADR is given priority in the contract. Contracts are framed mostly by the lawyers. And then it comes again to the law school. In the law school, of course, it should feature out as a prominent topic to be taught in the law school. So now, as courts or as the judiciary, we are only recipients of law. We receive law which are made by the parliament and which in most of them originate in the executive. And so our role is limited, because at the very end you have a provision or an article saying that cause follow event. And so the judge or the tribunal will always restrict itself to that particular act. And so then that is where we need to do more power relation with the parliament, with the executive, and even with the public at large. Thank you very much.
Thank you, Your Lordship, for those 2 solutions. Maybe you can have 2 from this side, please. Yeah.
Thank you. My name is Remigio Achia. I'm a member of parliament of Uganda. I represent the people of Pian, the northern part of the country in Karamoja. How beautiful to hear from Justice Wanguzizi, who we know as a champion of the fight against corruption in this country. I always read these things, but I've not ever met him until today, over the last 20 years. And I'm happy to hear from Justice Wambogo about the Article 159.2 of integrating traditional justice systems, arbitration systems in the Kenyan law. How come in Uganda, despite the richness of traditional justice systems, the Matoputu in Asholi, the Akrikhet in Karamoja, that very little has been done to document this and ensure that they are part and parcel as the first instance of solving issues in Uganda particularly. In Karamoja, your matter is not solved until the elders have solved it. I give an example which was written in the Monitor a few weeks ago, last year. A boy was accidentally shot his cousin, killed him, he ran to police. He was sentenced by Faith Monda to 10 years in prison. Justice Faith Monda, when she was still working that side. After finishing his 10 years in Maluku prison in Bale, he went back home and he had to face the justice system there. And because he didn't have 6 takeouts to compensate the other clan, he got killed. It doesn't help until we recognize the traditional justice systems that are obtaining in many parts of East Africa. Why don't we pay attention to this? Because for us in Karamoja, Uganda's justice system, the formal one, is secondary. It's actually secondary. Probably it meets people in town. But all the other disputes and serious cases are solved using the elders' traditional justice systems, which are also found there. It's unfortunate I'm saying this because they ends up offering instant justice. Someone gets killed very quickly. Why don't we embrace this? It fits well in our African traditions of restoration, reconciliation, establishing peace between groups and families, and it's restorative.
Thank you. Thank you. We've heard you, the Honorable Member of Parliament, of the Ugandan Parliament. So we can have, there were two hands. The three, this side we finished. The people with the mic, kindly pass the mic on this side.
Thank you. Costs of ADR, especially arbitration. There's been a feeling of late that arbitration is becoming very expensive. To an extent, people are saying we'd rather remain in courts, where you get arbitrators charging $1,000 per hour. Not that I'll mind being paid that. But it seems like now, I met a lawyer who recently told me he's advising his lawyer, his clients, not to go for arbitration because of costs. Two, on mediation, just like Judge Nyachai raised, are lawyers now becoming facilitators of dispute settlements or inhibitors of dispute settlements? My first ever court annex mediation, we started at 2:30. By 5 p.m., they were signing a settlement. Why? Lawyers were not involved. These were parties. When I got the ones with the lawyers, others have even returned the files, that these ones they will never settle. But I also had one where I told the lawyers, you go out first, leave me with the parties alone. And within 15 minutes, they had agreed. So are you facilitators now? Lawyers become facilitators or inhibitors of dispute settlements?
Thank you, the former registrar. Two more for this side. There's a hand up there. Then we close. Two, then we have comments from the panel. If you can move the mics quickly.
Thank you very much. My land justices. Let me make it very clear. In Uganda, Article 1262D inculcates the use of ADR as a mechanism of solving disputes. This is a constitutional provision. As my sister Florida Masinga said, even some of the justices here in Uganda had a challenge. They were interpreting Article 139, which was saying that courts have unlimited jurisdiction over other matters. This was a conundrum that had to be set by Justice Chabwire, where he also interpreted that the 1262D was manifestant in promoting Article 28, on which is more about the right to fair hearing. Other provisions like Section 160 of the Magistrates Courts Act, we have seen also our judges being more liberal. In the case of Enela and another, recently we had the Kanyamunyu case, where the Kanyamunyu case is where one of the gentlemen murdered a person. And we saw using ADR, that gentleman was able to go to Acholi, where Mataput and Oputu tree was done. And instead of going to court for 20 years, he was only sentenced for only 5 years. So I was just highlighting the point of my member of parliament. It should also be noted that Rule 18 of the civil procedure also provides that a court can put court annex mediation. Section 88 and 89 of the Land Act provides customary mechanism.
Thank you. Please
of
wind
mediation.
up. Please wind up.
So, in summary, I think our courts in East Africa should adapt the latest development of ADR in Hustler against Hamilton 2022, where a failure to comply with mediation or ADR, you can suffer adverse effects. And lastly, all lawyers should know that we are now going under oil exploration. And oil exploration cases go to our international arbitration proceedings. If you want to be part of the market of making money, you should join immediately. And last, Gachacha in Rwanda. My sister Florida spoke about that we are moving forward into litigation. We should not go back. Remember, Gachacha courts were set.
Thank you for your comments.
Enhance that. Thank you.
Thank you. The last one, this side, for equality. Thank you, sir.
Thank you so much. On the side of legal defense lawyers, I think one of the solutions to promote ADRs is in the framework of training, of transforming how lawyers are trained. And I think that we should stress on transforming lawyers from wise litigators to leaders, to negotiators. And at this, in this regard, I would recommend to the Bar Association, in the framework of continued training of lawyers, to focus on the negotiation skills so that lawyers can be leaders, not litigators. Thank you.
Thank you so much. So thank you for the contribution. So there are 3 questions. So the first question, this Ms. Kabasinga, you'll address it. This is a question from the Honorable, from His Justice Judge Nyachae. Why do lawyers resist ADR?
I think, in fact, what the justice said is why are lawyers very impatient? And really, the bad news is they just want it to be done quickly so they can go to court. For it to fail, so they can go to court. It's as simple as that. And the reasons are varied. They don't understand, for the majority of them, they don't understand the usefulness of ADR. That's one. Secondly, if you see the structure of legal fees, not what the gentleman in the former registrar mentioned, that arbitration, for example, the fees are becoming very high. But when you look at the structure of lawyers' fees for ADR in some countries like mediation and all of that, they're much lower than the fees they get in other processes. And if mediation fails, I'm going to get from my client my fees for mediation and for the next level, which is the court level. So all of that is something that factors in. But the impatience, I kid you not, it's about give me something that says we have failed so I can go back to court, which is what they're used to. Lawyers have a lot of ego. Do we have room in mediation to actually show what we are made of, how much we can fight for our clients? It's all very lovey-dovey, it's not combative. We want to show how good we are. And it's all about the client's interests. And that's why when they meet just the clients without the lawyers, you succeed very quickly. But when lawyers get involved, they are still having the mentality of my client's rights and obligations and all of that. Why is she compromising when if she goes to litigation, she can get something better? So it's all of those factors, but the impatience truly is about, even when court-ordered mediation happens and they tell the parties to go, the first discussion that is had, how quickly can we fail this so we can go back to court and tell them that we failed? This is reality. That is the reason.
Thank you so much.
I think when you're trying to do mediation, you have to have that in the mind. If you can throw the lawyers out, and I'm so sorry, my other fellow lawyers, but if you can somehow figure out making the parties meet by themselves, it goes much faster.
Thank you so much. I think that's from the practitioner's view. Then Mr. Njuma, you can deal with the issue of cost. There's an issue of cost that was raised. The fact that arbitration costs have skyrocketed especially on international levels and even domestic level? Maybe you can just make a comment on that.
Okay. It is true, Honorable Kubo, that Your Worship, the arbitration costs are skyrocketing, and it's a matter of concern. But we can take that now in our institutions. We can take that experience and try to control our part of the in our practice. For example, most of the institutions, they have their own fee structures for institutional arbitrations. Problems of course are so much high when arbitrations are ad hoc and they are for private arbitrators who are appointed. So we would rather encourage that these institutions set fee structures that are affordable and amenable, so that we make these alternative dispute resolution accessible, because accessibility also is impinged by those levels of fees. People are thinking it's much better to get back to court. For example, the way I say it, in arbitration, you'll have to pay, for example, for the administration costs, you'll have to pay for institutional fees, but also you'll have to pay for the arbitrator himself. So I would say we would adopt ease method fee structures that are affordable. For example, the East African Court of Justice, where they say if you choose that as an arbitrator, or arbitral institution, you will not have to pay for the arbitration fee. The arbitrator's costs. So yes, costs are very high, but that should be a point of discussion where we start to look at how these institutions can cut down costs and maybe regulate. For example, in Tanzania, there is now the Arbitration Act, which is trying to regulate area of arbitration conduct and prescribing the fees and all those things. So I think those could assist.
Thank you so much. Maybe, my Lord Justice Richard Mungo, you can help us to address the question that was raised. Are lawyers facilitators, or do they hinder ADR? And then once you finish, we'll have last remarks from His Lordship, Mr. Justice David Wangutusi. He'll share with us his last words of wisdom for this panel. Thank you so much.
Thank you very much. The question whether lawyers are becoming inhibitors of mediation and sometimes even in arbitration, the answer I would say is yes and no. I'm a typical lawyer on the one hand and on the other hand. But some of the best mediators we have in Kenya currently are actually family lawyers. There are a couple of family lawyers who are really, really, really good mediators, good facilitators of the process. They engage very well. They even train mediators or other lawyers to be mediators. So to that extent, they are not a hindrance. They are a hindrance, and I think largely a hindrance, when they have not had the opportunity of training. You see, lawyers are taught, we are all, those of us who are lawyers, we are taught in the adversarial process. We are taught how to be gladiators. You use your sword to cut from the left or from the right, because your client could be on this side today, and the next day, you're acting for a client who is actually in a different case on the opposite spectrum. So lawyers are taught to cut from both sides. Our business is adversarial. We are about to fight. We are about to win. That's what we are trained in the adversarial process. Systems. I'm not talking so much about the systems where, continental systems where there may not be so much of an adversarial background. But in the common law area, we are taught adversarial processes. So it takes a while to remove that blinkard. I call it a blinkard because, you know, a horse, when you blink a horse, it's only able to look within the spectrum of the area where the blinkard doesn't cover. And that's how lawyers are. We cut depending on what our client is concerned with and what his case is about. Until we are taught, it's a new culture. We are uncomfortable. It's an area we are at sea completely. Can you imagine being put in a room? I was like that. Being put in a room where you're being told, think about the interests and the needs of this party. Interests and needs. We are here about law. That's what I was trained. The law of evidence. In arbitration, the law of evidence in Kenya doesn't apply, and I think in most countries. Even in adjudication in Kenya, we now have small claims courts. The law of evidence doesn't apply. It's completely foreign territory for us. It requires training. It requires a shift. That's why I talked about the paradigm shift. Because until we have that shift, we would not be able to be facilitators of any of the ADR processes. Yet, the ADR processes are resolving, whether you like it or not, they are resolving more disputes every single day than those that come to litigation. It's a fact. Think about the river of justice, as I explained it earlier. Think about the spectrum of ADR. It is only at the far end, where the law is stiff, where the law of evidence and the rules of procedure are stiff, and you must comply, and technicalities must be in place, that you can get justice. It's expensive compared to negotiation, mediation, and some of the facilitative methods of conciliation and adjudication. All those other processes are far more friendly and cost-effective. Thank you.
Thank you so much. My Lord, the floor is yours. You just wrap up the discussion and give us your words of wisdom. Thank you.
The deterrence, as she gave it by advocates, is actually well packaged. In Uganda here, because when they opened up for anybody to walk into law school, we saw people moving from very high offices going to read law. It has nothing to do with the administration of justice on their part. It has everything to do with opening up a farm and making money. And that's in a bit what she said. When you adjourn a case 20 times, she claims attendance 20 times. When you wrap it in one day, she claims attendance only once. The adjournments are the addition to the fees, because the fees normally are determined based on the subject matter from the very start. So really, these are the prices. How long, how many times does she attend? That is why you find counsel can adjourn a case 10 times, 20 times, when even if he had done it at once, he would be the one to he would be the one to win that case. So and that's a very serious matter. The other one of combustion is something that we have been taught. When you reach there, fight to the nails for your client. Even when you see there is no justice where you are going. Mediation at times has the problem of meeting people who have filed. About 10% of the cases are filed knowing very well they will never win, but they file. Now that one doesn't want a quick solution. About 10% of cases are filed and then they resort to the civil procedure rules and use them to delay the case forever. You go to the rules and get injunctions and then abandon the case at the injunction stage. So all of those are things that would not encourage things like mediation, would not encourage things like I think those are the things. And then, as I said, and I agree with my brother, we must untrain. We must untrain the thing that we have been put into. If you look at mediation and because if you're looking at justice as something for the people, if you're looking at something for the economic development of a country, then quick litigation or quick disposal of cases is key. If you are looking at them as for a person, a personal thing, that's quite different. But if you are looking at it, and that's what the East African community is talking about. It's talking about development. It's talking about improved lives for its people. It is discussing how do we put money in the citizens of the East African community. If it is talking that, then mediation is the answer. Because the majority of the people in this country cannot afford the cost and style of litigation that we now have in place. So when we live here, my thinking is that we must think in that direction. How do we undo what has been done to us 100 years? We go back to mediation, and yet the advocates will also remain happy. Apparently, every senior 5 and senior 6 lawyer, a student who has sat economics has talked of turnover as a source of money. When it comes to court and you tell them, we want you to handle as many cases by making them short and therefore create a turnover for money, they don't want it that way. Yet turnover of cases, if I'm going to finish 20 cases, I'll get more money than your one case you've been stuck with all your life. But the lawyer doesn't want to look at economics when he's practicing. He wants to look at economics when he's passing exams to go to university. So that is something that we should also address. Our colleges, our law development centers should also begin seriously in training in that direction. And beginning at the law center is late. We must begin at university. We must begin at much lower classes. I see in books of P2, P3, a wig and so on, and the children are supposed to say, this one decides cases. This one decides cases. We must also have in those books, cases can also be decided in this manner. So that by the time they go up to those classes, to university, to the law development center, to master's programs, it is something that is inculcated in them already, which we are not doing. Maybe because we don't know, or maybe because our curriculum has question marks and needs to be improved. I think that should be all.
Thank you. Thank you so much. Please help me to appreciate my panel. We have taken 1 hour, 20 minutes. I think that's a record time. They've really tried to do that. And I just want to apologize to those people that we are not able to take your questions. After this, I think you're going for lunch, so you can look for us and then we'll be able to address them. And maybe just as a closing remark, I think the message that you are getting is all of us have a role to play if we are to take ADR to the next level. We are stakeholders in our different capacities. In this regard, I think there's some homework for us, 3 points, just to see, then we can be able to review them as we continue with this discussion. Number 1, we've been told about the change of attitude towards ADR as practitioners, as the government in terms of policies and the laws, as the courts, etc. Number 2, I think what also came out clear is that ADR is a choice. You have this choice every day. At the lowest level, with the domestic employees, to the big contracts that we draft, the commercial lawyers in the room, the government representatives in the room, you know, the civil society and the NGO, been told that ADR is a choice. And number 3, which has also come up in the last conversation, is that awareness and training. This has to be a continuous exercise. I think maybe a good starting point, and I mean, this is a challenge to the institution, the ESCJ, is maybe the awareness on the arbitration jurisdiction of the ESCJ. I think it will address so many questions that were raised in the room and part of the discussion that came out of the many panels. If we are to understand the jurisdiction of the ESCJ, most of these concerns, I believe, will be addressed. Thank you so much for this opportunity, and I wish you bon appetit in your lunch. Thank you so much.
Thank you. Thank you very much. Let us appreciate our moderator.
Thank you.
Let us also appreciate our presenter. And lastly, all our panelists, thank you very much for doing justice. And of course, to ourselves, we are all participants. Thank you very much. You can resume your seats. We are going for lunch. In terms of time, we are not doing well, but I think we shall need a mediator in that and see how we will proceed in the afternoon. Lunch will be served in 2 points. We have lunch in Kazinga Hall, and another point will be in Choga. We shall read on our coupons. They give us directions on where we should be going, so please take time and look at your coupon and see where it is taking you. COVID tests are still going for the closing ceremony tomorrow, so if you have not been there, we request that you do visit the same place and do your test. For those who would like to change their substitute. Mr. Evans Ogada. Mr. Evans Ogada is a managing editor, the Platform for Law, Justice and Society. He holds a Master's of Law in Public International Law, Bachelor's of Law from the University of Nairobi, Postgraduate Diploma, Kenya School of Law. He holds a Diploma in French Language and Culture, Alliance and Franchise. He might be moderating also partly in French. He has been an adjunct lecturer at University of Nairobi, member of the Law Society of Kenya Public Interest Committee and Constitutional Judicial Review Backbench Committee. He has been a member of East African Law Society. He is an advocate of the High Court of Kenya, which he has been since 2017. He has had publications, one of them being public participation as a prerequisite in public appointments, the right to bail and bond under the Constitution of Kenya, the judiciary as a protector of human rights and the rule of law in times of pandemic. We have a pandemic in Uganda, so you are in the right place. He specializes in constitutional and administrative law litigation. We couldn't have a better substitute than Mr. Evans Ogada. You are most welcome to moderate this afternoon.
Thank you very much, sir. Ladies and gentlemen, good afternoon. Habari zenyu wanajumuiya Afrika Mashariki. Mko salama, eh? Thank you very much. Welcome the President of the East African Court of Justice, the Vice President of the East African Court of Justice, the Chief Justices present, the judges of the East African Court of Justice and all national courts, the Honorable Attorney General from Uganda, the Registrar of the East African Court of Justice, the Chief Registrar, Kenyan Judiciary, and all registrars present. Ladies and gentlemen, welcome. To those who are from the French-speaking nations, Honorable les juges honorables, Honorable juge en chef, le président du Cour suprême de Burundi, soyez les bienvenus, mesdames et messieurs, soyez les bienvenus. Bienvenue à cette séance. Je vous prie, me pardonner, on va continuer en anglais au fin de cette session parce que l'anglais, on va utiliser la langue anglaise comme la langue de cette session parce que est la langue plus répandue dans la région. I hope the French speakers have tried to understand what I've said. We'll switch to French to English because it's the most widely spoken in the region. So we commence with the business of the day. We will invite Professor Dr. Juan, or is it Juan, Barata Mir. Professor Mir is a fellow at Cyber Policy Center at the Stanford University. He specializes in freedom of expression, media, communication regulation, and intermediary liability issues. He has taught in various universities in the world. He is regularly involved in projects with international organizations such as UNESCO, the Council of Europe, the Organization of American States, and the Organization for Security and Cooperation in Europe. He was previously the Secretary General of the Audiovisual Council of Catalonia, that is in Spain. He has also published several articles and books in academia and popular press. He was also a member, he is a member or was a member of the Permanent Secretariat of the Mediterranean Network of Regulatory Authorities. He has a very thick CV that transcends a lot in terms of his achievements. Professor Mir, welcome. Let's hear from you.
So, good afternoon, everyone. Thank you very much. On behalf of UNESCO, it's a pleasure to be here, and we thank this invitation to speak this afternoon before you. I would like to stress the fact that I'm here representing UNESCO because, to my surprise, I saw that one of the sponsors of this event is a law firm that has a family name that coincides with my family name, another Barata, but I have to say that I have nothing to do with this Barata. I'm a different Barata, but we coincide here in this event. So here again representing UNESCO, as I said. Well, I'm going to make this initial presentation from a legal perspective, and I'm going to describe a little bit the different elements that need to be taken into account, particularly from the point of view of international human rights, and also from the point of view of regional human rights, that is the African Charter and the African Declaration adopted by the African Commission on Human and People's Rights, on how to understand freedom of expression online, and also how to understand the possible regulation of certain activities that take place on the internet. Again, the idea is to frame from a legal point of view the discussion that we may have this afternoon. So, if we move to the first slide, the first thing I wanted to, or the second slide in this case, the first thing I wanted to mention here is that we tend to make the mistake to see the internet as a medium, as a medium of communication like the radio and television. And as a matter of fact, we cannot talk about, let's say, radio, television, and the internet. The internet is far more than a medium. The internet is a technological platform where life takes place. Through the internet, we engage in economic activities, we receive financial services, we may receive healthcare services, we receive education, we engage in private correspondence, we have private calls via the internet, and also, of course, we can use the internet to disseminate ideas, opinions, and information. But that is only one component of the internet. We need to understand, again, that the internet is a reality that goes far beyond that. Therefore, in our modern democratic societies, in our connected digital societies, I would say that the internet has become a basic precondition for human dignity, for human existence, a basic precondition for the exercise of the most basic rights, freedom of expression, but also the freedom of association, freedom of religion, freedom to participate in public life, and also to have access to vital services. Again, banking services, educational services, etc. Healthcare now is provided also at least partially via the internet. So the internet has been a fundamental tool for the individual to basically live within a society. This is why internet shutdowns do not only affect the right to freedom of expression, but they also affect the exercise of a wide panoply of rights and the provision of an extensive amount of services. And this is why, from the point of view of international human rights, internet shutdowns have always considered to be a disproportionate measure, incompatible with international human rights law, that has an impact that is by all means unacceptable on the rights of individuals, even if there are a few bad things that we want to prevent when shutting down the internet. There are other ways, if they really want to deal with certain bad things taking place on the internet, there are other ways, less intrusive, more proportionate, more according to the rule of law, that can be done rather than shutting down the whole internet and therefore putting money, lives, freedoms at risk. The third idea that I think is very important is the fact that freedom of expression applies both offline and online. What can be said offline shall be said or can be said also online. And we shouldn't have a specific legal regime applicable to the online world. Because the online world is not different from the real world. It's only a part of the real world. And I'm saying this because we see a lot this tendency from certain states to create certain cybercrime, cybersecurity, computer safety laws that introduce new crimes, aggravated sanctions, aggravated penalties, describe new behaviors in order to prosecute or to persecute certain activities just because they take place online. Again, from the point of view of international human rights, this approach would not be acceptable because, again, what is legal online is legal offline and the other way around. That's another thing that I want to express. The other thing is that we should we should also have a horizontal view when it comes to media, and we need to apply what we can call a principle of technological neutrality. A newspaper is a newspaper, no matter if it's published on paper or it's accessible online. A radio station is a radio station. Doesn't matter if it's accessible online or we will listen to it through the airwaves, and so on. So having particular laws talking about something called online media, again, is an inconsistency, means not understanding, that the reality of the internet is not understood, and therefore these may possibly create excessive restrictions when it comes to the exercise of the right to freedom of expression online. Something that, of course, is new when it comes to the online world is the presence of intermediaries. The internet of nowadays is not like the internet of the past. In the past, the internet was a myriad of individuals trying to publish things, to have their own websites, and to be heard. Now, in order to be heard, in order to be seen, in order to be found, basically we count on intermediaries. These intermediaries, in many cases, are, or let's say the most important intermediaries for the purposes of this discussion, are these hosting services. Twitter, Facebook, YouTube. These are platforms, corporations. They are not media. They are intermediaries that facilitate the publication of content and the access of content by third parties. And there's a basic principle that can be found not only in universal human rights law, but also in the African standards, which is the idea of intermediary liability, or intermediary liability exemption, which means that intermediaries, in principle, are not liable for the third-party content that they post. This is a basic principle to protect freedom of expression, because if we said that Facebook is liable for the content that is posted by the users, then Facebook would actively remove everything that smells a little bit of illegal. So the effect in terms of indirect censorship on the net would be very important. This means, therefore, that basically what applies, when we look at the internet, we have, first of all, international human rights standards that, of course, apply to the internet. We also have laws and regulations that also apply to the internet. I mean, something that I always say, to persecute hate speech on the internet, you don't need to have a law on hate speech on the internet. You just need to use the provisions that you already have on hate speech in your legal system. And the same applies to harassment, threats. A threat is a threat. Doesn't matter if it takes place in the middle of a street, through an email, or through the internet. So then we have legislation that applies to the activities of the internet. But something interesting that challenges, in a way, the way we understand the rule of law, particularly in the online world, is that now these very powerful corporations, these intermediaries, have the power, the private power, to regulate speech online. That is to say, that when we are on the internet in Uganda, what we publish is not only subjected to general human rights law and the African standards on freedom of expression, is not only subjected to Ugandan law when it comes to content, it is also subjected to the rules, internal private rules, that Facebook has when it comes to content. so that we have 3 layers. 2 layers are public, so to speak, are official, but 1 layer is private. Facebook, for example, if you look into the definition that Facebook has of hate speech, it goes far beyond legislation. The definition that Facebook has of hate speech is much more broader to avoid having any problem with states. So things that perhaps you could say in Uganda on the basis of the legislation, you cannot say them on Facebook because Facebook has strict specific rules when it comes to speech that applies to every single country where Facebook is present. In terms, again, of rule of law, this means a significant change in the way we understand how speech is regulated, because now it's not only regulated by states, it's also regulated by private companies. So next slide, please. What are the challenges that perhaps are the most important challenges that now we are facing from a legal point of view? The first challenge is jurisdiction. When we talk about the internet, and also when we talk about radio and television, we had a good old principle, which is the principle of country of origin. The authorities that were competent, for example, if a radio station from Kenya can be heard in Uganda, I would say that the authorities that were competent were those of the country of origin, that is to say, Kenya. When it comes to platforms, then the question is, well, what kind of law we apply, for example, to a platform like Facebook? And in the, let's say, 10 years ago, I mean, the solution that was usually presented was, well, California, or, for example, in the case of Europe, Ireland, this is where, I mean, Facebook was established in Europe, for example. But now more and more states have started to adopt their own pieces of legislation targeting these kind of services in the respective countries. States more and more are addressing these companies, are sending injunctions to these companies when it comes to content that has been posted in a certain country. And companies have started also to break this idea of the country of origin, because companies have the tendency to listen to national authorities for one simple, very simple and basic reason, which is the fact that if they don't do so, they have the risk of being shut down, or have the risk that the personnel who's present in that country might be arrested. So, first thing, the idea of country of origin is at crisis. We cannot say that the internet is a space without borders, that companies are based in California, so that only Californian law is applicable. Internet is seriously fragmented, including from a legal point of view. And nowadays, every jurisdiction has its own rules that tries to apply to the internet, even no matter where the content is coming from. That's a clear tendency we see everywhere. Then also we have the big dilemma. Platforms are between 2 pressures. One pressure saying platforms shall do more, and the other saying platforms are censoring, are doing too much. Who says platforms shall do more? States. States say, you need to do more, because we have the limits of legality to control speech, but you don't have this limit. You also have your own internal rules, so you can enforce rules that we as states cannot enforce. For example, during the pandemic, everybody was happy with the fact that Facebook, YouTube, etc. were taking down videos of anti-vaxxers. Well, anti-vaxxers may be dangerous, etc., but in most of the world, being an anti-vaxxer is not illegal. And expressing ideas against vaccines is also part of the exercise of the right to freedom of expression. You may disagree or you may agree, but this is protected speech. Well, companies engage in the task of going beyond the law and taking down anti-vaxxer videos, anti-vaxxer posts, assuming a certain responsibility, going beyond legality. And states, the World Health Organization, everybody was happy, saying platforms are doing a lot. But also, of course, then you have the civil society organizations, activists saying, well, platforms are doing too much. Now I have a piece of speech that is, sounds a little bit controversial and has already been taken down. These platforms have too much power. So this is part, a little bit of an ongoing discussion. You may hear people saying platforms still need to do more, they need to go beyond legality, they need to prevent all the harms and all the vices that threaten us in this world, and others say platforms should refrain from doing these things. So here we see, this is where we find Elon Musk. Probably tomorrow we will know that Elon Musk is the new owner of Twitter. Yesterday evening, Elon Musk entered the premises of Twitter in San Francisco with a sink saying, "Let's sink in." And you can find that on the internet. What Elon Musk is saying is that I don't want Twitter to moderate content. I don't want Twitter to get rid of harmful speech. I don't care about harmful speech. Only if it's illegal, it will go down. If it's legal, no matter how harmful it is, it has to stay. This is an important debate that is now taking place. Should platforms deal with illegal speech only? Or also they should tackle what is lawful but awful? Because we say platforms are putting in danger our democracy. Well, I mean, then if we entrust platforms with the obligation to protect our democracy, then we are asking platforms to decide when something is fake news or not, when something is, let's say, harmful in terms for a democratic speech or not. I mean, we are asking platforms to go beyond an analysis of legality and do another type of analysis, including the risks for society, etc. That is a very complex assessment, I must say, particularly to be done by a private company. But this is the kind of discussion that we are having. Also, we need to take into account that platforms have to deal with a huge amount of content. You judges have to decide, for example, on an article that was published and someone decided that this was defamatory. And you may spend months discussing about that piece of content before you reach a discussion, let's say a decision. Platforms need to take this decision millions and millions of times per second. They need to judge, assess content against their own rules millions and millions of times per second. This means that they are using artificial intelligence to assess speech, not human intelligence. That's the only possible way they can do their work. Because if we want platforms to minimally control what happens on them, particularly when someone posts child pornography, terrorism, etc., we need to accept the use of these tools that would immediately take down a suspicious piece of content. But we also need to understand that artificial intelligence has limits. And therefore, this is why I believe it's very important for countries not only to regulate the internet or platforms or speech, but also to regulate the use of artificial intelligence to avoid an excessive impact on fundamental rights. And of course, then the final question here is whether we want states, or whether states may succumb to the temptation of delegating into platforms the adoption of decisions that have to do with legality or harm. We see more and more states adopting pieces of legislation saying platforms will have the obligation to assess risks. Platforms will have the obligation to detect cases of serious crime. How platforms will have the responsibility to detect fake news. But question again, and this is already related to things that I said, do we want to delegate this power on platforms? And if not, are there other ways this can be done? Because states seem worried, on the one hand, about what is happening on the internet and are adopting more and more laws to deal with the internet. But on the other hand, these laws basically are telling platforms, you do it. And if you don't do it properly, you will be liable. That's what we are seeing nowadays, which I believe is extremely problematic. I'd say delegating the judiciary function when it comes particularly to legality to platforms. And just a final remark for you, might be interesting to know that today the official journal of the European Union has published the famous Digital Services Act, which was very much expected not only in the European Union, but also in other parts of the world. And as a matter of fact, I have to say that when I travel to different countries, already I receive requests saying, tell us about the Digital Services Act, because maybe this is something we can also introduce. So far, for example, Nigeria adopted recently a code of conduct for platforms, apparently inspired on the Digital Services Act, but which was actually a horrible thing that only used certain language, but actually was a very restrictive piece of legislation. So sometimes also there's this tendency to say, no, no, this is the European way, when actually it is not. In any case, I think that the Digital Services Act beyond the European Union is interesting because it introduces obligations for platforms that had not been introduced in any piece of legislation before. For example, the obligation for platforms to provide a statement of reasons every time a piece of content has been taken down. The obligation for platforms to be transparent when it comes to the rules that they have, the content moderation policies that they apply, so that users know when something can be said, something cannot be said. To be transparent, for example, about the algorithms that they use. To provide also users with the possibility to appeal decisions taken by platforms. And even there's a provision, by the way of the previous discussion, that establishes for platforms the obligation to have alternative dispute resolution mechanisms. That is to say that when a user is not satisfied with the decision taken by a platform with regards to a piece of content, the user shall be able to go to an independent mechanism to decide whether this decision was correct or not. Before the DSA, Facebook already created this ADR system, internal ADR system. It's called the Oversight Board. Maybe you have heard of it. It's some sort of, Zuckerberg called it in a very emphatic way, the Supreme Court of Facebook. It's not, I wouldn't call it a Supreme Court, but it's a body made by former judges, former politicians, former experts in communication that decides on cases of content removal by Facebook when the user was not happy about it, and then they apply international human rights law to address whether the decision taken by Facebook or Instagram was correct or not. Well, this is perhaps an interesting experience, but with the DSA we will see in Europe the emergence of ADR mechanisms to deal precisely with matters related to speech on the internet, and particularly speech taken down from the internet. Well, in a nutshell, these are, I believe, the most important question marks. I didn't want to provide solutions, but basically to provide questions that, and the particular implications for the principle of the rule of law, that the emergence not only of the internet, of online speech, but also the emergence of intermediary platforms, the way they are operating now, the way these new actors are challenging the way we need to understand speech online, and also the way speech is regulated online. Happy to further discuss about these matters, because we are all learning at this stage. Thank you very much.
We certainly can do better. A warm round of applause for Professor Mir. Makofi ya Kiafrika Mashariki tafadhali. Applaudisse. Thank you very much. Now, we next move to our panelists. Allow me to introduce them briefly. We have Honorable Neema Lugangira. Mheshimiwa Lugangira is a member of parliament from Tanzania. She is the chairperson of the Africa Parliamentary Network on Internet Governance, World Bank and IMF Tanzanian chapter. She's a holder of MBA in Purchasing and Supply Chain, BSc Honors Business Management and Information Technology. She has a variety of certifications in nutrition and local content, certification in policy, analysis and advocacy, digital rights certifications as well. She's the head of policy. She was previously the head of policy, Southern Agricultural Growth Corridor of Tanzania, acting director, local content, National Economic Empowerment Council. She holds a lot in terms of digital rights and the digital space qualifications. Her CV is definitely available online. Makofi kwake. Next, we have an elder statesman, by all accounts, senior advocate from Tanzania, Mr. Generali Twaha Ulimwengu. Bwana Ulimwengu is the board co-chair and director, Center for Strategic Litigation. He holds an LLB honors degree from the University of Dar es Salaam. He's an advocate of the High Court in Tanzania. Previously, he was Member of Parliament for Tanzania, a district commissioner. He's a journalist, consultant for UNDP, UNECA, African Union, East Africa Community, and the ADB. He's also a member of the Tanganyika Law Society. Mheshimiwa Ulimwengu, thank you very much. Karibu. Our panelists are going to give us their reactions, and we request that we stick to 10 minutes, panelists. We will start with Mheshimiwa Ulimwengu. Please give us your reaction and your comments, then we...
Thank you very much. Good afternoon, ladies and gentlemen. Having been given only 10 minutes to respond, I will not go into the usages of protocol and pleasantries. I'll just go straight to the issue at hand. And I thank Professor Mir for his wholesome presentation. Really, it states everything that needs to be stated. And my job will be just to ask a few things, point out a few salient things that I think are important to be noted. And one of them is that the internet really does not create the world. It's not, well, it's called the World Wide Web, WWW, but it does not in any way create the world. It puts it in a web. It puts it in a presentation that is connected worldwide, allowing information to be collected and shared almost instantaneously at any given time by anybody who wants to access that information and use it for whatever purpose. And because of this, I think it can be compared to the saying of the ordinary person who talk about a kid in a candy store, because there's so much information that those who are really starved of information, who want to access information, who want to get news and content and documents and archival material, can do so with such ease that it's sometimes dizzying. It gives you a lot of pressure, psychological, if you really want to get information, and you can get so much information, and from one information feed, you get to another one, and then you get, eventually you find that you are digressing, because you keep on finding new leads, new openings, new platforms that are connected to what you are originally trying to research. So that you create this scenario of a kid in a candy store. Now, a kid in a candy store is really good if you're a kid. You know, you want to get as much candy and sweets as you can. But just imagine that the same kind of choice that you have, the kind of openings that you have, the kind of material that you can access is to a terrorist who is looking for ways to harm somebody or a section of society or a section of a country, and he has got all that information that is also in the internet. And he has very little control because there are very few gatekeepers, there is very little gatekeeping done. Nowadays, governments do try to impose gatekeeping mechanisms, but they're not being very successful. So the same kind of ease that you have if you're researching for information that will allow you to write your book on the legal implications for people with disabilities when they are injured by anything that you do, is the same kind of ease that somebody who is not necessarily a good member of society has when he wants to get to information that will allow him to do the harm that he wants to deliver to anybody's door. And you will know, you will have noticed that in many reality TV shows which show you how people were caught because there was a murder or a robbery or whatever, is that when they go to their computers and their servers, they discover that they have been surfing sites that show them how to kill a person, how to hide a poisonous substance in food, how to, whatever. However they want to do a crime, they can always find it on the internet. So there are so many downsides to the internet that I'm obliged to say that it is not necessarily always a good thing to have an internet on your side, because as much as it can do good, it can do a lot of harm. When in Jewish law, Moses went to the mount and came back with his famous tablets, they were really playing the same role that Stephen Jobs' tablets were playing many, many years later. What is important and what is different is that those tablets that Moses brought back to us on earth are different from what Steve Jobs brought to us, because Steve Jobs were faster. They still are much faster than Moses's, and yet they have not been able to convert as many people as the tablets of Moses were able to convert. So there is good and there is bad. What do we do now? What we want to do is to make sure that whatever information that we have, now we have a lot of information, it's fast, it's ubiquitous, it's everywhere. It can be shared instantaneously within one click of a mouse or your finger on your telephone. You communicate with the whole world literally at zero cost. There is some cost, but it's negligible largely. What you need to do is to make sure that network and the fast speed that you have and the ubiquitous nature and the wide range of the world that you can access in 1 second is undergirded, is guided by certain soft skills of humanity that we must inculcate in our society, especially in our young ones. It is very easy for young Kenyans, Ugandans, and Rwandans, and Burundians to access internet and go and find jobs in the Gulf. That is very possible. But it's also easy for them to lose themselves in the attractions of pornography and child sex and prostitution and corrupt practices all over the world. It's very, very accessible. But if you have made sure that your society is based on justice, on humanity, on polite company being enhanced, on good practices being lauded, on bad practices being called out, then you are going to be assured that the internet will hasten the development of your societies without necessarily killing the society it's trying to save. So I'm saying internet did not invent the world. The world was there. What Galileo Galilei was doing back then when he was playing with the telescope is the same thing that we are trying to do now. We do it faster now. We do it faster, and we can share with as many people as possible across the world. But the difference between a mechanistic approach to internet and the humanistic approach to internet is that you have to civilize the human being that accesses the internet first before he does harm to himself, and maybe creates engines that will destroy the whole of mankind unless we take action to stop that kind of eventuality. Thank you very much.
Thank you very much, Mr. Ulimwengu. We've had so far two diametrically opposite views on the internet. On one side, the pitch by Professor Mir was internet and the connectedness with human rights. From Mr. Ulimwengu, the internet is good, yes, but it has its challenges. Let's hear from the next speaker, the panelist, Honorable Neema Lugagira. Over to you.
Thank you very much. And President of East Africa Court of Justice, Vice President, Chief Justices, judges from the national courts, Your Excellency, Ambassador of Tanzania to Uganda, my fellow parliamentarians, I greet you all. Habarini za jioni. I must admit, excuse if my nerves get over me, it's the first time that I'm speaking in front of learned sisters and brothers, not just at advocate level, but at judges and the like. But allow me to start first to give a brief background of how I ended up being here. Back in May of this year, I had the opportunity to meet the Assistant Director General of UNESCO, Dr. Taufik Jelassi, at the UNESCO headquarters in Paris. And I had been, as a digital enthusiast and ICT advocate, I have seen in many countries UNESCO has different capacity building trainings for judges in the area of freedom of expression, the rule of law, etc. So I used the opportunity of meeting the ADG of UNESCO to ask him, is there a possibility for UNESCO to also do something similar for East Africa and for Tanzania? A few months later, in September, the session was organized for the East Africa Court of Justice and judges from Tanzania. And I recall seeing a tweet that ADG from UNESCO made, and the director at UNESCO, Madame Marielza, quoted that tweet and made reference to the engagement that I had with the ADG back in May, June. So on that note, I wish to sincerely thank the East Africa Court of Justice for recognizing my little input and giving me this opportunity to be part of this very important meeting. And subsequently, I thank the Right Honorable Speaker, Dr. Tulia Ackson, for permitting me to come whilst at the moment where we are during parliamentary committee sessions. Having said that, allow me to start by quoting UNHCR. This is the resolution that they made in 2012, which says, same rights that people have offline must also be protected online. And in my personal understanding, this means that the right of freedom of expression holds two sides. There's a negative and a positive, exactly like what General Ulimwengu was saying and the professor. Now, it is without a doubt that the internet has become a very powerful democratizing force that transforms freedom of expression across all of its core rationales. And it has changed the way in which we receive information, we seek information, we digest information, and even impact on that information. However, I personally see two main challenges when we're talking about the issue of freedom of expression. One is that traditional media, over time, has merged with digital media. And this puts at risk communities from peripheral regions. In Tanzania, I come from Kagera, region close to Uganda. Now, if we don't make strategic efforts to also digitalize our rural media, to ensure that there are digital skills for rural communities, then there's going to be a challenge for them getting access to information, but at the same time having the ability of themselves also using freedom of expression through the internet. The second item is the overarching challenges of freedom of expression. And this is jurisdictional, because the internet is a global medium and doesn't necessarily follow national boundaries. And this is where yourselves as leaders in our court systems. Now, it's understandable that over the years, I think in the last 2 decades, the internet has probably been the only sector that has developed without having the right policy and legislation framework in place. So this is a fact. And over time, it has progressed faster than the way in which we have been putting policies and legislation in place. But right now, the whole world has recognized the need to govern the sector. Hence, we were just told by Professor, just today the EU passed the DSA, something which shows that even the EU, the US, all of them are trying to catch up with this internet development. And by recognizing that, we also have to appreciate the fact, even ourselves as African countries, we too also need to ensure we have the right policy and legislative processes in place. And I'm particularly saying this because oftentimes when we talk about freedom of expression, we only look at one side of the coin and not the other side of the coin. And what do I mean by this? One should not use their freedom of expression to make another person not use their own freedom of expression. And this is very, very common. And here I'm talking about online abuse. And I'm particularly grateful to the African Union Commission for Human Rights and People's Rights, because just this year, July, August of 2022, they recognized digital violence as an issue, as a human rights issue. But although Professor was saying we do not need laws or targeted national laws in place, but in all honesty, hate speech, online abuse are issues that tend to force others to self-censor. And when you force others to self-censor, it automatically means that you're inhibiting others to use their own freedom of expression. And for that, we as Africans, as African governments, it's also important to start looking holistically on what can be done to ensure that we have an enabling policy and legislative framework, yes, to be conducive for freedom of expression to take place, but at the same time, freedom of expression must be taken for all groups. I'll just quickly give an example. I'm a female parliamentarian, and in Tanzania, we have about 143, 146 female MPs. Out of us, the ones who are actively online are less than 10%. Less than 10%. Why? Because of the magnitude of online abuse that is subjected to women in politics. It is horrific being in my shoes. But when we go to the legal framework, even though most of our countries have cyber crimes acts, if you try and find where can I place this online abuse that I'm getting, it's not possible. It's not clear. I'm pleased that Prof made reference to Elon Musk issue when he was trying to buy Twitter. But he forgot one important component. One of the things that led Elon Musk to push back was that he said a large percentage of Twitter users are unknown, unverifiable, are fake. Well, fake, unknown, okay. As I said earlier, I put a caveat. I'm not a lawyer, so excuse me where I make mistakes here and there, but the bottom line is, one of the biggest issues that led Elon Musk to take a shift was that he said the value of Twitter may not be the true value because a large percentage of their users are fake, are bots. So he wanted Twitter to have a mechanism of making sure that all users can be proven that they're human beings. Now, on the other side, it comes an issue of freedom of expression. One should be able to express without being known who they are. Then on the other side, there's the issue of abuse, online abuse. So these are critical things that yourselves as the people of justice, we need to collectively discuss and see how can we find an avenue. Because from morning here, even the morning discussions, we're talking about cross-border trade, women traders, gender rights and things like that. But if you have a group of women in politics who are supposed to be advocating for those groups and not online because of the sheer magnitude of some people, a group of people strategically using the excuse of freedom of abuse, using the excuse of freedom of expression to instill online gender-based violence targeted, then we have an issue. And I believe that is not the true essence of freedom of expression. Now, to conclude, myself as a parliamentarian, I came to realize that oftentimes discussions that are linked to digital, ICT development, parliamentarians are left aside, particularly African parliamentarians. When you go at the global north, they'll be discussing issues related to Africa, making legislations at that level and expecting that Africa should adopt similar. But as parliamentarians, we're not part of the discussion. Therefore, our capacity as parliamentarians is not at par. And the risk of that is we will pass legislation that perhaps has missing gaps, giving you in the judiciary an extra work of not knowing how to implement those legislations because of the gaps. So this led me to, earlier this year in January, to embark on the initiative to start up the picture. For 4 days was trolled all over online to show that this is a type of work that our women parliamentarians are sent to do in Dodoma. The abuse was horrific. The details, the gravity, all kinds of things. And to the point that my kids were telling me, Mom, is this what it is to be an MP? Because the trolling was even going to them. But there was a parliamentarian, looked through the entire Cyber Act. There is nowhere that recognizes this issue. Looked at the Political Parties Act, looked at the National Election Act, Political Parties Act, National Election Act doesn't recognize online abuse because the time it was being drafted, this issue of online was not there. So we cannot say that there is no need. There is a need. And if it's something that is discussed to the level of the UN Human Rights Council, let us not dilute it. But what is important is to find the right balance. Thank you.
Monsieur le modérateur, puisque j'ai constaté que vous êtes francophone, je vais aussi m'adresser aux francophones qui sont dans la salle. Tout ça me rappelle d'une citation attribuée à un philosophe français bien connu, Voltaire. Il a un nom très long, mais simplement Voltaire, qui a dit ceci, le suivant. Monsieur, je suis complètement opposé à ce que vous dites là où vous êtes. Je suis complètement opposé à ce que vous dites. Mais je suis prêt à donner ma vie dans la défense de votre droit de dire ce que vous êtes en train de dire. Simply, in English, in that other language that is not so sophisticated, it says this. Voltaire, the French philosopher, once said, Mister, I am totally opposed to what you are saying, but I'm prepared to give my life in defense of your right to say it. That is the cultural level that we need to have before we can trust the internet completely. And the internet is run by ourselves. People who are liars, people who are dishonest, people who are thieves, brigands, really. And you want now the brigands that are already stealing from us to also create the rules that are going to govern the processes that they are in the habit of using to steal from us. That's why I say, let us raise the cultural levels of our people. Let our people, first of all, be literate, at least be able to read simple messages and comprehend them. Let them be able to receive simple messages of how people live and how people act in different corners of the country, of the society, and of the world. Civilize your people before you give them weapons of mass destruction like the internet. Because there is one day, I always see this possibility, this frightening possibility, where all accounts of the world can be hacked. And some evil spirit somewhere, some evil genius, gives instructions to the whole world to act according to what he or she, could be a she, couldn't she, wants them to do. Can you imagine what damage it will cause to the world? It will be the Armageddon, the end of the world, because these are instruments which are very powerful, but they're in the hands in people who we cannot be sure of their intentions. So I'm saying, with the internet, I get worried. I get worried when I see young people running around with smartphones, very expensive smartphones. One thing I ask myself, how did that college boy or girl afford a phone that costs 3 million shillings Tanzanian? How? Maybe it's a boyfriend who bought that, some sugar daddy or something. Maybe she's a thief. And how does she use it? Gossip. Gossip and character assassination of other people. Why wouldn't such a person, if they stood to gain financial gain, involve themselves in serious crime that gives them financial advantage? The only cure that you can have and you can rely upon is that the cultural level, the civilization, the levels of civilization, of the humanity, of the empathy in your society has been raised. But it can't be raised by these governments that are always interested in keeping people in check, not listening to what people are saying, making sure that the people don't know what they are doing, who rely on opacity rather than transparency to transact government business. It has to come from the people themselves, and the people have to oblige governments to behave like civilized groups of people. Otherwise, we are doomed. There is a day when the internet will be used against humanity.
Thank you very much. Voltaire, philosophy. You've had the most beautiful language in the world, so I hear French. What else will you need from this panel? Swahili. Thank you. Spanish, hola. A hand of applause to the panelists, to Professor Mir. Now, we are going to take questions. Due to hierarchy on this side, we are going to start on this side. Please raise your hands. After this side, we will move to this side. My brothers with the microphones, Kipchoge Keino, speed, alacrity. We start with the behind, yes? Thank you.
Yeah, thank you very much. I think I benefited from being your neighbor. Thank you very much. I'm Tio Milton, Director of Prisons, Uganda Prison Service. And first of all, I want to thank the presenter, the moderator, and the panelists. You have done a good job, but you have also made me confused. Because I've got the pros and cons of use of internet. I just have, the two panelists have really dwelt a lot, basically on my side. Thank you very much. This first question goes to the presenter. I'm wondering when they are coming with this law or provision in terms of human rights, did they think of a group of people whose rights must deliberately be controlled or regulated in order to keep peace or security? You know where I'm coming from. I just needed a comment from there. In relation to, for example, I have 73,000 plus inmates. Imagine a situation where we say freedom of information, freedom of speech applies to every human being, includes the people I keep. You can imagine what can happen. Mr. Olimwengu hinted on that. Imagine you have inmates, they have access to internet, pornography, whatever information, prison break. Just you think about it, what can happen? Will I be in charge? When you give a small time for inmates to watch TV, just the mere TV, where they watch some erotic dances on the screen, 2-3 minutes, these guys will never sleep. That one alone, it will make them not to sleep. I think you get what I'm saying. Now, just to the panelists, I believe we are here, we are for this conference. I'm not going to be quoted and in parliament. I don't know whether this topic was given by Ugandans. I don't know. Just the last, I think early this month, the president ascended to a bill on abuse of computer misuse. Bill was accepted by the president just this month. But the public out there, I'm part of public, I also read things. They are saying, look here, this move is deliberate. And I'm happy my bosses, my MPs are here in the room. The public is saying, the parliamentarians, they made sure this bill is passed because of two things. One, they are avoiding accountability. The public have sent them in parliament, their representatives, to the wananchi. They don't want accountability. Because it is through the internet, through Facebook, through Twitter, that their deals can be exposed. Two, corruption. Because if you're going to say that so and so is this, that's this, you'll be in trouble. So the public is saying, this bill purely is to protect the politicians, to be specific, the MPs. What is the comment from the two panelists? Thank you very much.
Thank you so much, Chair, and the panelists. My name is Ekudo Tom Julius, Member of Parliament, Uganda. I am happy to listen to the conversation, and when my brother said the misuse, Computer Misuse Act was brought in by the Parliament of Uganda simply to protect maybe the politicians, I think that is out. Because if an act has been put in place, even if you're a politician and you have misused the computer, internet, you will still be accountable. This does not avoid anybody to account to his or her community, never. And this, if you are exposed in the internet, that so and so is a corrupt official. Yesterday, I said it, if you marked it well, I said it, the state sometimes protects the corrupt people. Now when you say it has been passed because we want to protect the politicians, no, this is out. For me, what I was saying is that, yes, as parliamentarians, we have passed this act. Reason being, we want to control the use of internet. If we left it like that, even the justice will get confused. This one has been put in place in order to control, so that even the justice will have where to pass, what to do. Yes, the enforcers will also have what to be done.
Thank you.
Yes.
Do you have a question?
And I remain a legislator for
Thank you very much. Short and sweet. Short and sweet. Do you have a question from here? We have two hands. I see Judge behind with his hand raised. also saw a lady here. We finish with the judge, we go to the lady there, then we go to Professor Milesh here. Yes.
Thank you. I'm Justice James Alala from South Sudan. You see, I'm not seeing that there is disagreement. In actual fact, the issues related to freedom of expressions is not absolute. It is even limited by the international human rights declarations. And also, at the national constitutions, you find the freedom of expression is given, but also is limited, all right? Which means that it is regulated, all right? Now, I'm saying there is no disagreement that any act that is constituting a crime is regulated and prohibited by the law. Now, for example, we talked about the hate speech, all right? It is regulated and prohibited in the penal code. Now, the first opinion is saying there is no need for a specific, you see, law for the internet. Since the crimes that are committed on the internet are there in the penal code. That is his argument. The other side is saying, no, let's have a specific, all right, law that is regulating what is going on or the crime that are committed on the internet. The question, what are those crimes that are committed either in natural world or on the internet? The same, you go to the defamation, you find it in the penal code, all right? And it is that defamation that also can be, all right, you know, termed as a crime using internet, you see? So you see, there is no new crimes. You have previous crimes that have been there, regulated under the penal code. And also, if you want to duplicate or repeat what is there, that is another thing.
Okay.
So, in my opinion, I'm saying the freedom of expression has its limits.
Thank you very much.
It is regulated by the law.
Thank
and
you.
you are not allowed to go and encroach into other privacy and other private life of other people.
Thank you
You
very
are
much.
not allowed by law. Thank you.
Thank you very much, Judge. Thank you, Judge. I saw a hand here. Please, brevity, precise. Comment or question, precise.
Thank you very much. I'm Dr. Caroline Asimwe from the East African Kiswahili Commission. My issue is to do with the internet, of course, digitalization that comes with digital surveillance. With global geopolitical connections, definitely we know that digital surveillance is also a feature of something that can come up with a closing civic space. What do you say about that when it comes to the legal sector? And then you're talking about human rights. The second issue is on what happens in our society with our structural inequalities. Who determines what is acceptable in the digital place and what is not acceptable? Asanteni sana.
Thank you very much. Fantastic. We are doing well. Prof?
Thank you very much. So as much as, it's more of a comment, yeah? As much as freedom of expression has its limits, it is absolutely crucial for democracy, even for the sovereignty of the people. And this is what the East African Court of Justice also acknowledged in the Burundi Journalists Union's case. Yeah? So democracy is not only about throwing ballot papers into the boxes, it's about debate, yeah? It's about arguing things out. So this is, freedom of expression is the instrument which the people use to formulate their opinion and to express it and to exercise its sovereignty. And now if you look at those cybercrimes legislation, we would realize that it actually criminalizes much more than the penal codes usually did. Let me read you out one very short provision. It is section 23 of the Tanzanian Cybercrimes Act of 2015. A person shall not initiate or send any electronic communication using a computer system to another person with intent to coerce, intimidate, harass, or cause emotional distress. So if my wife writes me an email telling me that she doesn't love me anymore, she causes emotional distress. And it is not punishable under the defamation laws, under the Penal Code of Tanzania. And now if you look, how come that, my Honorable Madam Nema, I'm very sorry for cyberbullying you experienced. Yeah, I know it is totally terrible. I know how it feels. However, how come that Tanzanian authorities were not in a position to pinpoint that provision to assist you? And yet they were so quick to find that provision, to cite it when a Tanzanian comedian was laughing at a picture of President Magufuli, who himself was very good at publicly humiliating female civil servants. We also remember that video. How come? And this is, I think, my opinion in this debate. Actually, this cybercrimes legislation, the way it was adopted and the way it is used, we also must look at the normative political context of this legislation. It is not to protect the powerless. It is not to promote digital inclusion of female parliamentarians. Because when it comes to digital exclusion and bullying, the authorities remain passive. They don't assist. Okay. But it is used as an instrument of oppression, as empowerment of those who are already in power.
Thank you. Thank you very much. We will respond to the questions as posed. The first question was posed by Director Tayo, my neighbor behind. When these laws were created, and the human rights argument, what's the space for regulation of peace and security? Prof?
Well, I mean, I think that as a public servant, probably you know that human rights also incorporate limits, and one of the limits to freedom of expression is national security. And this is clearly established in Article 19 of the International Covenant on Civil and Political Rights, and also you can find it in African standards. Applying, of course, the test of necessity and proportionality. Not every single limit is possible, but all the limits that are necessary and proportionate to protect national security can be established according to international human rights law. We need to have a proper understanding of what international human rights law says. The other thing is that according to national legislation, also, when it comes to prisons, states have a margin of appreciation to establish all the necessary measures to guarantee that within the prison system things work properly. And of course, a prison is not the same as the rest of the world. Some specific provisions have to be included with regards to the conduct that needs to be respected, and also, let's say, there's the responsibility of those who are in charge to apply proportionate measures to make sure that national security is properly preserved. So we are not here, I mean, discovering anything new in this sense, no? Of course, human rights are the rule, restrictions are the exception. We need to understand that, and they have to be limited and proportionate. But are they possible? Of course they are.
Thank you. We have exactly 6 minutes. Let's try using the time remaining to respond to the next few questions. The panelists had specific questions from Director Tayo, computer misuse, corruption, and accountability. I think that was responded to by the Member of Parliament from Uganda. We have specific questions to Honorable Nema? Probably.
Thank you. I'll start with the last speaker. First of all, let me make myself very clear. Nowhere in my statement did I say that the authorities did not help me. So let me make that very clear. I myself did not go to the authorities. And the reason I did not go to the authorities was all of the people who were doing the online abuse were fake accounts. So how then do you determine who is the person? So that's the reality, and those are the loopholes in the system. Now, with regards to your other part of the question, culturally, when someone has passed, we respect the person of past, and may our former president rest in eternal peace. Now, just to further cement on that issue, as I said earlier, we all understand and appreciate the importance of freedom of expression. I myself, as a parliamentarian, greatly benefit from engaging with different persons online. However, when we talk of freedom of expression, we must also remember there are two sides. You should not use your freedom of expression to make me not use my own freedom of expression. And here I go back to the quote that I started with. The UNHCR resolution in 2012, it said, same rights that people have offline must be protected online. If you're not able to abuse me offline, you should not be able to abuse me online. And to conclude, all of these things that we're saying here, there is a gap in how the internet is conducive for all of us to be online. If more parliamentarians are online, more parliamentarians engage online, we would be better equipped and better understanding in these issues, and therefore we would be better placed on how best to deal with these scenarios. And a natural reaction for me as a person who endures day in, day out online abuse would be to have the most stringent legislation to protect myself. But because I am empowered with the understanding, I know that is not the solution, because I too benefit by being online. By being online, it is easier for me to reach a wider audience of people who naturally I would not reach. Therefore, we need to work together to make sure more African parliamentarians are online, more women in politics are online, and us as legislators work closely together with judiciary, and it should not be an issue of pointing fingers, you versus them, because I may also ask you guys very well a question. You said that you understand what I go through online abuse. Trust me, you do not understand because you're of the opposite gender. You do not understand. And going back to our cultural context, for a female parliamentarian or a woman in politics to be pegged that you're doing prostitution, selling yourself, is in no way something that you can understand and comprehend. Thank you.
Thank you very much. We've concluded with the elder statesman, Monsieur Generali.
I thank you most sincerely. And I think the ambassador has something to say. I might have to say.
There's an interjection. I'm told the Honorable, His Excellency, the Ambassador from Tanzania has something to say.
Thank you very much. Thank you, moderator. Mine is just a small comment. I think most of the discussion here has been based on the Google land. Because when you talk about the web or the internet, where most of these cybercrime acts are formulated around the world, including here in Africa and the developed world, there are two types of webs. There is a Google land, which we've been discussing here, but also there is a deep web, where a lot of crimes are taking place. And in the deep web, that's where you have all the drug traffickers conspiring up against everybody else. But also you have the terrorists, and you have the people with the, the child pornography, and all these sort of things. That's why states around the world, they are legislating about, regarding these cybersecurity acts. And some of us, I think most of the arguments we have been basing on the issue of, what we see on the social media, the Google land. And if my brother, the gentleman who mentioned my late president, if he considered the deep web, his comment was out of place. I thank you.
Thank you, Your Excellency. We conclude with Honorable Ulimwengu.
I thank you very much, moderator. I sympathize with my very young colleague here, because it's true. Tanzanians and Africans generally, not only Africans, but humanity can be very unfair, very unjust, unfeeling, and cruel. So what happened to her was a very cruel thing, for which I think we all have the duty to sympathize and empathize with her. But also it is true that once you have built a society, or you have tolerated a society to be built that lacks empathy, sympathy, solidarity, justice, and consideration, when that same society comes back to bite you with that venomous and brutal force, you have no right to complain. I'm sorry to say that Magufuli did not show very much empathy with people who suffered. And I can count. We should not be discussing this with my ambassador here, because we have ample time to discuss that. But suffice it to say that Tanzania, under the departed president, became a very cruel and brutal society. Look, we have a member of parliament, your colleague, at least even if you're divided by time, you're separated by time, who was gunned down in government facilities at 13 hours in the afternoon, and was left there for dead. And the government, the whole government structure, contrived to make sure that he doesn't get medical attention, until some good Samaritans moved his body to, not body now, he still lived in Nairobi, and then from there to Brussels. A member of the opposition who disappeared, never to be seen till today. People, a pressman, a colleague of mine therefore, because I'm basically from the press, who was disappeared by apparently state agents, never to be seen again, whose little baby child was born while he had disappeared. We were hoping at the time that he was still alive somewhere, only to be told later by a minister of the government to say, well, he may have died. He won't be the first person to have died. That unfeeling that Magufuli fostered among Tanzanians and among Tanzania, especially official Tanzanian persons, cannot be left simply because he passed on. Otherwise, we'd be speaking very well of Hitler or of Idi Amin here in Kampala. So I hold it as a principle that if you want us to treat you with respect when you die, treat us with kindness before you do. Thank you very much.
Thank you very much. A round of applause. Merci beaucoup. We have come to the conclusion. Very heated, very robust, very personal, very emotional arguments. At the end of it, democracy. What is meant by democracy? A Greek contraption meaning demos, the people, kratos, have to have their say. The people have to have their say. In having their say, definitely, some escape the boundaries of civility and the law. How do we calibrate the benefits of democracy as we try to reconcile with the madness that pervades each of our societies? That's the challenge we take forward from this discussion. Thank you very much. Hope to see you in the next session.
Thank you very much. Let's give another round of applause for the panelists. Thank you. We shall be going into another presentation, which is our last one. And this will be on judicial resource limitations, its effect on judicial efficiency, what can we do as courts. Welcome the moderator of this session, who is Honorable Justice Charles Nyachei. Honorable, you are most welcome. Let us welcome him. Closely following him is Honorable Justice John Udziki-Tlima, who is the presenter this afternoon. Our panelists, Her Worship Sararanga, Chief Registrar, the Judiciary Uganda, you are most welcome. Take your seat. Honorable Christine Mutimura, Honorable Christine Mutimura, the Deputy Registrar, East African Court of Justice, you are welcome. Take your seat. Honorable Anne Amandi, the Chief Registrar, Courts of Judicature Kenya, Honorable Justice Dancy Nshimiana, you are welcome. Take your seat. Lastly but not least, Honorable Dr. Robert Eno. It is one of the biggest panel we have had, and I want to say to them that you are the last people this evening, and I will give you a story of one pastor who was preaching in the church and took too long, and all the congregants left the church, and he continued talking, and one person came back and he said, "You are so blessed to be the last person here." And the person told the pastor, "I only came to pick my mat where you are standing. I thought you had left it and I would pick it. So if you remain on the mat very long, the last person will come for it." So it is a great afternoon. I hand over to our moderator this afternoon. You are welcome, my Lord. The moderator is Honorable Justice Charles Nyachei, who is a judge at the East African Court of Justice, the First Instance Division. He holds Masters of Law from the University of London, Bachelor of Laws, University of East Anglia, Norwich, England, Bachelor of Arts, University of Stirling, Scotland. He is a founder partner of Nachai and Aspiva Advocates. He has been a chairperson of the implementation of the Constitution of Kenya. He has been a commissioner, Kenya Law Reform, chairperson, Institute of Education in Democracy, chairperson, International Commission of Jurists, Kenya section, council member of Law Society of Kenya, and the State Council Attorney General's Chambers in Nairobi. You are welcome, our moderator this afternoon.
Thank you very much. Before you take your seat, Your Worship, how long do we have exactly?
I told you the story of the pastor. You have to monitor your audience, but
you see, we are monitoring our audience at the tail end of the day. If we had monitored our audience from the earlier in the day, we wouldn't be in this problem. So now we've got to decide how long do we have.
Let's take it up to, you can stretch it up to 6:30.
How long is that in terms of time?
That's too long.
It's 10 minutes, 11 minutes past 5, according to my watch. So,
can we say 1 hour? Because
1 hour?
yeah, because from the responses when you mentioned 6:30, we will definitely end up like
So let's aim
like
at
that.
finishing by 6:10.
Okay.
Okay. You are the driver, so I hand over the plane to you.
Thank you, thank you, thank you very much, Your Worship. Now, the reason that we are in this conference is to have a conversation on access to justice for East Africans, and access to justice means that the people of East Africa are able to approach the various courts, both at the national judiciaries and the regional court, and that those courts respectively are able to deliver justice to them. Now, in that context, one of the most important conversations that has been ongoing and is still ongoing, both at the national judiciaries and also in the regional court, is the whole question of resources for the judiciaries so that they are able to precisely deliver deliver that justice to the people of East Africa. And this is really what this session is about. I think what we have just agreed is that this session will take not more than 1 hour. So here's what I propose to do. I will give the presenter 20 minutes. I will, and unfortunately we have a rather large panel. I will give the panelists 5 minutes each, so that's another 25, plus 20 makes 45. And then the remaining 15 minutes, we will use in an interactive session which includes the responses from the panelists. I intend to be fairly stringent on that, and it may force me to interrupt. So if I do, please don't take it personally. So our presenter, and to save time, I'll be very brief in the introductions also. The presenter is the Honorable Justice John Nudis Keitirima. I hope I got that fine, who is a judge of the High Court in the Family Division in Uganda. I will take it as read as regards his qualifications. We then have the panelists. To my immediate left is the Honorable Mrs. Anne Amadi, who is the Chief Registrar of the Judiciary of Kenya. And finally, the Honorable Justice Dr. I'm not quite sure how to pronounce the first. Didas Nshimiyamana. I got that reasonably correctly? Good, thank you. He's a judge of the High Court of Rwanda, the Chamber of International Crimes. So without too much ado, I will invite Justice Keitirima to make his presentation. My Lord, you have 20 minutes. Thank you very much.
Thank you very much, my Lord. I'll adapt to the protocols that have been adopted before me, and in the interest of time, go straight to my presentation. I think I'll have an abridged version of what I'd prepared in the interest of time. But first to say that when I was asked to speak about this, I said, really, what value am I going to give to this topic? It's something that we have talked about before. It's a perennial topic. And at times you wonder what we should do differently. It also reminds me about the Titanic movie, for those who have watched the Titanic movie. As the ship was sinking, you had these very loyal entertainists that were playing the band. And they would keep on playing the same tune as they saw the ship sink, oblivious of what was happening. Or maybe they knew what was happening, but they were just loyal to their duty until they sank. So at times, I think we need to think differently on how we approach this topic. Because financial autonomy for the judiciaries is a sine qua non to the independence and effectiveness of the judiciaries. There is no limit to that. There is no way around that. And yet, as we have heard in the morning, I think this is the arm of state that is usually told to work within their means, to work within their limitations, or that there is no money. I think that's the language we usually receive. We therefore find, as judiciaries, ourselves at the mercy of the executive and legislature when it comes to the allocation of the budget, which does not augur well for judicial independence. Because the executive and the parliaments may use their power of control over the purse to undermine judicial independence and ultimately their effectiveness. And we have seen these examples in the region. I think I'll be spared just not to mention. It's a fact that if you annoy the politicians, you'll not get the money you want. That's a fact. On the other hand, if you please them, on the inauguration speech, you'll actually get a budget increase. So the budget expenditure, as I've said, is a prerogative of the executive and parliament. Now, what can we do as judiciaries? We have the perennial lamentations that we don't control the sword, nor do we control the purse. I'll give you just a few examples of how unjust the allocation of resources has been in this region. I was looking at the budget of the East African Court of Justice, which I think is at $3.5 million US, if I'm accurate, compared to the entire budget of $91.5 million US, and that is 4.1% of the entire budget. Incidentally, the East African Court of Justice is doing very well in terms of percentages. But compare this with the legislative arm of the same community, which stands at $15 million US, and that's about 16%. The disparity of 4 and 16 cannot be easily explained to me. If you come to Uganda back home, our budget is about 381 against a budget of 48 trillion shillings, and that's about 0.8% of the national budget. I'm told in Tanzania, the judiciary's budget is about 0.39%. And then, of course, the Kenyan budget, even with the increment which was promised, and that will be 22 billion shillings, I think, against a budget of 3.3 trillion, that's about 0.6%. So the judiciaries in the region are actually performing under 1% of the national budgets. And yet they are expected to do their best. They're expected to access justice to the people and to do it in record time. How can we stand to this glaring injustice when you're expected to mete out justice What should we do about it? In a situation where there is no equal bargaining power and resource allocation, there is need, in my view, for affirmative action for the judiciaries. In Uganda, after realizing that a certain gender would lag behind in almost all aspects, in education they introduced what we call 1.5 points. We gave them 1 point. That would be the starting points for one to qualify. In other words, those would be additional points to the women who would qualify to go to university. The notion that there will always be objectivity in budget allocation is an illusion. That will never happen. It's like the biblical writings and the illusion that at one time would have a lion lying beside the lamb and sharing a meal equitably. Unfortunately, I don't think we'll see that situation. So as a result, we have the perennial problems, failing to provide the necessary infrastructure, limited human resource, incapacity of the courts to enforce their decision, low remuneration, lack of public confidence, and lack of investor confidence. And ultimately, we shoulder the blame because of that. So what can we do? What powers are within our means? What governance structures can be in place to ensure equity? My proposal is that budgets of judiciaries should be ring-fenced. With regard to the national judiciaries, I'm proposing at least 3% of the national budget. At least 3% of the national budget. For the East African Court of Justice, I would propose at least 6% because of the wider geographical jurisdiction. My analysis has been that the budget of the ECJ, as compared to the budget of the community, has always oscillated around 2, 3, or 4%. So I'm saying the starting point should be at least 6%. And in my view, this is not too much to ask for. And I would also want to propose that this should be emphasized in every forum that is available to us. The leadership of our judiciaries should champion this cause on every opportunity available to them. Good governance principles should ensure that despite the limited resources, there should be equity in distribution of the resources. The Chief Justices in their forum way back in December 2021 suggested a 2.5% as being ring-fenced from the national budgets. In my view, I think this is the best guarantee we can have as judiciaries. If we are to maintain or to achieve the financial independence we are always seeking for. Of course, the other way is for the Chief Justices and the heads of courts to meet the heads of the executives and the legislature to negotiate their budgets and to make justification for their budgets. But in my view, this is not sustainable. And it tends to hold the judiciaries hostage. That every financial year, you must lay strategy on how to please the boss. Every financial year. It depends on the negotiation skills of the head of the institution. It will depend on the relationship the head of the institution will have with the other arms of the state. So that cannot be sustainable, although it's a strategy. In my view, the judiciary should also be given a self-accounting status, and therefore the ability to control their own funds and apply those funds in accordance with their priorities for the better administration of justice. And therefore, the budgets should be systematically and practically free from inappropriate political interference, so that the courts are financed on the basis of objective criteria and equity. The leadership of the judiciaries should be involved at all stages in the budgetary process. It must be recognized that the administration of justice has its own distinctive and specialized administrative needs and cannot be readily catered for within the framework of the broader public administration. The capacity of the courts to deliver justice and achieve the highest level of operational efficiency can be best secured by placing every aspect of the administration of the courts under the ultimate control of the judiciaries. Leadership of the judiciaries must have an eye on the money. This function, in my view, cannot be delegated. The judiciary should have the inherent and statutory powers to fix even salaries and allowances of the employees, as long as they do not act unreasonably, arbitrarily, and capriciously, and working within the framework of their budget. Priorities within these institutions should be given to the core activities of the institution. First things first. So, even if we are to achieve the financial autonomy we are craving for, there is a governance issue within the institutions themselves. The institutions must ensure that they're in control. Because at times you have a dichotomy. You have a leadership that is composed of judicial officers. Then at times you have an administrative structure really detached, though working within the same institution, and we have to be very careful about that. Where should the finances of the judiciaries come from? I want to borrow a riff from our act, the Administration of Judiciary Act 2020. There are three avenues. Money appropriated by Parliament, and that's where we usually look to. Grants or donations. This is an area that we don't usually look at, but which I think is very helpful because of the perennial problems of the domestic resources we have. It's inevitable that we have to get support from the donors. And I've seen this working, by the way. I have been to Tanzania. I was in Tanzania recently, and I looked at their regional courts. They have very modern regional courts. And when I asked the magic behind this, I was told that they're being assisted by the World Bank. And I think that's the situation also prevailing in Kenya as well. So we must have a robust engagement with the donors where the domestic budgets cannot support. And also, the other avenue the Act has given us in Uganda is from the revenues generated by the judiciaries. Those are the fees and the fines. Now, we may actually achieve this. We may make a case, we may get the money. As institutions then, there is need to be very transparent and accountable to what we have received. There is need to improve our financial efficiencies and accountabilities. We should ensure effective and efficient court administrative systems that increase capacities of the courts and improve access to justice. The judiciaries should ensure that those charged with preparing and proposing the budgets for the judiciaries remain in close and direct communication with the stakeholders, like the judicial officers and supporting staff. In other words, they should adopt what I would call a bottom-up approach. This approach, I think, has been used successfully by a prominent politician within the region in the budget process. Such communication would allow administrators to respond quickly to the actual needs and priorities of the courts. Efficient management and administration is important to the operations of the judiciaries as they are to the operational success of any public enterprise or private organizations. Judiciaries should be able, within the resources given, to project outcomes that are visible and demonstrate true value for money. We should, as much as possible, try to avoid appearing before the accountable institutions like the Public Accounts Committee. We should lead by example. As I promised, I will make an abridged version of my paper and make a conclusion that economic transformation and development cannot thrive if citizens do not have confidence in the rule of law and the justice system. The rule of law regulates economic activity, defines and affirms rights and obligations. And this can only be achieved if judiciaries are guaranteed the adequate resources to do so. And therefore, care and safeguards, as I've suggested, must always be taken into consideration and based on the separation of powers and ensure that neither the executive nor the legislative authorities are able to exert unnecessary pressure on the judiciaries or relegate them to the perennial begging arm of the state. The safest guarantees I've proposed in the allocation of resources should be adopted and pursued vigorously. And in our presentations, I think there is also another factor we need to emphasize. Because at times the judiciaries are seen as consumptive institutions. We do not tailor our budget to demonstrate how our outcomes affect economic growth and development. As you are aware, budgets are prepared by economists. So when we put there a narrative that seems amorphous to them, that we say like, you have the highest case backlog. It sounds amorphous to some people. So what? But how does it affect the transformation of the economy? If a case, say, a land dispute is going to delay in court for the next 5 years, and you are having about 10,000 cases of that nature, and because of the orders being imposed, no production can take place. What is the aggregate of that inefficiency, of that delay? And how does it affect the economy? Maybe that's the language the economists need to hear from us. I thank you for listening to me.
Thank you very much. Thank you, my lord. And in particular, thank you for being time conscious. Honorable, so we now go to the panelists, and like we agreed, 5 minutes each, please. Honorable Sarah Langa Siu, what has been the experience of the judiciary of Uganda, and in particular, whatever the experience has been, how has this affected the delivery of justice to the citizens of Uganda?
Thank you so much, my Lord, and I want to recognize all protocol. Allow me, my Lord, I'll use my 5 minutes. I'll spend half of it just talking about a story that I think is important. I joined the judiciary 17 years ago, and the judiciary I joined back then as a magistrate grade 1 is a different judiciary that is existing today as I serve as a chief registrar. And I want to say that I thank the presenter. He said partly what is pertaining as far as the Ugandan judiciary is concerned. However, he said perhaps this topic has been discussed for way too long, and maybe it's time to change the discussion. And I want to say I think we will not give up on how long we continue to have this discussion until we get to where we exactly want to be. And what is the situation, or what is the experience in Uganda? Again, relating back to my story of 17 years ago, a different judiciary then and now, I will just talk about one component of a budget. When I joined, I was earning 600,000 shillings. That's just about maybe $120 or $30 today. A magistrate grade 1 today earns 5.2 million Uganda shillings. Perhaps that is $1,200 or $300. What is this saying? This is saying we should not give up and we should continue living in hope. I live in hope particularly because along the way, I remember the days when the situation was really bad financially for the judiciary. And back then, the principal judge emeritus, now retired, Yorokamba Mwine, encouraged us in a conference like this that let us live in hope. We lived in hope, and the year came, the year 2020, when finally the judiciary had an act of its own, and that is the Administration of the Judiciary Act. The Administration of the Judiciary Act had been pending for close to 20 years. It was a long journey of waiting. A number of things had happened, including court decisions, and I must thank Justice Cheborion Barishaki. He wrote one of the best decisions that touched the issue of independence and financial autonomy in the judiciary, and that was in the case of the Uganda Law Society versus the Attorney General. And that is Constitutional Petition number 52 of 2017. So, Lord Chair, what came with this act was that a number of gains came, which we are in the process of implementing to show that we are moving. We are not yet there. Perhaps we are not even 30% on where we want the judiciary to be because of the limited finances, but there's been some improvement. Prior to the act, as the presenter said, our budget was about 0.4%. In terms of shillings, you would say Uganda shillings, 199 billion. Upon the enactment of that act, we saw the provisions of Article 155 coming to life, where the Chief Justice was able, for the first time, to present the judiciary's budget to the President. And this is the first time the judiciary had a platform of explaining exactly what do we want to do, where are we, and where do we want to be. So in that budget, we tried to look for 800 billion. We didn't get it. We came out with 376. And that is the first time judiciary had that kind of money in its existence. And that was the last financial year. And because of that, the situation in the judiciary, we now call it the new judiciary. Why? Because things that had never been done, milestones that had never been celebrated for the first time, they were being celebrated. Again, we are not yet there. What are some of those milestones which came with the enhancement of 376, almost doubling what we had? We expanded our structure, and we began to recruit. We had a structure that had been on paper since 2009, and by then was only filled up to 37%, meaning we were greatly under-resourced. We did not have the staff to deal with the cases, and the backlog was huge. Finally, for the first time this financial year, as we speak now, we have 72 judges of the High Court. We've never had them. We have 77 chief magistrates. We have never had them. We have 301 magistrates grade 1. We had never had them. We have operationalized the courts that had never functioned because we lacked judicial officers. Finally, we have them. Again, we are not yet there. We hope again to recruit even more in this financial year. What am I saying? The discussion about money, it is true. The judiciary does not have all that it requires. You look for 800, you get 376. This running financial year, we sought 575. We came out with 381. Again, there were explanations, COVID and the like. But come to judiciary, you will find finally the towers. We call them the twin towers. The appellate courts, the Supreme Court, and the Court of Appeal are finally going to have their own home in the judiciary. This is a project that was developed way back in 1999. It took 20 years of waiting for the judiciary to have money to be able to put it up. I think for those of you who flew over through Kampala, you could have seen that part of the two towers that have changed the skyline in this city are the towers of the judiciary. So our experience is that we are moving, and I want to agree with the presenter that it's time to change strategy. And this was again discussed when we attended the Commonwealth Magistrates and Judges Conference in Accra in September, where in one of the discussions, it was shared that it's time to change strategy. We shouldn't stick too much to being on the issues of independence and abandon the fact that, as the presenter has said, politicians want to hear a certain language. And indeed, in the journeys leading to the enhancement of the budget, it was the first time people were beginning to learn that, oh, we are not just a consumer. Actually, we contribute to socio-economic development. It's the first time people understood what is the value of cases that we have in the courts. In fact, that caused us to now start compiling, and we are not yet done, but so far we have come up with the courts that have so far presented their case values. We have about 12 trillion that is locked up in the case files in the courts. So the Chief Justice now, as strategy, when he is presenting and looking for funds, he knows that when he has more judges to deploy, for example, of the 12 trillion, 11 alone is in the commercial court. If those disputes can be resolved, we'll be plowing that money back into the economy. And so it's important to understand that judiciary is no longer, it's not just a consumer, but it actually contributes to socio-economic development. When the criminals are locked up and people can run their businesses successfully, the judiciary is contributing. So finally, people begin to understand that actually we are relevant. When we collect non-tax revenue and we have it go to the consolidated fund, like in the last financial year alone, it was about 12 billion. That is a contribution. So finally, people are beginning to understand that the judiciary is not a consumer, and therefore, the more resources it gets, it uses it to produce more resources and benefit the economy. As I wind up, thank you. Yes, as I wind up, I just want to say that regarding the bottom-up approach, this is happening. Actually, this week as we speak right now, there are judicial officers, the administrators, the registrars are sitting to discuss and give their input to the next budget. In other words, we have understood that judicial officers who are critical in the administration of justice must participate in the process, and indeed, they do participate in the process. So, Chair, as I wrap up, I want to say that while we have made gains and we have improved our coverage and we are available to administer justice and therefore reduce case backlog, our constraint has also been challenges in sister institutions, which, for example, like now, we have magistrates waiting to work and deal with cases, but they do not have the prosecutors to prosecute before them. 102 courts do not have prosecutors, and therefore, we cannot administer justice in spite of the improvement to the judiciary. In essence, it should be holistic. Thank you.
Thank you. Thank you very much. Honorable Christine Mutimura, you deal with a court that is different, being the regional court. Its nature is different. The process by which it is resourced is different. And of course, as a court, it's been around for a significantly shorter period than the national judiciaries. What is the experience of the East African Court of Justice, and how do these dynamics affect the delivery of justice to the citizens of East Africa?
Thank you very much, Honorable Nyachai. I want to thank the presenter for making a very good presentation and highlighting the fact that there's a close link between the judicial independence and judicial efficiency. The East African Court of Justice's challenges in terms of our financial independence are not very different from what we have in the national judiciaries. In our case, the Secretary General is the accounting officer of the community, and he has the power of general financial management. Our financial rules and regulations allow him to delegate his powers in respect to budgeting, budget execution, and expenditure, and this delegation of powers is extended to the registrar of the court. As the presenter stated, our court receives only 8% of total contributions made by the partner states to the EAC, and the Secretariat is actually charged with the budgeting. So what is the challenge for us here? In the process of budgeting, we are involved as a court in the budgeting process. However, the approval of what we have provided as activities goes through a committee of the Council of Ministers, which is called the F&A Committee. This is a committee that is made up of mainly budget officers from the partner states. And one of the biggest challenges that we have faced when appearing before this committee is getting them to understand the role of the court and why we need activities in place, certain activities in place. You have issues like training that are given a very slim budget. And we all understand the importance of having our judges undergo frequent training, especially at a regional court with the growing jurisprudence and the different kind of matters that we keep receiving as a court. So that is one of the challenges we have, that we are not properly represented in the F&A. And for me, I think it would be much better if we had judicial officers from the partner state sit in this committee and also be able to make a good case. This also explains the point that Honorable Langa stated, that we are mainly viewed as consumers. I think from the discussions we've had since the beginning of this conference, we realize that we still have a long way to go in terms of having, whether it's the partners, especially the partner states, the citizens of East Africa, and I guess the leadership in the partner states, to understand what the role of our court is, its mandate, and its contribution to integration. For us, that is the biggest bottleneck in the achievement of our financial independence. I also want to say that in the same vein of being viewed as a consumer, our court is, the service of our courts is of an ad hoc nature. And this has been since the court was established. We'll be making 21 years. We have since grown. Our caseload has quadrupled. And the fact that we are yet to be granted permanency of the court still draws the point to how we are viewed as a court. And as long as we are viewed in that way, and our leaders think functioning on an ad hoc basis is how we should carry out our business, then we still have a long way in terms of getting financial independence. Because in this very Financial and Administration Committee, a case that is always brought forward is that we are ad hoc. Our judges are not always there, so the budget that we present does not make a good case for why we should have an increase. The challenge of that, of course, is further precipitated by the fact that our heads of state are yet to assent to the administration of the ESCJ bill. This is a bill that was passed in 2016. It is 6 years since, and not a single state has assented to that bill. Someone also raised, I think it's the presenter also raised the issue of how we set priorities when budgeting. The fact that we are not included or we are not given a voice, or even when we do, the kind of people sitting on these panels do not understand the mandate of our court, then we are also not able to set key priorities. And I think in this case, it would be better if, for purposes of managing our own finances, we are given our share of the contribution from the partner states, and then we decide how best to utilize that money. We also have a provision in the treaty that provides that the Secretary General shall be charged with, or the Secretariat shall be charged with resource mobilization. Now, the challenge of that is we have instances where we approach development partners, but because it doesn't come from the Secretariat, they're not ready to give us the necessary support. So that is a challenge for us as well, because why should we go through the Secretariat for purposes of resource mobilization of our courts? Further to that, I think one of the ways we can actually push for the independence, the financial independence of our court is through increased visibility of the court, its mandate, and also the decisions of the court. Because we need the leaders, we need the citizens to understand why we are there. And I think the Attorney General of the Republic of Uganda made a very good case for why we are there as a court. It was also quite unfortunate to have sentiments from the floor on the role of our court vis-a-vis the national courts and the conflict that is there. I think such views do hinder our journey to achievement of financial independence, and we hope that the more we try and publicize the mandate of our court, the role, and also get people to understand the kind of decisions that this court is making, then perhaps our leaders will be generous enough, or not necessarily generous, I think that's not the right word. The leaders will be able to come up with decisions that will enable us get the financial independence that the court deserves. In addition to that, I also think there is need for the amendment of the treaty to allow this financial independence. We have provisions in the treaty that actually hold us back in terms of achieving this. I mentioned the issue of involving judicial officers. I also think that we have the issue of slow disbursement of funds, which is also challenging for us. So in as far as we are pushing for financial independence, as long as we have partner states not adhering to their treaty commitments in terms of making their contributions, then that will still be a challenge that remains with us even if we are granted financial independence. Thank you.
Thank you very much, Honorable Christine. Honorable Anna Madi, this conversation about sourcing of the judiciary in Kenya has been a fairly robust conversation for quite some time. As the presenter made reference, it has been a conversation at the very highest levels. As you share with us your experience, one thing that comes to mind is, do you think that when the people of Kenya promulgated a very radical and transformative constitution in 2010, and when you look at Article 159, where they declare the delegation of judicial power from the people to the judiciary, did the people of Kenya miss an opportunity to constitutionally ring-fence this whole issue of resources for the judiciary? And did the history of the, what do we learn from the history of the Judicial Services Act, which created the Judiciary Fund in 2011? And I think it's only now that the Judiciary Fund is being activated. Sorry, I'm just throwing those. You can ignore them, but I just thought they would be interesting as you respond.
Thank you, Chair. Good afternoon, honorable delegates. I just want to begin first by agreeing with everything that the presenter said, because our experience has been quite similar to the experiences of the other judiciaries in the region, and the numbers that he gave in terms of our underfunding levels are accurate. We truly are at 0.6% of the national budget, and this takes care of the 889 judicial officers that we have, 172 judges, and the rest are cadis and magistrates and cadis. This 0.6% budget covers 133 court stations across the 47 counties. And this compared to the about 350 members of parliament who operate only in Nairobi with double the budget that the judiciary has. So we begin to see the injustice right there, just in terms of numbers. We have been subjected to arbitrary budget cuts in the middle of the financial year based on what's happening on the bench at a given time. We had a situation where a judge declared the Constituency Development Fund unconstitutional. Unfortunately, that was just a day before I was to appear before the Justice and Legal Affairs Committee of Parliament, and I faced the wrath of Parliament on that day. It was terrible. And again, we all remember the infamous revisit of 2012 when the Supreme Court nullified the president, 2017, the presidential election. And that year we got 50 million shillings on our development vote. So that is how gross it can get. As a judiciary, we recognize the need for accountability, and for that reason, we have sought to constantly engage the agencies that hold the purse strings, the different parliamentary committees, mainly the Justice and Legal Affairs Committee, as well as the Budget and Appropriations Committee. And in these meetings, both formal and informal, we have sought to emphasize the correlation between a well-resourced and efficient judiciary vis-a-vis the achievement of the agenda of the national government. We have been able to demonstrate to them constantly
that a well-funded judiciary should be able to contribute towards the ease of doing business. It should be able to contribute towards, investor confidence, which is good for all of us. And I'm happy that as a result of these engagements, we have been able to come up with outcomes that would make a difference if we follow them through. For example, the last engagement we had jointly with the Justice and Legal Affairs Committee, Budget Committee, and the Public Accounts Committee, one of the issues that came up was that since judiciaries hold a lot of deposits from litigants, either as cash bail or as deposits in civil matters, why can't we be allowed to retain the interest on these deposits so that then we can enhance our budget? We have lots and lots of money in deposits, and having engaged with our bankers, we were able to agree that they give us interest on these deposits. Initially, they agreed to a 2%, then they enhanced it to 4%. We are still pushing them to move it a little higher because it's quite a bit of money. And one of the things that the parliamentarians agree on was to support the judiciary come up with a framework within which we can retain these monies, because currently we are getting the interest and remitting all of it to the consolidated fund. So we've seen that there are actually ways in which through these engagements we'll be able to enhance our budgetary situations. We have constantly discussed the danger that we see in the very diminished view of our justice needs. And this has been discussed by the previous speakers. We need to, it's a mindset issue. We are seen as just consumers, which really is not the situation. That diminished view of our justice needs to be changed, because we have had a lot of papers written that have brought out the correlation between poverty and lack of access to justice. So this is something that must be worked on, the mindset of those that determine what goes to our judiciaries. It's interesting that every year we release the State of the Judiciary and Administration of Justice report, which is required to be discussed both by the Parliament, the National Assembly, and Senate. And we've done this dutifully. I think the next report is being launched next week on 4th of November. But interestingly, both houses have never discussed this report. In fact, about 3 years ago, when we did the report and sent it to Parliament, we normally make sure every member has a copy of it. They returned them to the judiciary and said they just needed a few copies for their library. So they don't see the need to discuss the performance of the judiciary, the needs, the gaps. It's that bad. At the public level, in the past we have had the public budget hearings under the Justice, Law and Order Reform sector, and judiciary has suffered because we would go into an auction where you get the ceiling and you mix with police, with the internal security, with the prisons and everybody. So the Ministry of Internal Security under the sector takes 90% of the budget, then 10% is supposed to be shared between the Judiciary, Anti-Corruption Commission, Human Rights Commission, and all that. So in line with what, Chair, you're asking about the Judiciary Fund, which is really a constitutional fund, we decided to remove ourselves from the GJLOS sector. And for the last 3 years, we have been sending our budget, our resource requirement to Parliament directly and not through the GJLOS sector, because we felt we were being oppressed by the Ministry of Interior and Coordination of National Government. So we have been sending our budget requirements to the Justice and Legal Affairs Committee directly. And we've also been having public hearings on the budget for the judiciary on its own. We have seen this to be a very useful approach because members of the public who come for these forums express their support, and we take them as our partners in lobbying their representatives in the National Assembly to help us get more, and we're starting to see this bear results. In terms of just making do with what we have been able to be very innovative in some of our approaches. For example, when COVID came up, we saw that much as we were pushed into trying to fast track our digital strategy, we saw that we had a lot of savings in terms of fuel costs, in terms of maintenance, in terms of even people getting sick. We found that there was a lot of saving just by doing things differently, and that's a way, one of the ways through which we see that our resources can stretch to cover, to give us more in terms of service delivery. As we continue to enhance our digital innovations, we've also seen that then we may not need to continue with the things that we've been applying resources to. For example, we've been criticized for building very big courts in Kenya. That was under the World Bank. We have very large modern courts. And we're seeing that maybe with the innovations that are now there, do we still need to build courts that are that huge? Do we still need to keep recruiting more and more clerks and accountants? Because with the ERP systems that we're putting in place, we may not need to have, all the things that we think we need to be spending money on, just as a way of stretching that shilling to be able to help us deliver more with less. We have seen also that through collaborative approaches, we are able to make savings. For example, we have what we call the Huduma centers, and these are public service centers where you can go and apply for your birth certificate, for your ID and all that. And we're now having registry services being introduced at these Huduma centers, so that instead of building a court in a place where one is needed, we are able to use the resource that is there to share the resource with the national government and still be able to provide services that are needed by the public. It's not all doom and gloom. We have been able to have the Judiciary Fund starting July 1st this year. We are experiencing a few teething problems. We were able to do this through a lot of collaboration with the Central Bank, the National Treasury, and the Controller of Budget. That has given us some level of autonomy in terms of, for example, just reallocating funds. Before, we had to go back to Treasury even if we just needed to reallocate funds from one activity to another. But with the Judiciary Fund, we're now able to do the reallocations at the level of my office, and we're able to then run activities more smoothly. The other good thing that we have we are experiencing with the Judiciary Fund is that at the end of the financial year, any funds that are not utilized do not go back to the Treasury. We're able to retain it so that then our activities run more smoothly, and this is a good thing. We also, it's a good thing that our judges are not paid by the judiciary, they're paid by the consolidated fund, so their remuneration does not eat into our budget. And it's a good thing also that I think our judiciary is one of the best remunerated in the region. We've had a lot of judiciaries coming to benchmark with us. It's not enough, we keep pushing. And from the learning that we receive in this forum, I'm sure that together we'll be able to do more. I think I've exceeded my 5 minutes. Thank you so much, Chair.
Very much. Thank you very much. The Honorable Justice Dr. Nshimiyamana What's the experience of Rwanda on this issue?
Thank you, Moderator. Much has been said on the independence of the judiciary, about the institutional independence and personal independence of judge. On my side, I'm just going to share experience in Rwanda about how court can do, how has been done in Rwanda. Various strategies has been adopted and continuously adjusted through various enactment of new laws, instruction of justice, and so on. And mechanism of monitoring their implementation has been settled. In those strategies, in order to overcome the issue of judicial resource limitation, includes the introduction of single judges in a single bench solely in all courts except in Supreme Court. Secondly, allowing contractual judge and court registrar to adjudicate for a short time. Available judges and court registrar, in the interest of justice with their consent, can be moved to other court in order to help or to assist a heavily burdened court. I talk also about the specialization of court and judges. The specialization of court judges is often advocated as a major performance factor in terms of enhancing justice. In Rwanda, with this strategy, it has been established the commercial court, which deal exclusively with commercial litigations. For specialized chambers has been also created, one relating to family minors and minors, economic crimes and the financial crimes, and the chamber specialized in hearing cases relating to labor and administrative cases, and the chamber specialized in hearing international and transnational crimes. Remember that with this specialization, the specialization in itself can enhance the efficiency of the court, but allowing judge to acquire more detailed knowledge and in more efficient organization of the work. Let me just continue saying that the introduction of ADR mechanism as court annexed mediation. In Rwanda, judges and registrars have been given competence to mediate. When I read the annual report of court of the activities of the court, I'm just found that in year 2020, year 2021, the judicial year, about 1,000 cases has been mediated. I found also, those have been mediated by court registrar in pre-trial phases. Among the cases mediated by judges, I highlight one case involving 112 parties, and a case of 9 is a case of 900 million, has been settled in mediation. Using ICT technology, this has been said by in the panel of Mukibi, but let me say that in Rwanda, the use of this ICT in daily work have been prioritized. The ISMS, Integrated Electronic Case Management System. We have Sobanuzi Nkiko, as in English you can say, ask the court. We have also Judicial Management Performance System, which help to monitor daily activities of judges. Judge can monitor himself what he did, the president of court, even to monitor the daily activities of the whole court in 1 month, and so on. So, if we say judicial resource limitations, we cannot be limited on the budget, allocation of the budget, because what is necessary is to overcome that situation. Just that's why I direct my presentation on what court can do as a national court. Thank you very much.
Finally, on the panelists, the Honorable Dr. Robert Ino, again, your court is probably has a different set of dynamics and challenges, but bottom line, it's a question of what is your experience as a court on the challenges of resourcing for you to be able to deliver on your mandate.
Thank you, Chair, and all protocol observed. Let me start by saying that I endorse what the presenter has said, even though it is leaned towards the practice at the domestic level. But most of what he has said in his paper, I think, can be replicated at the regional level and even at the continental level. The question about sources of resources, the African court, we also get our resources mainly from member states. 90% plus of the funding of the court comes from member states through the member states assessed contributions. And we get about 9 to 10% from partners for our activities. Secondly, on the effects of resource limitation, at the continental level, we still face a similar problem as at the domestic level. Resource limitation, I think Christine has raised that. Resource limitation has the effect of limiting the activities of the court. You cannot do recruitment, you cannot do proper reforms. There are instances we want to engage in establishing form unit within the registry of the court. We cannot do that. The Chair, let me focus on, because at the continental level, approach. And here I have about, some are similar to what has been. The first one is on a judicious, and I hold the position that we will never get the adequate resources we need. Say we are self-sufficient and we have 100%. We must put in place mechanisms to avoid duplication, to avoid waste. The African Court is in Arusha with other AU resources, with other AU organs, interpret in terms of procurement services. We work with personnel to ensure that we provide services to them. Is how do we generate resources? At the African Court, we publish quite a lot of documents. So many documents, and we give to people. People request our documents, DHL, and send to them free of charge, and decide to income internally. I want to raise is the third point is how do we technology? We live in the norm. We should we were forced to use IT. Activities were done electronically. We saved more than on stationery. 68. So it means that if we explore, we can save some resources. Exploring is to relying on the executive. But we are currently exploring the possibility of establishing directly from the trust fund. And lastly, Chair, I know a lot has been talked about cooperation. The independence of the judiciary cannot be exercised in the abstract. The judiciary is part and parcel of a larger group of stakeholders, the executive and the legislature. And we must explore ways of ensuring that we work with these other stakeholders to get the resources that we want. At the African Court, for example, we prepare our activity report, submit it to the member states. It is the member states that may adopt our budget. It is the member states that determine the structure of the registry. But if we do not engage with them and explain to them what the court does, why the court is important for the attainment of the objectives of the African Union, they will continue seeing the court as a threat rather than a partner in the socio-economic and political development on the continent. So we believe that while exercising and promoting the independence of the judiciary, we must also not do this in the abstract. We should work with other stakeholders for them to understand properly the work that we do as a judiciary, to be able to convince them to give sufficient resources for the execution of our mandates. I thank you, Chair.
Thank you very much, Dr. Ino. If there are maybe a couple of questions, comments, as long as they're restricted to 1 minute each, and I'll take a maximum of 4. I start with the principal judge, and then there was the hand behind there. Yeah, the one shaking. The hand, Justice Chiborion, and I can't see who that is. The lady over there to my left. In that order, please.
Thank you, moderator, and I thank the presenter and all the panelists for a very brilliant presentation and interventions on this topic. To say the problem that we have in the ESCJ in terms of budget allocation, and as you can had budget cuts for quite a long time. And I think the budget of the court started at 4-point-something million. It has now gone down to 3.5, despite of the increase of the activities of the court. Now, I think one of the things, and I think when you're talking about resource, we should also talk about human resource within the court. And our secretariat is very lean in terms of, like now we only have a deputy registrar as the head of administration. And we have had only one office at that level for quite a long time, although the structure allows having a registrar, a deputy registrar. But who supports these people? Because when you want to go and argue your case, you need to have people who are well equipped in terms of knowledge in the area of budget. We don't have a planner. We don't have a planning officer. We don't have HR officers. We don't have auditors. So the court is very lean in terms of the registry, to the extent that sometimes the accountant, she's a professional, but at the lowest level of professionals, P1, is the only officer who supports the registrar when they go to present a budget. So I think when you're talking about how to increase our possibilities of getting the 6% proposed by the presenter, we need also to equip our secretariat. Thank you.
Thank you very much. Yes, the gentleman in uniform.
Yeah, thank you very much, moderator. Thank you, the presenter and the panelists. I still remain T.O. Milton. Yeah, I just want to take from where Honorable Chief Registrar left her comments. I just want to say that it's real not a question, just appreciation. And from her remarks, it means that our judiciary has really come from very far. Has come from very far, and that's why I think you are doing what you are doing. On the other part of the remark, you say that, yes, although you are doing very well, but other justice stakeholders, they need to be basically at your level. You mentioned DPP, because you can't perform if DPP are lagging behind. Just like us, for example, now you have 6 high court circuits. You have over, I think, 100 something chief magistrates, meaning that you have opened so many courts all over the country. Also on our side, you find that where you are, where you have open courts, prison's not there. How are you going to operate? Where the high court circuits, our presence is not much. So for us, for you to perform, what am I saying? My recommendation is this. Really, we should have collective voice in presenting really our budgets, such that all the necessary stakeholders, the advisors, all of us, we perform. If police is effective, DPP is not, obviously work cannot be done. If you are very effective, prisons not, work cannot be done. So what am I saying? I'm saying that let's have a collective bargain. Here in my culture, I know I come from northwestern part of this country bordering DRC and Sudan. In our culture, we say that when they're distributing meat, don't look at your neighbor's hand. Because those days, Ogali will be put in the middle and then people sit, they begin to distribute. Without knowing that your elder will be given a big amount than, that kind of thing. So they say, don't look at your neighbor's hand. Otherwise, you will not enjoy the Ogali. So I'm not looking at your hand, but I'm just saying that you also uplift us. Why I'm saying this, there was a time we sent our technical people and in a panel of
Please.
good governance and security.
Please wrap it up.
Just 1 minute, I'm finishing. When they raised this, Honorable Sierra, your people told my people that we are fighting ours. You also fight for yours. So I thought that one was not very good. Thank you very much.
My Lord Justice Cheborio.
I thank all of you for what you have contributed to this very important topic to our work. When I was working with the Aegis Chambers in Uganda, we used to travel to Arusha for various committees. And I would travel with the officers from the Ministry of Finance of Uganda, young officers, finance officers. And their work in Arusha was to sit with the Secretariat to determine how much money would go to each of the institutions in the ESC. We would also travel with ministers, permanent secretaries from the Ministry of Finance and other ministries to go and decide on how much money would go to each of the institutions within the ESC. We would also travel with ministers. They would go to do the same thing. Now, this discussion has gone on. I note that the National Judiciary seemed to be getting out of it. Uganda's, the presentation was that we are improving, things are going on well. Kenya is the same, things are improving, we are going on well. I didn't follow well others, but it would appear that at the national level, there is improvement. My question is, at the ESCJ, have we identified whom to talk to, whom to deal with, so that we can unlock this issue? Because there are two issues. One is equitable distribution of the little resources that are put in by the states. And then the other is the budget being approved specifically for the court. Whom do we need to talk to? Do we know? In Uganda, it had to take the head of state. The Chief Justice went to Entebbe with a properly prepared budget, with the decisions of the court we had made, showed the president, and then the president, yes, I understand your problem. And the money came out. The other day I was following the politics in Kenya, and the president talked, and I think things happened. One president said, now I'm locking, another one said, I've unlocked. Now at the ESCJ, whom are we talking to? Have we approached the heads of state? Have we approached the Council of Ministers? The other day we're here with the Prime Minister, who is our Minister for Regional Affairs. Have we talked to her? Because you may get surprised that we are just being mishandled, squeezed at a very low level. Why haven't we, if we have not gone to the highest level and presented our position? And if so, how do we do it? I think we have to be pragmatic. We have to identify where to go and be able to. There's a lot of goodwill. When the president of Uganda was approached, he said, I didn't know this was happening in the judiciary. Now, imagine we have been suffering for so long, and he didn't know. And the parliament also turned and said, oh, we didn't know. What is the problem? We are willing to come on board. Bring your bill tomorrow. Now, I think we have to find out where to go, and we should do it quickly. That's my contribution.
Thank you, Justice Cheborian. When I grow up, I want to be as optimistic as you are. There was a lady from the back there. There was somebody from the back. Please, the lady there.
Thank you.
I think the president of the African Court, you wanted to say something? Not now. Okay, so we just have that. Yeah, okay. Please go ahead.
Yeah, thank you, Chair. Mine is just a question. The East African Court of Justice sits 4 months in a year. Is this as a result of limited resources, or there's another reason behind it? And I wanted to know what's the court doing to improve that?
Thank you, moderator. Mine is in terms of resources. We have just talked about 3% is what the EACJ has. Now, there is no way, Mr. Moderator, you will treat somebody who is not sick. And it is the sick people who go to the health unit. Like for the case of Uganda, the budget process is on from this month. So, the judiciary should now prepare a budget, a paper, a document, in order to be taken to Ministry of Finance and Planning so that these things will be considered in order to raise up the budget, the funds, as Uganda. And other countries also do the same, because there is no way EACJ will get funds apart from these very countries that form East African community. So for our case, this is the budget process. The budget cycle is on, and we need to move on so that we put some money, some funds into the EACJ court. I thank you.
Okay, moderator, I think I can go first.
You can go first. Sir.
Yeah. My observation is that it is really dependent on the political climate that will determine the resources you will get. That is a fact. Whether that is sustainable, it is something we need to interrogate. The Member of Parliament, my honorable member, said, you go through the process. I can assure you the judiciaries go through all the processes. I don't think there's a process they skip. But the issue is, who is the ultimate determiner of what goes to these institutions?
are we going to rely, and that has been my argument, are we going to rely on the objectivity of our honorable politicians to determine what goes to the judiciaries? Or is it high time, because we must agree that when it comes to the bargaining power, we don't equal the other arms of the state. That's a fact. So if this other arm is to function at equal status, what is it that can be done to guarantee that it functions effectively? That is my argument. That when you are in a discussion and you see that there is a weak link, there must be a deliberate policy to positively and maybe give affirmative action to that weakest link. That has been my argument. The second point is that even when these resources are in the institution, you know, it's like employing, you're having an employee and you say, I want you to dig this garden. I think it would not be good management for the employer to start saying, I think you should start from that corner and meet in the middle, or you should do this or do that. You should say, I want results. So even with the resources that come to the institution, I think it should be left to the leadership of that institution to determine how the resources should be applied. And I'm not saying the judiciary should not be accountable. No. At the end of the day, they must be accountable because we are using public resources. But if you are giving us the mandate to do this job, I think you trust the leadership, as it is done in other institutions like Parliament. Trust the leadership to say, I think we can do this and this and this and this to achieve this outcome. Thank you.
Thank you very much. My Lord Justice Nshimiyana.
Thank you.
I'm sorry.
Is a kind of summary of what have been said before. Just on national level, the judiciary or court has to pursue or conduct studies, initiatives, and review of the court policy in order to overcome the question or the issue of judicial resource limitation and developing, evaluating, publicizing best practices. Thank you very much.
Thank you very much. Honorable Christine.
Thank you, Chair. Moderator, I just want to first respond to the question that was raised as to why we have only 4 sessions of the court. And that is the ad hoc nature of our court dictates that we hold sessions in such a way that we are able to allow our judges also undertake their duties in their partner states. So as long as we are an ad hoc court, then we cannot have a complete year fully engaged. Lastly, I wanted to say, and I want to echo what the Honorable Sarah Langa said, not all hope is lost. I think as the court where we are today, a good example is this function that we've been able to hold, and it's a way of trying to show the relevance of our court. So what we need to drum up, first of all, is that this court is there and it has a very important role to play in the region. In addition to that, I also want to echo what the Honorable Justice Cheborian said. We need to engage, but who are we engaging? One of the, like I did mention earlier, the way the council works is that it has committees that we are somehow twisted to first report to before getting to the council. But I think with increased lobbying from our leaders at the court and also from our respective ministers of EAC affairs, then I think we can get the support that we require. One of the challenges we also have is the decision making at the EAC level. So you'll have a matter, I'll give a good example of our request for judicial independence or judicial and financial and administrative autonomy. This is a matter that was brought before the council over 7 years ago. And believe it or not, at the next council, we are going to present our case as to why we still need financial and administration autonomy. The documentation is there. The council sat, gave their views, but also the fact that we have frequent change of members of the council affects the decision-making of the council. So this year you'll have a certain minister who's definitely positive, but next year a different minister will come and it will all change. But still I said, let's keep engaging and let's keep what we are doing to publicize the work of our court. Thank you.
Thank you very much. Honorable Ahmadi.
Thank you, Chair. I just want to react to what was said by the gentleman from the prisons. And I want to agree with him that even as we raise concerns about underfunding of the judiciary, we must recognize that other agencies that work with the judiciary are equally underfunded. And when they're less funded than we are, then there is that imbalance that is created. In Kenya, we have the National Council on the Administration of Justice, which brings together all the justice sector agencies, judiciary, police, prisons, probation, children's services, Law Society of Kenya, civil society, name it, where we are able to discuss and see which agency is suffering more than the other, where are the concerns for all these agencies, so that we move together. And as the Chief Registrar Uganda had mentioned, the situation where you have more magistrates than prosecutors. A few years ago, Kenya was in the same situation, but right now through that framework, the number of prosecutors is almost double the number of magistrates and judges. So I think that collaborative effort where we work together and identify the gaps together is very useful. Thank you very much, Chair.
Thank you. Honorable Sarah.
Thank you very much. I'll just conclude by saying, as the saying goes, seasons come and seasons go. I think the judiciaries have to arise to the fact that the current seasons require strategy. And even as we talk about our independence, yes, which should never be compromised, we must use strategies that will allow us get the adequate funding. And once we have received that funding, let us show value for it. I think members here will bear witness with me, Honorable Chair, when we had the launch of our annual performance report, a creation of the Administration of the Judiciary Act, one of the ministers who was invited there requested the permission of the Chief Justice to allow him brag about the achievements of the judiciary. Why? Because we are showing that for the leap in the budget that we received, there is value for money. So let us show value for money and let us adopt strategies that work without compromising on our independence. And one of them is to show we are relevant both to the socio-economic development and to the nation overall. Thank you.
Thank you very much. Finally, Honorable Dr. Ino.
Thank you, Chair. Just to respond to the question raised by Honorable Justice Sheborian, and I think Christine has touched on that. I'll respond by sharing the experience of the court. At the African Union, we have structures. Structures looking at budget, structures looking at personnel, structures looking for everything. So we identified each of these structures. Before their meeting, we meet with the relevant, maybe the bureau of the structure of the budgetary committee or the bureau of the personnel committee, engage them. You may call it lobbying, you may call it whatever, but you engage them, explain to them why you need that particular budget for the proper functioning of the court. Explain to them why you need personnel for the proper functioning of the court. So that when they are reporting, before they are reporting to, say, the Executive Council or even to the Assembly, they already know firsthand the problems that the court is facing. If you bring these matters directly to the Executive Council, they will never listen to it because they have a huge amount of work before them, and the issue of the court may not even be relevant. So we do the groundwork well in advance before the matter reaches the decision makers. Thank you.
Thank you very much, Dr. Ino. To wrap up, I believe, my Lord Judge President, oh, I got a wrong message then. Okay. Thank you very much for your indulgence, everybody. Just to finish by asking you to join me in thanking our presenter and the panelists up here, and also thanking yourselves. It's been a long day. I really thank you for your patience. Thank you very much. Asanteni sana.
Thank you very much. Thank you very much, Judge Moderator. Let us give the moderator a very big round of applause. The second one will go to our presenter. The next one is to you, all the panelists. Thank you very much for talking about resources. I will request you to resume your seats. As you resume your seats, I have some announcements to make. One, for those of you who may not have taken a COVID test for the closing ceremony tomorrow, I am informed the medical team is now about to close. So right from here, you can pass by and do that test so that we are ready for the closing ceremony tomorrow. The second one is that during the closing ceremony, which is going to be in a different tent, which will be in the gardens, we shall be required to leave our phones and other gadgets behind. We shall have our phones within the hotel, but to access the venue where we shall be having the closing ceremony, the phones and other gadgets will not be allowed there, so you can see how to keep them safely before you move to the closing ceremony. We shall be starting very early tomorrow, exactly 9, so that we catch up with time to be ready for the closing ceremony, because we have been advised that His Excellency will be here by 11 o'clock, and is supposed to be here up to 1 o'clock. So we shall keep time so that we can exhaust the presentations that have remained. The other announcement is that some delegates have vehicles parked at the hotel on the lower part. We have been advised by the hotel that we can move them to the other parking where the residence is, so that the security takes over this place. So we shall be requested to have them moved. The other one is that for the delegates who come from out and have vehicles, tomorrow we shall be accessing the venue through the first gate. It is called a service gate. So we shall not be coming up to the main entrance. We shall use the service gate, and then we shall be guided on how to park our vehicles. Lastly, I will give the registrar to give a few announcements if you have some. The last one is that we have tea. Our tea is there. We can have it as we leave the venue. I want to thank you very much for your participation and your patience. Yes? The session will start from here. We shall do our presentations, and then we shall relocate for the closing ceremony. Yeah. So we shall start from here in the morning. If we can make it at 8:30, so that we redeem time, the best for us. So I want to wish you a very good evening. Some have dinners in different places. So I wish you a pleasant evening. Thank you very much. See you tomorrow in the morning.